Milord,
Yes, please.
may I have kindly to mention to Lordship, my Lord, inclusion of Order 41 Rule 11.
Yes.
My lord,
I'm grateful, Lordship.
my lord, may I have permitted to mention one matter, my lord. My lord, the matter is, my lord, second appeal, my lord. It was preferred by the appellant, my lord, but it goes out of list due to the non-appearance of the earlier advocate, my lord. I got the face Vakalatnama, my lord.
Appeared for order for 2 on admission hearing.
Admission of the appellant, my lord.
Handle.
Deeply applied, lord.
Subject to
Yes.
Madam, may I have kindly to mention, my lord, FA 147 of 2017, my lord, for hearing matter, my lord, what happened, my lord, it was earlier mentioned, the file is also lying in the court, but it is not getting listed, my lord. My lord, what happened, my lord? The client is, my lord, more than 80 years of age. 1994, my lord, the suit was filed, my lord.
We have a range from 60 to 80 already on our list.
My lord,
Ma'am, wait for some time. No, not right.
hearing, my lord.
Hearing no.
Milord, subject to your lordship, I know Milord, today is not the.
Say no, Ms. Maite, why are you mentioning?
But yesterday your matter, I requested your lordship to take up the matter tomorrow. But today and tomorrow, both days will today some
Which matter?
medical test will. I have yesterday's list 45.
What
Your
is that?
Kindly takes it up today and
What is the item number today?
item number 45 of yesterday. Today this matter is not appearing.
Why? We passed some order.
No, I do not want order. Tomorrow it is fixed. I am praying people to take up on next Monday.
When it appears, ask somebody
As
to
you
mention.
as
Yes,
you
yes,
lordship.
yes.
Today, tomorrow, both days are Milord for medical.
Whenever, yes, Ms. Maite, no difficulty. Whenever the
Fine.
matter is called on, they ask somebody to mention.
Grateful to your lordship. Then
Yes. No, say. We said no. Call Cornelius.
May I, Milord, mention this matter, Milord?
No further mention, please. Yes.
The rest
Yes.
of the application.
Accordingly, FA number 83 of 2016 is dismissed on contest, thereby affirming the judgment and preliminary degree dated March 13, 2015, passed by the Civil Judge Senior Division, Kollani, Nodia, in title suit number such and such, nor less to cause formal degree be drawn up. Yes, Ms. Jose, yes.
30th January, the matter came up before your lordships as Lazima matter. On the basis of office report, your lordships have directed me to correct the to correct the name of the appellant. But there is no mistake in the memo of appeal. The mistake is in the judgment copy. Lordship may kindly see.
All right.
The memo of appeal, it is Shantanu De.
We'll just check up. Shantanu De, yes.
Lordship may kindly see the judgment copy. One A is missing. Shantanu.
That is the defect pointed out by the department.
No, department has said that in the
Memo, it's wrong.
memo is wrong, but not.
We'll say that there is no defect. Learned counsel for the appellant points out that the name of the appellant has been correctly mentioned in the memorandum of appeal, although there is a slight printing error in the judgment of the trial court. Full stop. Next para. We find substance in such contention. Full stop. Accordingly, let it be deemed that there is no defect in filing of the appeal. Full stop. No defect in filing of the appeal.
While the requisite was directed to submit over
Yep.
the fortnight, Lordship may kindly extend the time because for this defect I couldn't.
Very well. The time for filing requisites is extended for a week from date. Thank
Fix it today for filing short notes.
Thank you. Neil. Both the parties file their brief written notes of arguments. Full stop. Hearing is concluded and the matter is reserved for judgment. It a party there. Thank you. Thank you. What is that?
What's the argument for the respondent?
What did you file just now?
The petitioner.
Acha. দুটো ঢুকিয়ে দিন, আমাকে দিতে হবে। দুজনের কপিতে দুটো ঢুকিয়ে দিয়ে একটা আমার পাঠিয়ে দেবেন।
Your Lordship, I am appearing on behalf of the petitioner.
Yes, Mr.
Yes, Lordship, this is an application for an appropriate order. Your Lordship will kindly bear me for a moment, Lordship.
Mr. Have you directed service of copy, or this is appearing for the first time?
No, actually, this matter appeared on 19th of January 2023
Yes.
before their Lordship, the Honorable Mr. Justice Chittaranjan Dash and the Honorable Justice Partho Sarathy Sen.
Right.
Your Lordship will kindly consider that order. We have filed this application. A matrimonial suit was filed by the
No,
wife.
this is Justice Rajshekhar Mantha and Ajay Kumar Gupta's order. We find. This is Sanatan Ganguly versus Pratima Ganguly.
That is item number 5. Item number 4 is
আপনি
Aditi
ভুল
Sarkar.
ফাইল দিয়েছেন, কোডটা দিন। একটা ফাইল 4 নম্বর আইটেমে দিতে পারছেন না?
169. Aditi Sarkar.
অদিতি সরকার।
Yes, ওইটাই যেটা দেখছেন ওইটাই। A matrimonial suit was filed by the wife against the husband. In the matrimonial suit, the husband also filed a counterclaim seeking for divorce. In the matrimonial suit, I filed 2 applications. One is under 25 for custody for alimony and 26 for custody of the child. Suit was degreed.
Your suit. Your suit for divorce was declared.
Yes, because he has also filed a counterclaim.
Both for divorce.
Both for divorce.
Right.
It was allowed. Now
Your suit was allowed or both were allowed?
he filed a counterclaim denying my allegations but asking for divorce.
So divorce was granted on your allegations. Yes.
Now what
25,
has-
26, yes.
Now what has happened? The custody of the child was given to the husband, and a permanent alimony of 10,000 per month was granted. Being aggrieved by that, I have come up before your Lordship by filing 2 appeals. One for the custody, one for the alimony. During the pendency of this appeal, Lordship, the son attained majority. So
So
that
custody-
appeal has become infractious. 168 has become
That
infractuous.
is also appearing before us.
No. 169, Lordship. The alimony was granted 10,000. Thereafter, I filed a 125 and it was enhanced to 12,000 she is getting per month. Now I've filed this application for permanent alimony.
You have filed an appeal against that permanent alimony order.
Yes.
But it should be FMAT then.
If it was
FAT is appearing as FAT.
now it is
It's against
FA number
an appellable
169
order.
of 2005.
That's not a decree. And we will direct that. So what is the appropriate order for?
Now, appropriate order, Lordship. Now I'm claiming 1 lakh rupees for per month for alimony
So virtually enhancement.
enhancement.
What was Justice Das and Justice Sen's order?
Justice Dash and Justice, that is the order. It was referred to mediation.
Failed.
Mediation failed, but in the order they have their lordships are directed to file affidavits. Only the word is that we suggest instead of monthly alimony, the party should reach at a quantum towards permanent alimony to the end matter for all times to come. For such purpose, the party should agree to reach a
You're reading from
Position-
which portion?
order of 19th of January 2020.
Yes, which page? First page.
First page. One
Suggest that instead. Yes, yes. So a lump sum quantum.
Lordship.
That was the suggestion. Yes.
Parties are directed, second last directed to file affidavit before the mediator, and if they want, they may be assisted by their learned counsels. As per the direction, we have filed an affidavit of assent before the learned mediator. Now, Lordship, kindly
Yes.
go through this.
So mediator, it failed before the mediator.
It was failed before the mediator.
Both
They-
parties filed affidavits.
No, kindly go through this. The husband
They-
filed this application that we need time to file the affidavit of assets. But thereafter, they have said that since there is no specific direction of filing affidavit of assets, only affidavit, we are not inclined, and ultimately the mediation failed. Now, if your lordship, this is coming before your lordship, may I be permitted to serve copy upon Mr. Ashit Bhattacharya, who is appearing for the husband, and fix a date for hearing of this application has been served.
We'll direct the department to carry out the necessary rectification, and you will carry out the necessary rectification in your memorandum so that it is reflected as an appeal from an order, from a final order of alimony. So it will be a FMAT, we'll place it under Order 41 Rule 11 and then hear you on that. It has to be admitted first. Nobody pointed out. If it's appearing as FA first appeal, how can it be a regular first appeal? It's not a decree. 25 is not a decree. It's an appealable order.
Lordship.
Appeal lies against that.
Whether it is required to be admitted under Order 41 Rule 11? Because
Definitely, any misappeal is required to be admitted under.
Lordship will kindly direct.
That's a formality, Mr. Right. Questions of where is the memo? We can't find the memo. Let us find out the memo first.
What is missing, I suppose.
No, memo is here.
Memo is here? LCR was called for, Lordship. I have prepared a paper book also to that effect.
Paper books have been
No, it has been found.
no paper books have been prepared.
Sir.
Served. So you have got 2 copies here. You can file it in court.
No.
You have filed it in the department. Very well. Learned counsel appearing for the appellant wife submits that the present appeal has been preferred against an order of grant of permanent alimony. Fullstop, the wife, comma, being dissatisfied with the quantum of the same, comma, has preferred the present appeal. Fullstop, we find that since the impugned order is an appealable order and not a decree, comma, the appeal should have been classified as a first miscellaneous appeal. Fullstop, next para. Accordingly, the department is directed to reclassify the appeal as a first miscellaneous appeal. Fullstop, such necessary reclassification shall be done within a week from date. Fullstop, the file be sent down immediately to the office for such purpose. Fullstop, next para. However, comma, in view of substantive orders having been passed in the matter and paper books having already been
I've been instructed the paper books are ready with me.
paper books having already been prepared by the appellant wife, comma, we deem that the appeal has already been admitted. Fullstop, accordingly, the appellant is directed to file the requisite number of paper books by tomorrow. By tomorrow.
1 week, Lordship.
Within a week from date and serve advance copies thereof on the learned advocate for the respondent. Fullstop, next para. Upon reclassification, comma, reclassification and filing of the paper books, trial court records have arrived. Comma, the office shall furnish a report as to whether the appeal is otherwise ready for hearing. Fullstop. Upon such report being furnished and the appeal being found to be ready for hearing, upon recategorization, comma, liberty is granted to the parties to mention the appeal along with the present application for hearing. File your paper books immediately. এটা ডিপার্টমেন্টে যাবে, বলে দিতে হবে রিক্যাটেগরি এই অর্ডারটা দেখে নেয় যেন রিক্লাসিফাই করতে বলেছি মিস অ্যাপিল হিসেবে।
I'm grateful to you.
Yes.
This is an old appeal, my lord.
What is the app?
The application is for restoration.
Oh.
So dismiss for default. Sir, service.
Can 9?
Can 9, my lord. Well, can 1, 2, and 6 is already pending, as I can find from the orders, my lord.
Those have been
all the orders.
decided. 1, 6, and the other application?
1, 2, and 6 is pending disposal, my lord.
Oh, those are also pending.
Those are, yes. One is along with the, that's for stay, I believe.
This is a second appeal.
The second appeal.
So then we'll have to place it under order 41 after restoration. Have you given a copy to the other side?
Yes, my lord. Service.
Good service.
I believe so.
Check. Substitution has been effected.
Yes, sir. Substitution has been effected.
Has been effected?
Yes,
or application pending?
No, substitution has been effected, my lord. My lord, there were 3 persons, my lord, passed away.
All have received?
All have received. A good service, my lord. 90% of them have
restoration was filed within time, within 30 days.
Restoration part is, I believe, is over.
So what is this?
So this is a restoration. Oh, restoration. I'm very sorry. Substitution part is over. Restoration is on board, my lord.
Restoration has been filed within time.
Within time, my lord, yes.
Affidavit of service filed today be kept on record. Fullstop. The appeal was never admitted under order 41.
No.
Affidavit of service filed today be kept on record. Fullstop. Despite service, none appears for the respondents. Fullstop. Being satisfied with the cause shown for the absence of the appellants on the relevant date, comma, can 9 of 2024 is allowed, comma, thereby recalling the order dated August 5, 2024, whereby the appeal along with the applications had been dismissed for default.
Yeah, just check.
whereby the appeal along with the connected applications were dismissed for default. Full stop, next para. Accordingly, SAT 500 of 2008 along with can 1 of 2008 within bracket old number can 9762 of 2008 bracket closed, comma, can 2 of 2009 bracket old number can 1024 of 2009 bracket closed, and can 6 of 2019 bracket old number can 9202 of 2019 bracket closed are restored to their original file and number. Full stop. The appeal be placed in the list on February 17, 2025 under the heading Order 41, Rule 11.
We put the other side on notice again, maybe?
If there was a caveat, then only.
No, there's one.
No. If you have any connected application, no. If the appeal is admitted, only then. You can give a notice. Somebody appeared for the other side. Did somebody appear? If somebody appeared, give a notice.
I'll put them on notice.
Put
That
them
will
on
be better.
That will be easier.
Grateful. I am
Yes.
for the respondent number 1 in this matter.
Yes, Mr. Dev, what is the matter?
I am for the respondent number 1.
Respondent number.
For restoration, but in the application for restoration, it was said that the petitioner could not reach in time. But at the bar, it was submitted that he missed the list. But considering
your
this
lordship has
your
directed that there was,
direct to file one supplementary affidavit
the lordship kindly see your lordship
Affidavit
last
has come
order.
by saying, explaining the delay of 112 days, though that aspect has completely been avoided.
No, in the application, there is an explanation
But for the delay part,
for the delay.
your lordship was directed to, on last occasion, your lordship was directed to file a supplementary affidavit to explain the reason for the delay that has not been incorporated in the original application for readmission. What are the supplementary affidavits?
What was the reason for the delay? Given a copy to them?
No,
Got
I
a copy.
already saw.
What is the reason?
For paragraph 6, my lord. That is, it was dismissed.
Paragraph 6 is after getting knowledge. So why were you absent in the first place?
My lord, the reason for dismissal for default was given in the original application or readmission. Only the delay part reason was not given.
Paragraph 8 of the application, he says that he was engaged in another
Another
court,
court,
so
my
he
lord,
could
like-
not come. But at the bar,
Well,
when
your
the
lord-
matter was
The
moved,
list
it was
got collapsed
submitted
that day.
that he did not, he missed the list.
The list got collapsed that day, my lord, we
Considering
got
this
knowledge.
alimony, your lordship was pleased to direct. the
Let us
subject.
just see. Yes. What was the great difficulty in contacting him?
But he is of 85 years of age.
85.
He was,
It's equally difficult to contact a
Before
12-year-old
that,
child and an 85-year-old
my lord,
person. It's a phone
his
call
son-
away.
His son usually stay outside. My lord. He was admitted in the hospital before that.
Where have you stated
My
that?
lord, I have also annexed the discharge.
Where have you stated that in your supplementary
My
affidavit?
lord, sir.
You cannot take these things lightly.
No, my lord, I have stated.
Hey, Mr. Dev will come.
As you-
Upon hearing learned counsel for the parties
Yes,
And-
I am suffering, my lord.
perusing the application as well as the supplementary affidavit filed today, comma, we are convinced that there was sufficient reason for the delay in filing the application for restoration of the appeal, push up, application for restoration of the appeal as well as the absence of the appellant on the relevant date when the appeal was dismissed for default. Push up, next para. Accordingly, can 4 of 2024 is allowed, comma, thereby recalling the order dated October 11, 2023, passed in FA number 123 of 2012 and
My lord.
you have not annexed the order.
My lord, next slide. The application, my lord. Page 9. Page 9 of the application.
Thereby restoring FA 123 of 2012 along with the connected applications to their original file and number.
Lord, all applications are disposed of, my lord. There is an interim order since 2012, my
That
lord.
minute I am objecting any day after
Well,
one.
I
week,
prefer
this is of
reimposition
the
of
matter.
that.
This is a this is a case, my lord, where the plaintiff could not.
No,
prove
no,
his
no,
own-
no, 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 Mr. De. Restoration automatically means that the orders are restored because it was not says that the interim order was vacated.
Lordship.
If it is not said, that's a law. For the next para, since there was no observation in the order dated October 11, 2023 regarding the interim orders which were subsisting at that point of time being vacated, comma, it is deemed that the said orders which were subsisting at the relevant juncture automatically stand revives as on this date.
Yes.
What about paper books?
Already, my matter is ready for hearing, my lord.
Forget it.
Lord,
No hearing right
pick
now.
up anytime
No,
after 2 weeks or so.
not right. Later. What are can 2 and can 3, Mr. Bhattacharya?
Application for substitution after setting a settlement.
3.
Yes, my lord.
That is 3.
3.
What is 2?
2 is the application for appropriate order and or direction which was filed by my learned friend.
Appropriate
Only
order means?
For preparation of paper book, I have prepared the.
Acha, let us see.
Stay application has already been disposed of.
It's a
On
substitution after setting a said abatement. What is the delay?
Delay, my lord, there is a because
They have explained in paragraph 6 and 7.
What is the delay?
My lord, appeal number 1,
What is the number of days of delay?
152.
Is explanation?
Explanation, my lord, I have said that the 1 is actually the appellant is the Sotbirkar as well as the appellant, and he has actually contact with the learned advocate. And 2 was
Yes, what do you say?
And I am appearing on behalf of some of the respondents.
You have served on all.
my lord, appearing on plaintiff
Plaintiff respondents, some of the respondents. 1A to F, 1A to G, 2 to 12.
What about the others? You have to serve the
Plaintiff
substitution
response.
application on all.
Plaintiff respondents.
Have you served? Was there any direction?
plaintiffs.
All the plaintiff respondents. You are appearing for all the plaintiff respondents. What is the decree for?
Except 13.
13. Why not 13?
13.
Why not 13? All the others you are appearing. Take instruction, appear for 13 also. What was this decree for? Against which you have challenged?
My lord, partition should just degree.
Preliminary degree or final degree? No, then you have to serve all. All will be affected. The petitioner shall serve the petitioners shall serve copies of the
Respondent number 13 died.
Oh.
They have to make an application. Because I have not the
you are this is this can this be an afterthought? You should point out at the outset that he has died.
In the partition should number 24 of 2005. That time respondent number 13.
When did 13 die? Before the decree? Was his heir substituted?
Later down it, no?
না আমি তো জানতে পেরেছি যখন
Actually, it is beyond the knowledge because plaintiff died.
You are saying, so you should know.
No.
His name is not there in the decree.
Degree দেখো degree
But minimum preparation.
কি নাম বল?
We have to ascertain that also, Mr. Bhattacharya. Please check up.
Well, actually, my lord,
What actually check up the degree? Actually, figuratively, virtually.
No.
Just check up the decree whether his name is there. 13 is Jumatan. Whether her name is there.
Jumatan, my lord, substituted. My lord, degree copy, my lord.
13 in the decree is Zohra, not Jumatan.
Jumatan.
What
13.
Jumatan?
13.
In the decree, 13 is Zohra.
No, Jumatan. Page 2.
We have the decree before us.
Two degree in the flute.
Have you got a copy of the decree?
Yes, ma'am.
Show us your copy. Zohra রয়েছে যে Oh, her heirs were substituted.
Yes, already transferred.
Why didn't you implement them? You prepare an appeal and file it like this, and the client entrusts you with the matter. Mr. Bhattacharya. And the appeal is of which year?
But the appeals are
2010.
Yes.
For 14 years, they are languishing. And you have not even implicated the proper parties in your memorandum. দেখি মেমোটা দেখি। We find at the outset, as rightly pointed out by learned counsel for some of the respondents who are appearing today before us, comma, that although respondent number 13, Jumatan, had died during pendency of the suit in the court below, and her heirs had been substituted, comma, which is reflected from the impugned decree, comma, the said heirs have not been imputed as parties to the present appeal. Push up next para. The learned advocate on record for the appellant is directed to carry out the necessary amendment to the memorandum of appeal during the course of the day, impleading all the heirs of late Jumatan as parties to the present appeal. Full stop, next para. Because they are not with you, they must have not given Vakalatnama to you. So they will be performer respondents. Do you understand what we are saying, Mr. Bhattacharya? What have you said?
13 plaintiff died.
Plaintiff died. That you have understood.
No. Plaintiff have died, my lord. Unless I'm taking decision instruction, man.
What instruction shall you take? Have you got Vakalatnama for her heirs?
No.
Then you have to implement them as what? As what? Very tough question.
Well, no tough question, my lord. It is, my lord.
You have to implement them as?
Pro forma.
Pro forma. All very pro forma. Then do that, please.
Okay,
During the course of the day, full stop. The cause title of the present application shall also be corrected accordingly during the course of the day by the learned advocate for the appellant. Full stop. Copies of the application shall be served by the appellants on all the non-appearing respondents, comma, including the newly added respondents, and an affidavit of service to that effect shall be filed on the next returnable date. Full stop. The applications shall be listed in the monthly list of April 2025. Because there are so many parties, Mr. Bhattacharya, it will take some time to serve.
আমাকে এটা ফেরত দিন না আমাকে
14 বছর বনবাস হয়ে গেছে Mr. Bhattacharya, we'd better advise you to check up whether others are still alive during these 14 years. Partition suit.
51%.
51 persons. কল করুন পরটা বাবু কল করুন পরটা দেখেছেন ইয়েস মিস্টার চ্যাটার্জি
Lord, on side.
Mr. Karmakar is not supposed to know. You are supposed to instruct him.
My fault.
So there is no caveat.
No, Milord, these are very old appeal. Milord, they have
Directions have been given and all.
Yeah, ঠিক আছে. Now, the problem here, Milord, is this is a shop inside, Milord, the Grand Hotel. Milord, my suit for declaration of my tenancy rights was dismissed. I preferred this appeal. Injunction was granted. Now, Milord, your Lordship knows Grand Hotel is going through, Milord, a complete overhaul. Now, by that, what they're doing is, Milord, they've disconnected my electricity, my ingress and egress, everything. My business has stopped, but they've also stopped this. Now, this fact, Milord, we've got it on record in the sense that we've got it on record before them, not before the court. So now I will have to file a, Milord, either a supplementary affidavit or a fresh injunction, Milord, to get that, Milord, injunction before your Lordship. There is an injunction. Kindly have a look at the order of 25th of October 2017. That should be the only order, Milord, which would be on record.
Yes. Disturbing position. Yes.
Milord. Last paragraph. Milord, there is it's debatable whether this comes within that injunction, whether contempt will lie. Yes, Milord. That's one aspect.
Disturbing position and ingress.
This can be taken to be a part of that. Whatever they are doing, Milord, is a part of.
Absolutely.
My Lord. So,
but then there's a violation of the injunction.
If there is a violation, I'll have to, Milord, come up with an application to that effect as well.
So, Mr. Chatterjee, what do you propose? Because this
Sir-
application is still pending.
Yes, brother, this is still pending.
Just give a notice to the other side.
Yes.
Whoever is appearing will dispose of the application, direct paper books and all these directions. And whatever contempt or whatever you have to file, you
We
file
file a
independent.
separate application.
Since none is appearing for the respondent and the appeal is quite old, comma, the learned advocate appearing for the appellant is requested to serve a notice on the learned advocate on record for the respondent indicating when should you keep it?
A week.
Monday.
A week.
Indicating that the matter shall next be listed on February 17, 2025. When a receipt in that regard shall be filed by the appellant.
I'm great. My application.
Yes.
I am for the respondent. First placing the can 2, my lord. This is my alimony application.
Let us just sort out first the condonation and everything has been allowed. There's a condonation
Condonations in respect of a recalling application. There was a condonation application.
No,
my lord.
that has been allowed.
No, my lord. That is
Recalling of
pending.
what?
Recalling of the injunction order not to contact the second marriage. They have short for.
That's their your application,
Yes,
right?
right.
So you have filed opposition to that.
Yes. Opposition reply was
So now first you'll be moving your what alimony application.
can 2.
Let us find out the affidavit of assets also. Affidavits of assets were filed separately, Mr. Meena.
Yes, we have filed
Separate.
our affidavit.
No, separately from the application. That is what you are saying.
Yes.
So recalling and all this, we are just keeping aside for the time being. Let us first deal with the stay also later on. Your affidavit in opposition. এটা কাঁচি ফাঁচি দিন তো এটা কেটে দিতে হবে এটা একটুখানি কেটে দিন এটা জাস্ট কেটে দিন এই শুধু সাদা শুধুটা কেটে ব্যাস affidavit of asset on behalf of the appellant. Very well. You have not. You have also filed your opposition and affidavit of asset.
Yes.
Right.
The reply is also there, my lord, in connection with that.
Pardon, Mr. Meena. Yes.
There was a reply against that opposition, my lord. Yes.
Reply.
Reply to can 2. Can 2.
Let's just find out that reply. Reply erroneously this is can 3 we have a reply in the back sheet it's corrected as reply but in the front it's opposition but can 3 is the caption can 2 এর আছে reply দুটো আছে কপি আছে কিনা দেখুন তো নাকি একটাই কপি ওখানে কাগজ তো আমাদের এখানে কেউ সাজায় না আমাদের সাজিয়ে নিতে part of the job কাগজ সাজাবেন লয়ারদের শুনবেন জাজমেন্ট দেবেন তারপর ওটা got it move your application Mr. Miller any alimony was what is the appeal is against what
Against
you take your seat we'll hear it yes no seat
that suit for divorce, my lord. Divorce degree was granted against that. I
use the microphone
suit for divorce.
husband got a divorce degree against you you have preferred a challenge against that
Yes.
were
my
you
lord.
enjoying alimony in the court below
Yes, my lord.
is there any issue of the marriage Minor
Yes,
issue?
one child,
Still minor?
not minor, 22 years old. He is pursuing.
He,
He's
then not entitled to alimony on
but
that.
there are judgments, my lord, that up to completion his, my lord, educational career, my lord.
That will be your alimony for him because it will be your expenses. He is not a dependent of yours, nor his. 22-year-old male is not a dependent of the father or the mother.
22 years old. There is
Definitely
no
not
doubt
a
of it.
dependent.
That I
But
have
if he has
disclosed.
education expenses which you are bearing, that can come within your expenses. Anyway, let us hear you on this. You enjoyed some alimony in the court below.
Yes, ma'am.
How much?
Total 7,500.
Throughout the suit.
Throughout the suit, my lord. That is, my lord, I have annexed that order, annexure E, page 35, ordering portion at page 36 of the alimony application.
Only 2,000 to you and 3,000 to him. 5,000.
No, my lord. Prior to that, but I am reading prior to that.
Oh, you are getting 2,500 from judicial magistrate.
Yes, my lord.
You are still getting that.
No, my lord. Even during the pendency of the suit, my lord, they have stopped that alimony also.
Did not file any execution case with the magistrate.
Magistrate, that is also pending, my lord. And in the affidavit of assets, my lord, there is a column. How much
But
alimony?
Mr. Meena,
My lord.
it has been stated here in the order.
lord.
Admittedly, you are getting 2,500 per month for you and the minor son. But
Yes,
it
my
has not been adjusted. Considering the facts and circumstances, I am of the opinion that the petitioner being able-bodied is duty bound to maintain his wife. I am of considered view that 2,000 to you and 3,000 for the son will meet the end of justice towards the alimony. Oh, in addition, right?
In addition, my lord.
Very good. Right. 7,500.
Yes,
So
my
now what is your claim?
my lord, I have claimed, my lord, 40,000.
40,000.
My lord.
His income?
My lord, they have, I have said, my lord.
What
they
are your assets? You don't have any job.
My lord, I used to work as a Dengue Potirod Bahini, getting 1,600 rupees. That work is done.
Per? 1,600 per?
There are 3 to 4 sittings, my lord, in a year, 20 year. This is not a, my lord,
Per
permanent
sitting
job.
you get 1,600.
No, for 7 days.
7 days, 1,600. That's not a job.
That
You are no longer there.
No, my lord.
So
When they called us, called my client for
So
that
that's
job,
not a regular income. You don't have a regular income and assets.
assets, nothing, my lord.
So what have they disclosed regarding their assets?
Lord, what I'm showing, my lord.
What is non-agrarian deponents?
Non?
Agrarian, your affidavit of assets.
My lord, that is what the language is stated in the Rajneesh versus.
Their agriculture was an issue. You need not say that you are non-agrarian. Rajneesh, their agriculture probably was an issue. Anyway, so as per their opposition and their assets, what is their asset or income?
But they have disclosed
Yes.
in the affidavit that their income is 77,856. That is page 7, my lord, of the opposition, my lord.
No, their affidavit of assets is also there.
Affidavit of assets.
Monthly income from page 6 of that. Monthly income is net 62,616. That is the net income. They haven't given the gross.
Salary slip I have annexed.
Where is your gross? Gross income? We'll consider the deductions whether they're good or not. You have to give the gross income. What is your actual income?
Salary slip, my lord.
You have to mention that in your affidavit also. Annexing something without any supporting pleading won't do. You have given your expenses. What is your actual income? They have not disclosed that. Your net income, you are nobody to decide what is your net income. We'll decide that. What expenses, what deductions are valid, legal, mandatory.
In opposition, they have annexed the salary slip.
Where is that? Which page?
Page 7, annexure. Affidavit in opposition.
Assets page?
Page 7.
Mr. Meena, take your seat. I'll just.
74.
Because let us hear them first, Mr. Meena. I think that will be easier.
Man.
because they let them argue first because we have to direct them to pay.
Man.
So let us see their defense. Your claim is you don't have any income, no asset. You have claimed for your son as well as yourself.
Man.
Son's education expenses, you have annexed something.
Yes, my lord. Annexed. Annexed.
Let us hear them, then we'll come back to you. Yes.
But 74 page 74, I have annexed the salary slip, my lord. But my gross income is, my lord, rupees 77,856. And deduction is rupees 15,240. So net income.
No, what is this cumulative?
Lord, quarterly, I said.
Ach.
Currently.
This is of June 2024. When did you file the affidavit of asset? July. What is your current income?
Salary cost.
You have to disclose your current income also.
I shall, my lord.
We'll give you a week. You bring your current income.
But one more thing, is two more thing, my lord.
Yes.
Thing is, my lord, the order of decree of divorce was passed in the 31st of July 2018. The appeal was filed in the month of October 2018. I have remarried, my lord, in my lord May 2019.
So it was filed within limitation period, appeal.
It was filed within limitation period. My plea was, my lord, that I do not know.
When did you marry?
My lord, in May 2019.
So after the appeal period.
Appeal period.
So you say did not know of the appeal.
Yes, my lord.
And what is how do they deny it?
They are denying, my lord, that they are saying that in the month of December, one learned advocate of this honorable court has filed a Vakalatnama in the department.
But that we consider later. Let us first decide the alimony first.
Yes, my lord.
There's some
And
alimony.
one more thing, my lord. I am presently a cancer patient.
You have your expenses, medical expenses.
I have my medical.
Must have disclosed that here also.
Yeah, I have disclosed it here as well.
What are you doing? What is your job?
I am an SI under West Bengal Police.
Police.
ASI.
ASI. So your current income has to be disclosed. Just file a one-page affidavit, give a copy, come back next week. Mr. Meena will just take the current
My
affidavit.
lord, also the gross salary I will disclose.
Please disclose. We find from the records that the affidavit of asset of the husband was filed at in the month of July 2024, pushed up in order to ascertain the current alimony of the husband, comma, the current salary of the husband, comma. The husband is directed to file a short supplementary affidavit disclosing his current salary slip, comma, including the gross and the net salary. Full of such affidavit shall be filed within a week from date with an advance copy to the learned advocate for the appellant wife. Full of the matter shall next be listed on February 19, 2025 under the same heading. Come back.
One
Yes.
thing I'm just
Yes, Mr. Meena, what?
affidavit of assets, they have not disclosed what arrear amount they have paid in connection with the earlier suit. And that is the part of the annexures, my lord. I have instructions that they have paid only 13,000 and odd.
You have disclosed in your application.
Yes.
The current, that is not a part of their asset.
My lord, as per the
Liability, if you say yes, maybe, but it comes
as
in business,
that
it
have
comes
to
in
be-
the profit
that
and loss.
annexure says that has to be disclosed, my lord.
Oh, Rajnesh says that.
Yes, my lord, that I have.
The arrears of alimony.
Yes, my lord.
আরেকটা line add করে দাও, the husband, the respondent husband shall also disclose the arrears of unpaid alimony till date. Do that also. Put it in that affidavit, give a copy to them and come back on 19th. এইগুলো না যেভাবে সাজিয়ে রাখছি এভাবেই থাকবে। হ্যাঁ। এখন করে দিয়েছি, এখন যেরকম করে দিয়েছি এরকম থাকবে, ঠিক আছে? Thanks. Yes, Mr. Shen, what is that?
In Malad, I appear for the appellant Malad.
Right.
Beneficiaries under the will is are the appellants, my lord. But initially a probate application was filed by the executor, my lord. The executor was an advocate, my lord. The advocate died, my lord, and the probate application was dismissed for default. Thereafter, my lord, search operations were made, and subsequently, my lord, and letters of administration was filed by the beneficiaries, my lord. That application has.
They were the beneficiaries or you?
We are the beneficiaries.
Oh, so you filed that, yes.
But that application has been dismissed by the trial judge, my lord, holding that it was not filed within 3 years. So,
No, when did the executor die?
executor died long back, my lord. It was
Before 3 years.
no, 2006.
And when you filed this,
2015, after I came to know that he has died, he has not taken steps, my lord. I was residing outside Bengal in connection with my service, my lord. Subsequently, thereafter, my lord, what happened, my lord? The heirs died, my lord. Now, my lord, the substituted heirs are the niece and the nephews of the original testator. During the probate proceeding, my lord, the wife of the testator endorsed a no objection to the will, my lord, but ultimately no objection to the probate proceedings, my lord, but it ended in a default, my lord. My lord, now it was hard, my lord, by the other bench, my lord.
so no restoration, there was no scope of filing any restoration. So you filed an independent letters of administration after 9 years.
After almost 9 years.
So you have to satisfy the court only on limitation.
But so far as the application is concerned, my lord, the application was
Directions.
filed long time back, my lord. The application was for the hearing of the appeal, my lord. My lord, there were certain orders during the hearing took place in the other benches, my lord. During the course of the hearing, they said that they will give no objection.
You still stand by that?
Subsequently, my lord, on the next day, they come back and they file, they want to file affidavit in opposition. But so far as the affidavit in opposition in the appeal, my lord, it's of no
question of affidavit.
But our only point, another point, my lord, I will be urging, my lord, whether they have stepped into the shoes of the
Records are before this court.
my lord. Paper books are ready, my lord. Entire matter is before this court.
We'll direct the appeal to be listed in the monthly list of March. Nothing else remains. We'll dispose of Can 5 of 2024 by saying that already the paper books have been filed, records are here.
Fine.
So we'll direct the appeal to be listed in. Not before that. Forget that.
Lordship, my prayer is that client,
Yes.
my client is filing, willing to file his objection and
Objection to what?
objection for not to
Against what?
against this probate application.
There cannot be any objection. There is no scope of filing any opposition or objection to any memorandum of it. Memorandum contains the grounds of appeal. Only whatever are the documents in the trial court will consider that those are part of the paper book. There is no scope of filing any objection or opposition to any memorandum because it's not a pleading of the parties, right?
Furthermore, I want to ask, my lord, whether they can at all
Step into the
object to
shoes.
the will of-
Substitution has been allowed.
Substitution has been allowed.
That is subject to because there was no adjudication under Order 22 Rule 5.
They, my lord, they have stepped into the shoes, my lord. Whether my original objector person who could have object, my lord, he has given endorsed no objection. So at this stage, as this
No objection was an exhibit.
my lord,
I'm prepared on that.
and he's
Stepping into shoes.
he stepped into the shoes. Now, my lord, his objection should be limited, my lord. He cannot go behind that, my lord.
We'll direct it to appear next week. Come prepared next week as an exception. Can 5 of 2024 is an application for expeditious hearing of the appeal. Footstep. Learned counsel submit that the appeal is otherwise ready for hearing, comma, the records are before this court and the paper books have already been filed. Footstep. Accordingly, let the appeal be listed for hearing on February 17, 2025. Come back. 5-minute appeal, please come prepared on the no objection, whether you can re-agitate that issue and also on the merits. Limitation. Come prepared with all your judgments. Mr. Shen, please, whatever judgments you cite in advance, please make this a practice in our court. We are telling to all of you. Whatever judgments you want to cite, give a notice to the other side, give the citations to the other side, and vice versa. So that on the date of hearing, no time is short. I want to give a reply to this judgment. This was not within my knowledge. That is happening, Mr. Shen. That is not supposed to happen, but that's happening. It's nobody's fault. But just give notice to, like other high courts also, they do it. just give information to each other, what judgments will be citing, come prepared. If you can, file short written notes also, and we'll dispose of the appeals one by one, so that we can include other appeals. Next. 11, yes. About a perimeter asset for alimony. Yes, Mr. Bhattacharya, you are the on the right side or the wrong side of the law?
I'm the respondent, but this wife and this application has been filed for alimony pendently.
Husband has asked for alimony.
No, wife,
Yeah.
my application, Milord, time and again, Milord, like today, Milord, they are evading the process of the court, Milord, they are not appearing.
Who is appearing for them?
Milord, Shaurjo Rai, Milord, on the last occasion, your lordship directed me to serve my affidavit of assets. I have served upon him. Now, Milord, he says the client is not in touch with him.
Have they filed their opposition? Was there a direction?
Definitely. Kindly see the order dated 22nd April 2024 and the order previous to that. Even time was also extended.
Non-traverse করে allow করে দিই, তাহলেই চলে আসবে। 22nd April.
April 2024.
Wait.
And there was also another
22nd April, yes. Before different bench also similar thing.
yes, yes.
No, then you had not filed affidavit of assets.
Yes, definitely. Thereafter, Milord, and Milord, there was Milord also another direction on 20.
None appears for the appellant on 2nd of July, 16th of July, again same. But matter was that, oh, you also did not appear. Very well.
There was 21st March.
So equally responsible. You are not serious with your alimony.
There was a direction, Milord, passed by the
When was the direction for affidavits filed?
22nd April was extension, Milord, the
22nd April, it was, yes.
kindly also see 21st March.
No, extension given to you.
Yes.
Both sides may file their affidavits in the meantime. That was the first direction.
And Milord, kindly see the order dated 21st March. There was a direction to pay ad hoc 50,000 that was complied with. Now, Milord, after that, Milord, what happened, Milord? The husband is sometimes intermittently, Milord, transferring 8,000 to 10,000 every month, according to his own wishes, and in some months it's only 2,500, 300. Milord, my son reads in a Milord English medium school, BD Memorial in class 6. Milord,
What have you asked for? What alimony have you asked for?
yes, Milord, kindly comes to Milord. My prayer, Milord, is page 9 of the application, 35,000 alimony the pendentility, and Milord, 25,000 for minor son and 1 lakh as litigation expenses.
Have you disclosed what does he do?
Milord, last
You don't do anything. What is your qualification?
graduate. Milord, from
And
the
what does the
very
husband do?
husband, kindly see page 8, para 18. This is my last known, Milord, what he used to do, Milord, at that point of when we were living together. Now, Milord, we are not aware what he does.
What is he? I mean, what's his qualification? Project manager?
In a company called SCM Building Intelligence Private Limited at Mumbai, and used to earn rupees 2 lakh per month. Milord, this is a position, Milord, which I am saying, Milord, when we used to live together. Now, Milord, we are not aware, Milord, what he does.
So direct him to pay another ad hoc amount of 50,000. When was that direction given?
21st March 2024. Now, Milord, for one thing, Milord, if your lordship would kind enough to see, Milord, I have annexed, Milord, the page 15. This is the fee chart of the school. Kindly see the total, Milord, right hand side bottom, 66,500. Right hand side total at the bottom, 66,500.
This is per year.
Yes, this was in class 6. Now, Milord, the year ending will be in March.
He's in class, which class now?
6. Now, in year ending will be March. Milord, next session will
PDM International is ICSC or what? International still a
ICS. No, it's Milord CBSE school. CBSE school.
some central board.
Central board. Now, Milord, he will be in class 7 again in March. I do not know this. Now, school has not sent, Milord, this year's expenses as of today. They uploads in their website. I do not know what will be the expense. And Milord,
We find from the records that the husband stroke appellant has been consistently avoiding
and Milord, para 13 also, Milord, page 8, para page
appearance in the matter, push up till date, comma, no affidavit in opposition, and stroke or affidavit of asset of the husband has also been filed despite several directions having been given in that regard. Push up next para. As a last chance to the appellant husband to file affidavits, we are extending the time for affidavit in opposition to the alimony application and affidavit of asset of the husband for a fortnight from date, that is till February 25, 2025. Pushed up. Reply, if any, shall be filed by March 7, 2025. Pushed up. The application shall next be listed for hearing on March 10, 2025. Pushed up. We are satisfied from the averments made in the alimony application, which have still not been controverted by way of an affidavit in opposition by the husband, that the appellant wife is in dire need of income, dire need of money in view not only of her own needs, but also the educational expenses and other needs of the minor child of the parties. Full stop. Accordingly, accordingly. Learned counsel for the wife also points out that by a previous direction passed in March 2024, an ad hoc amount of 50,000 was paid by the husband to the wife. Push up next para. We are of the opinion, in view of the above discussions, that a further ad hoc amount of rupees 1 lakh should immediately be paid by the appellant husband to the wife, which will be adjusted with the final order of alimony passed in connection with the present application. Full stop. Accordingly, the appellant husband is directed to pay an ad hoc amount of rupees 1 lakh within February 20, 2025 to the respondent wife to meet the present needs of the wife and the minor son of the parties. Full stop. Next para. Such payment shall be without prejudice to the rights of the parties in the alimony application and in the appeal. Full stop. The appellant husband shall, for the purpose of compliance, act on the written communication of the learned advocate appearing for the wife directly and or through the learned advocate for the appellant, coupled with a server copy of this order. Serve on his advocate as well as directly. And the application will come up on 10th March. English medium. Yes. Here for the
respondent lordship led by Mr. Owen Banerjee.
By Mr.
Owen Banerjee.
Owen Banerjee. Yes. Yes. What is your case? Section 5.
Section 5, my lord, can 1 is section 5, can 2 stay, and can 3 is a application for permission upon the son of the deceased person to proceed with this appeal for appropriate order. Actually,
why permission? I mean,
my lord, actually this
he
is
died.
appeal.
Died after passing of the decree and
My lord, after passing of the order, she died.
But before preferring the appeal.
Before preferring the appeal.
In the interregnum.
Interim.
That's right. All right. What do you say about the leave? You are the only heir.
I'm the only heir.
Lordship, he is the
Onathnath Das was the original appellant.
No,
original
father.
What is the challenge against? What is the decree?
My lord, actually, decree against. My lord, the second husband of my mother executed a will in my mother's favor. That was probated accordingly. This probate was challenged before the learned. I got the probate from the district delegate Barakpur. This probate was challenged before the learned district judge at Barashat. Learned 4th ADJ Barashat has been pleased to revoke this appeal probate and have challenged this revocation before this honorable court. Now, my lord.
What is the delay in preferring this appeal?
My lord, delay
189 days.
What is your explanation? 149. What is the explanation?
Explanation, actually.
189. You have explained only 149, whereas the report says 149.
There is a mistake in calculation.
What is the explanation?
Explanation, my lord, my mother used to reside in the second husband house. My lord, there will be a subject matter of this appeal. And I used to reside in tenanted premises. I oftenly come and I did not have any thorough knowledge about this.
Your mother left the property to you by virtue of the
Milord.
no to them.
No, to me.
Acha.
Because
revocation was allowed.
Revocation was allowed. Revocation was allowed.
So yes, so you were not living with your mother, so you did not know about what the litigation.
The pendency of all this litigation and afterwards, that.
Yes, what do you say to the?
Actually, one addition. During the pendency of the appeal, during the lifetime of the mother, she duly contested this revocation proceedings. Even that, my lord, I was not engaged in.
You lived elsewhere.
I used to live elsewhere.
You did not sign anything.
I heard that some proceedings are pending, but I did not have.
You are sure you have not signed anything, any paper on behalf of your mother?
I have nothing, my lord.
Lordship, in this case, we have
Take the mic a bit closer.
In this case, Lordship, we have filed a caveat against the order. That caveat has been received by the instant petitioner on 23rd of November 2023, whereas the appeal has been filed on
23rd of November 23.
23, Lordship.
Yes.
Whereas the appeal has been filed on 4th April 2024.
This period has not been explained.
Lordship, no. And he says that he has no prior knowledge about this proceeding. So he has received the caveat. So it shall be presumed.
Actually, my lord, I have stated.
Wait. We cannot both.
Yes.
Well, what is the source of their knowledge according to their application? What is your name, please? Your name.
My name.
You.
Dhiman Banerjee.
Banerjee. Mr. Banerjee, what is their explanation of the knowledge? Let us see from their application.
Paragraph 3 onwards.
Yes, they have admitted about the caveat.
Yes, my lord. I have stated.
Please take your seat. You are more experienced. Please take your seat. We are feeling threatened by your para 4 of the application. They have stated they knew about the revocation of probate on such and such after obtaining a note. So they have admitted the caveat. Let us see what the explanation they have given about it. Bewildered, could not decide. Remain deal, mother remain deal. So explanation has been given, some explanation.
And for the rest 40 days, Lordship, explanation has been given for 149 days.
Yes, given the explanation till the filing of the appeal. But he has stated the period of delay to be 149. If you see carefully from para 4, he has given explanation till the date of filing of the appeal. Same was prepared and filed on such and such date. So the explanation for the entire period has been given. Then the number, numerically, the number of days has been given wrong. So we'll give him the leave and condone the delay. Probate matter, we have to be sure. Court of conscience also.
The ground
and then we'll come to the stay. Stay will hear you separately. Can 1 of 2024 is an application for condonation of delay in preferring the appeal, pushed up. Learned counsel for the appellant submits that the appellant, comma, being the son of the testatrix, comma, resided elsewhere than the testatrix, comma, the latter residing with her second husband during the relevant period, push up, next para. Although a copy of a caveat was received on November 23, 2024, a copy of a caveat lodged on November 23, 2024 was received, comma, the appellant was completely unaware of the previous proceedings and hence was bewildered, comma, followed by indecision as to what to do, push up, coupled with the fact that the testatrix was all along ill until her demise, comma, the appellant was not in a position to prefer the appeal before it was actually filed, pushed up, next para, the poor monetary capacity and advice from family members has also been cited in the condonation application as reasons for the delay. Pushed up, next para, learned counsel appearing for the respondents harps on the prior knowledge of the impugned decree of revocation of probate by virtue of the caveat lodged on November 23, 2024, which it is submitted that the period from then till filing of the appeal on April 4, 2024 has not been properly explained. Push up, moreover, comma, whereas the delay is of about 189 days, comma, only 149 days delay has been explained. Full stop. Next para, on a careful perusal of the application, comma, we find that the appellant has given explanation for the entire period since learning about the revocation of probate by virtue of the caveat lodged on November 23, 2024 till the presentation of the memorandum of appeal. Full stop. Next para, however, comma, the numerical a numerical error crept only in as much as the number of days of delay is concerned. Full stop. Hence, comma, even though the number of days of delay has been erroneously mentioned in the application for condonation, comma, the explanation for the entire period of delay has been substantially given in the application. Full stop. Upon hearing learned counsel, comma, we are satisfied with the sufficiency of the cause for the delay. Full stop. Accordingly, Can 1 of 2024 is allowed, comma, thereby condoning the delay in preferring the appeal and the connected application for leave. Full stop. Next para, the leave application is Can
3.
Can 3 of 2024 is now taken up for hearing. Full stop. The appellant's father was contesting the revocation proceeding all along.
Appellant's mother.
Appellant's mother was contesting the revocation proceeding. Oh, sorry. You said testatrix, it will be testator. The father left the will.
The second husband of the mother left the will.
আচ্ছা, তাহলে testatrix সেখানগুলো বলেছি testator করে দেবে। আচ্ছা, এটা কেটে দিয়ে নতুন করে Can 3 নতুন করে। Can 3 of 2024 has been filed for leave to prefer the appeal. Full stop. The appellant's mother had all along contested the revocation proceeding in the code below, comma, out of which the present appeal arises. Full stop. However, comma, after the revocation decree was passed and before preferring the appeal, comma, the mother of the appellant died. Full stop. Next para, hence, comma, there is no scope of substitution. Full stop. Upon being satisfied on hearing learned counsel for the parties that the appellant has a direct interest in the outcome of the present proceeding, comma, Can 3 of 2024 is allowed, comma, thereby granting leave to the appellant to prefer the present appeal against the impugned revocation decree. Full stop. Next para, the appeal is accordingly deemed to stand registered and admitted. We will direct stay application is there. Stay application, you have asked for stay of what? Stay of the revocation. But if we grant stay of revocation, then the probate will revive and that will be allowing the appeal before hearing them. You can ask for injunction, but not revocation. Let us see the averments. At best, injunction. So revocation will not stay. Or we can do this. We can dispose of this application. No, without any averment regarding injunction, we can't.
No, there are averments of injunction. Will also go through the application.
Right. To us.
But actually, from paragraph 5 onwards, I have described how the learned court below has made the wrong.
Injunction averment has to be, they are trying to dispose of what. But since the appeal has been preferred, you cannot act on the probate. We'll extend you from doing that.
Actually, what is happening?
It has been revoked. What has happened, Lordship? There is a deed of settlement. There is a registered deed of settlement where the erstwhile testator settled the property in my favor. And suppressing that registered deed of settlement, they have obtained.
As of today, there is no probate, right? Because it has been revoked. So there is no scope of passing any stay. If you pass a stay, if you stay the revocation, then the probates are revived.
Actually, what is happening by the dint of this order of revocation, they want to forcefully occupy the probate.
You have not stated that anywhere, not a single sentence. We'll give you leave to file an injunction application. Can 2 of 2024 is an application for stay of the impugned revocation decree. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we are of the opinion that in the event any stay is granted at this stage, comma, the same will tantamount to allowing the appeal before the appeal is heard on its merits, comma, since the effect of stay of operation of the revocation would be to revive the probate in favor of the appellant before hearing the appeal on merits. Full stop. Next para. Although learned counsel for the appellant makes allegation as to efforts on the part of the respondents to deal with the subject matter of the disputed will, comma, since we do not find any appropriate averments in the stay application in that regard, comma, we are unable to grant any order to that effect. Full stop. Accordingly, Can 2 of 2024 is dismissed on contest without any order as to cost. On the above observations, full stop. However, comma, it is made clear that it will be open to the parties to file appropriate application for injunction in connection with the present proceeding. Full stop. If so filed, comma, the same will be adjudicated on its own merits without the court being influenced in any manner by any of the observations made above.
But kindly
File a proper injunction application will consider.
as you lordship has some expressed the view that since the appeal is pending, they should not prosecute probate. But actually, what has happened? They have put a padlock.
No, we are wrong on that. Because the probate has been revoked. There is no scope of
It has been
probate.
revoked, my lord.
You could have proceeded with the probate.
My lord, actually, what has happened? They have put a padlock upon the suit property and
File appropriate application, sir. আর প্রথমে একটা করে দেবে affidavit of service file to be kept on. আর tested tricks গুলো testator হয়ে যাবে. File an application next week, give a copy to them and come back.
Lordship, may I just indicate one thing? Your Lordship has recorded the date of receipt of the caveat on 23rd of
So we said, we corrected that, we said the caveat was lodged on 23rd.
23rd of November 2024. The appeal has been filed in the 4th of April of 2024.
my lord, I received on that which date I received, I have submitted.
No, 24 November 23.
In their averments, they have also
This will be
written-
2023. November
Perhaps,
23.
Lordship, but in their averments, they have written 2024.
যা আছে থাক আমি দেখে নেব। We'll check it. If we put it in their mouth that it's their submission, then it remains. But otherwise, we'll consider that. Good argument, Mr. Banerjee. Who is your senior?
Mr. Owen Banerjee.
Your grand senior is here.
He is not only senior, he is the brother of our.
Oh, is it so? আচ্ছা।
Keep clear.
Thank you.
No question, not proceed.
The appeal has already been infactual because there was a requirement for filing the section 5 application. I have not filed.
Not only that, the order which has been challenged without the section 5, that list is finally subsequent order passed by the order 39 rule on to disposing of. That your lordship can do from.
We'll record everything and.
That is your recorded. Can you see your lordship's order?
Oh, in our order. আচ্ছা।
Last order can you? Considering my application of vacating, my lord has passed an order.
So till date, no section 5 has been filed.
The appellant do not want.
Fair. We'll record everything.
Can you record? See.
We'll record that the appeal has become infructuous.
Can you peruse it? Lordship did not be dictated again. It can be gathered from here.
So what do you want? I mean, what observation do you want?
I don't want any observation. It should be disposed of. Because your lordship has recorded everything here.
Yes. Appeal will dismiss the appeal as time barred also.
Yes.
That is what we are doing.
This well, the subsequent order
Infructuous.
will pass.
That is what we are precisely.
That has been recorded here.
Appeal, now we have to record that again because we are dismissing the appeal. Learned senior counsel, or if you don't want, we won't record your name also.
ওইটা রেকর্ড করুক বাকি সব বাদ
Then we have to, you have to justify that. We have to justify that by observations in the order, Mr. Vasu. Learned senior counsel for the respondents attracts the attention of the court to the order dated January 28, 2025, where the facts were substantially recorded. Full stop. Also, comma, learned counsel for the appellant submits on instruction that the appellant does not want to proceed further with the appeal. Full stop. Next para. As rightly contended by learned senior counsel for the respondent numbers 1, 2, and 3, comma, the appeal has, comma, in any event, comma, become infructuous in view of the challenge being preferred against an ad interim order, whereas the main temporary injunction application has been finally disposed of since. Full stop. Next para. Moreover, comma, in the absence of any application for condonation of delay, comma, the appeal, comma, which is otherwise time barred, comma, also is non-est in the eye of law. Full stop. Accordingly, if FMAT 117 of 2024 is dismissed as time barred, full stop. Can 1 of 2024 is also consequentially dismissed. No orders to cost.
In this matter, I am for the private respondent number 28 to 18, my lord. But I am badly suffering due to injunction. Because what happened? The Banglar Amar Bari already sanctioned in favor of me. Money already disbursed to my accounts. But due to injunction, I am unable to construct my building. Apart from learned court below declared that the appellant herein have no share at all. Apart from their
This for numbers 11 to
18.
I am 1 to 11.
So you are co-defendants. The injunction is also against them. Arises from partition suit. Partition suit dismissed.
And should decree.
Your part.
And defendant number 2.
Oh, sorry. Decreed in preliminary form. So you obtained that preliminary degree.
Yes, my lord. His title has been refused. No share.
Sir, they have given my lord half and half.
No share on what premise?
The deed, my name is not there.
In the deed of transfer, on which all of you claim. What is your defense to that, Mr. Math?
The property has been purchased from the Grant Property Fund. Therefore, my lord, all these.
So that nucleus.
Therefore, my lord, all these 3 brothers have their right 1/3 share. My lord, I have in the record of rights, my name has been recorded in respect of 1/3 share, and they have each have my lord 1/3 1. Therefore, if they they are trying to my lord impress your lordship that they have got the fund, they will make the construction. Let them make the construction over there. Kindly modify that order.
So over the portions of which they are in occupation of, and he has obtained in respect of a particular portion also. So then what remains in the injunction? They won't be transferring to third parties. Construction, you are not your portion.
That possession manner, as per the record of rights, I am in possession. That should not be disturbed.
What is your answer to this?
Court declared that he has no right, title, interest, my lord.
Regarding possession?
My lord, he has no possession, my lord.
Has it been declared? Show us from the judgment, impute judgment that he has got.
Been declared. That has been specifically stated, my lord, in page 5, my lord. Page 5 of the impugn order. Defendant number 2, Adhin Raut, has no manner of right, title, interest over the suit properties, my lord. Specifically stated, my lord. Page 5.
But the records of right shows that he is in occupation at least. So injunction will grant regarding his portion.
Never, no. In the trial court, no injunction was there even against us. They maybe.
They did not pay for.
Well, I am in possession. That's why I am not paid for.
I am also in possession. Record of rights shows that.
My lord, has no manner of right, title, interest, my lord. That means I think, my lord, he has no possession at all. Record may be, my lord. Kindly see the
issue for this.
Mr. Mahato, the difficulty in these cases is that you are not in possession of any record of right. Your name may be there, but which portion you are in occupation of, how do you ascertain? And tomorrow you will come up with a contempt application and you will say that they have violated. How do we know which portion, particular portion of the premises property you are in occupation of? How can you grant an injunction which is not implementable?
This is my lord, the partition suit has been instituted for demarcation of the area between them. Suppose I have not there, but who are in possession.
Nothing has been allocated to you. Nothing has been allocated to you. So the partition will be between them.
Decided in the appeal.
But how do we ascertain? If we grant injunction, Mr. Mahato, we have to say that they cannot disturb your possession in respect of the occupation of yours. How do we ascertain exact which portion you are in occupation of? Mere recording in the record of right does not ascertain the exact portion of which your physical possession is the prerequisite of an injunction order. Otherwise, Mr. Mahato, you are right. Every kosher.
As per record of rights, but what is
that?
What is
So therefore, it will be a right. Therefore, it will be a non-implementable injunction order.
That even let them not to
Transfer third-party interest.
Do not allow.
No.
Kindly expedite the hearing of the appeal.
No. Because the balance of convenience is in their favor. They have obtained under a scheme. They have obtained this the aid. It cannot be a blackmailing tactics by you.
Then all 3 are in possession.
The court is not dependent on your concession, Mr. Mahato. We are not inclined to grant injunction to you on possession.
That so for record of rights, 1/3 share is with me. As per
record of right, do not confer any title. That's settled.
There is no dispute, but it is my presumption. There is presumption that I am in.
Joint family nucleus. What proof?
No.
What proof did you give me in the court below that it was a joint
That
fund?
has not been proved, my lord.
Then there is no proof that it was purchased from joint fund.
Therefore, I have been, I have not get this, I have defeated in this suit.
Exactly. If there is no proof,
That is required to be, well, that.
you have to show some prima facie case to get an injunction, Mr. Mark.
That's fine. In the-
You just say that it's purchased from joint family and you get an injunction. What? Nothing before the court below. You did not produce anything.
My lord, prima facie presume, my lord, that there something is, otherwise, my lord, it should not be recorded in my name.
But then we cannot grant any
And my lord,
injunction to you.
they have not prayed for any correction before the authorities.
Court held that it is wrongly.
Consider that how long this record of rights is there. My lord, they have never challenged it. Therefore, they have accepted in that sense.
Only third party interest we can grant.
What will
But
be my
they'll suffer irreparably if that scheme goes.
Consider what will be my position. We have, my lord, our residential accommodation. I
No,
said,
you have that scheme. Under the scheme, you have got the money.
Yes, my
I have
It's over a demarcated portion of the property.
particular
plot.
Because your clients will also be affected then.
Yes. I have also
seven
got
minor-
a.
the serial
My
number
name is
42.
there. In
No,
the
then
slip.
if you construct, he's right. If you construct over the entire property, nothing limits.
No. There is a vast area, my lord. Total area is.
What is the total area? Give us the
Total area is 2.98 acres. 2.9.
2.98 acres.
Yes, 30. Only.
And
small.
Amarbari scheme is regarding? Both of you have Amarbari scheme.
Yes. My name is there, but I have not get the money till date.
What is the area? One room.
You must have submitted an application for that.
Yes.
It must have been annexed to your opposition. Where is that?
On the page.
Yeah,
7.
only under the scheme you have got.
Yes.
Is 7.
Yes.
Let us see where the scheme. Give us the page where by which that scheme has been sanctioned.
On the serial number 42.
If you get under this scheme, you don't have to have a sanction plan.
Yes, my lord.
Where is the sanction plan?
That has been, my lord, in the plan. My lord.
Which area do you want to construct?
Road number.
We have to be sure of which
Plot
part.
number 831.
Where do we find that? Which page?
6.
Number?
Your name is?
Shashank Rao.
Page 6 does not contain your name. Rather, Adhin Raut's name is Adhin Raut, Mr. Mahato's client.
Devendra.
Page 6 of the opposition of respondent numbers 12 to 18 we are looking at.
I am the legal heirs of Devendra.
Because Adhin Raut also has equal share there. How can you
Only-
construct?
Only recorded his name in the record of rights.
No, he's right. Recording of name is you cannot. If you construct, there will be nothing left in the appeal. You construct over half of that. No, in fact, 1/3. You have to construct in accordance with your shares if they win, because you have to leave their 1/3. We can grant an injunction that you won't be. We will permit you to construct, but you will have to leave 1/3 area out of that property for that construction, and no creation of third party interest. Mr. Mahato, what do you say to that? The present appeal has been filed against a preliminary partition decree. Learned counsel appearing for the appellant argues that although the appellant's name finds place in the records of right as co-owner of the property, the trial court overlooked the same in refusing to grant any share in the name of the appellant. Secondly, it is contended by the appellant that the premise of the impugned judgment was that the purchase deed of the property does not include the name of the appellant as one of the purchasers, whereas the purchase itself was effected by a consideration flowing from the joint family nucleus fund of the joint family of the parties. Such contentions are controverted by learned counsel for the respondents. Learned counsel for respondent numbers 1 to 11 on the one hand and respondent numbers 12 to 18 on the other individually argue that they have obtained sanction under the Amar Bari scheme floated by the state of West Bengal. Full stop. Whereas the respondent numbers 1 to 11 have not yet got the funds under the same scheme, said scheme, comma, the respondent numbers 12 to 18 have already got such funds as well. Full stop. Next para, as such, comma, it is argued by the respondents that in the event an injunction is passed restraining them from making construction, comma, the advantage of the scheme would be lost irreparably, which would cause irreversible injury to the respondents. Full stop. Next para, keeping on balance the arguments of the parties, comma, we find that a prima facie case for hearing the appeal on merits have been made out. Full stop. Next para, the balance of convenience of and inconvenience dictates that the respondents ought to be permitted to make construction under the scheme in question in respect of their respective 1/3 shares, comma, subject to the outcome of the appeal. Full stop. Next para. Accordingly, can 1 of 2024 is disposed allowed partially on contest, comma, thereby restraining the respondents from making any construction without leaving 1/3 portion of the suit property and or from creating any third party interest in respect of the suit property in any manner whatsoever. Full stop. It is, comma, however, comma, made clear that nothing in the above order prevents the respondent numbers 1 to 11 and respondent numbers 12 to 18 from making construction in respect of their respective 1/3 shares in the suit property during the pendency of the appeal. Full stop. Next para. The appellant, in view of the appearance of all the respondents through their learned advocates, service of notice of the appeal is dispensed with. Full stop. The trial court records be brought by special messenger at the cost of the appellant, which shall be put in within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
My only thing, this is Banglar Bari, not Amar Bari.
ও আচ্ছা, আমার বাড়ি যেখানে বলেছি ওখানটা বাংলার বাড়ি করে দেন। বাংলার বাড়ি, then you are entitled to construct over the whole of West Bengal. Or Bangla has several connotations, like Ram. Ram Da has one connotation, Ram Boka has another connotation, and Bangla also has similar. Anyway, make your construction, use Bangla, but not that 1/3. ডিফেক্টিভ বলছে, কি ডিফেক্ট দেখুন। We find from the office, from the stamp reporter's report dated August 5, 2024, that the appeal is not in form, as the certified copy of the impugned decree has not been filed, in the absence of which the names of the parties could not be verified, nor could the sufficiency of court fees be ascertained. Push up next para. Accordingly, the learned advocate for the appellants is directed to cure the defect by filing the certified copy of the impugned decree at the earliest. Full stop. Upon such certified copy being filed, comma, the office shall furnish a revised report. Full stop. Let the matter go out of the list for the present.
Defendant number 2 is the Malad appellant.
Copy could be served.
Yes, ma'am.
I am appearing for Milord respondent number 2 and 3.
Naturally, Baripur. Baripur caveat address was given. See our previous order.
Yes,
Mr. Mahato, what is the matter? Sorry.
That suit for partition.
Right.
This is against Malad the final decree. Malad, when the commissioner's report was accepted, and
Mr. Mahato, give us half a second. There are certain defects we just check up.
last occasion,
Yes, sir. You applied for certified copy before the decree was passed. Judgment was.
it is wrong. Malad, decree was signed in a subsequent date. But Malad, the date of the judgment is 3rd of May 2023. I have applied on 15th of 3rd of May, and I applied prior to that. I applied prior to I applied.
How could you apply for the certified copy before the
15th of March? I applied Malad 15th of March.
before the judgment was filed? How can the limitation?
Because,
How could you apply? How was your application accepted, Mr. Mahato?
Because my lord, on the last of that, before that, my lord, I made an application for appointment of account commission. My lord, that was rejected by this order. My application for appointment of account commissioner was rejected by this order. But my lord, prior to that, I have filed the application for certificate copy. How, my lord, why I do not.
Limitation, my lord, is staring on their
Decree was drawn upon non-judicial stamp paper instead of proper form.
Generally, it, my lord, drawn upon the non-judicial stamp paper. But report is, my lord, it is not in form.
Anyway, since they have obtained certificate copy, there is no question of limitation.
No, limitation is there. When, my lord, when they have applied, my lord, that has to be.
Let us see the certificate copy.
Yes, my lord, if your lordship kindly come to the first page, the reverse side of the first page of the certified copy.
No,
Date of order is 3rd of May. I have applied on 15th of March.
এটা কোনটা দিয়েছেন আপনি? এটা সেকেন্ড জেজেস কপিটা এখানে রয়েছে তো। আপনার কাছে অরিজিনাল সার্টিফিকেট কপি আছে না এটি? We find a photocopy with the memo?
Original has been filed. May I check?
আপনার ওখানে অরিজিনাল নেই?
No, my lord, I have checked up the record. It was filed with a photocopy, not the original copy.
Original file?
দেখেছি আমি বার করে।
স্ট্যাম্প রিপোর্টার কি রিপোর্ট দেবে না এটা লিখবে না এটাই তো দেখছি।
Oh, my lord, the original has been sent down for correction.
That's the difference.
My lord, if your lordship would kindly, my lord, I have, my lord, obtained, my lord, the bunch of certified copies of the learned trial courts, my lord, orders, my lord, on 14th March 2023, the order says today. The copy আছে না? Order a bunch. My lord says, my lord, today filed final partition report, final decree along with final partition memo. Lord, I do not know what does it mean. My lord, then my lord, this is on 14th March. And my lord, their decree is signed on 4th August 2023. Final decree is prepared, sealed and signed.
So what?
Then, my lord, the decree becomes final on, my lord, 4th August 2023.
No, 3rd May.
Very well, 3rd May. Then, my lord, he says he applied on 15th March. How can we?
Prior to that,
Well,
it is not.
The application is not maintainable. That application for certified copy should have been rejected.
No, that has
There
not
was
been
no
rejected.
degree on that date.
That has not been rejected.
That's
my
not
lord.
a valid certificate copy.
Certified copy has been given to by the court, my lord. Court, it has been supplied. Court has issued this.
My lord would kind enough to see, my lord, 3, my lord, this page, my lord, flag mark pages. These are the, my lord, entire certified copy, original and film of planted.
I applied for
If the stamp
certified.
reporter has given a report, it is impossible to compute limitation. Kindly see the report of the stamp reporter.
Yes, we have seen that because it was before. What were the dates of when you obtained?
I applied on 15th of March 2023. My lord, requisite stamp, my lord, it was 30th August.
Yes.
My lord, requisite stamp paper deposited on 30th August, made ready for delivery 30th August, same day.
And you filed when?
I have filed the appeal, my lord, on
January
7th of October.
The application.
Mr. Bhattacharya will consider the date of application for certified copy on the same date as the date of the judgment decree. Calculating that, I mean, the court took some time and they filed within limitation. We'll say that. This cannot be a ground for what should you do? Dismiss the appeal for this?
Not at all, my lord, but this is so.
No, we'll say that this defect has been cured. What other defect? Any other defect? It has gone down for the other defect. We'll record that the defect, there is no defect, and the other defect, the trial court records will be come back, a revised report will be filed, and in the meantime, we'll take up the injunction application right now. And what about these? There were irregularities.
For pointing out the irregularities, nothing else.
What irregularity? Tell us.
Kindly see, my lord, the 14th, my lord,
March.
March order. My lord, it says, my lord.
Today filed the final partition report. Along with final partition, whatever memo.
Whatever, my lord, can't be made up. Then, my lord, kindly goes to the order.
That's why they applied for certified copy.
Yes, kindly see the August, my lord, the next page, not then thereafter, the 3rd flag marked order, my lord, kindly see August order. It was signed, sealed and prepared on August.
Yes.
Therefore, a decree takes a final shape in August. My lord, in March, my lord, I do not know whether certified copy could have been at all. My lord, it says, my lord, the judgment in, my lord, has been passed. Although, my lord,
Then we set aside the judgment on that ground. It's an irregular judgment. Absolutely irregular judgment. Based on these, we'll take this on record and set aside and direct the trial court to pass another final degree.
When the
Let us do that then. You are right. There are irregularities. Palpable irregularities, several irregularities. So we set aside the degree on that ground.
When the report was submitted by the commissioner, my lord, I applied for certified copy of the report. But that was not supplied. I prayed time before the court. Kindly allow me some time so that after getting the certified, I shall file the written objection to the report. Court has
that certified copy application was treated to be the final, the judgment degree application.
My lord, applied for all.
You are not given the final report, certified copy of the final report, but on the basis of that application for certified copy, you are given the judgment.
Everything has been given.
We find from the office report that although the judgment and decree impugned in the present appeal were passed on May 3, 2023, the certified copy thereof was applied for on March 15, 2023, that is on a prior date, which makes it impossible to compute limitation. Push up next para. The certified copy was directed to be sent down to the court below for necessary correction accordingly. Push up next para. It was also recorded that the decree was drawn up in non-judicial stamp paper instead of proper form. Full stop. Next para, we find as well that pursuant to the direction of the registrar L and OM, the certified copies of the impugned judgment and decree have been sent down to the court below for correction. Full stop. Accordingly, we direct the office to furnish a fresh report in that regard after the certified copies come back to this court. Full stop. Next para, insofar as the prior application for certified copy is concerned, comma, we are satisfied with the explanation of the learned counsel of learned counsel for the appellant that on March 14, 2023, comma, when the final report of the partition commissioner was filed, comma, the appellant applied for a certified copy of the said report, full stop. Instead of granting the said report, instead of granting a certified copy of the said report, comma, however, comma, the application for certified copy was treated to be one for the certified copies of the impugned judgment and decree which were passed subsequently on May 3, 2023. Full stop. Next para. It is submitted by learned counsel for the appellant that the requisites were notified to the appellant upon the judgment and decree being passed on May 3, 2023, on August 30, 2023, and were deposited on the
2024.
2024, August 30, 2024, and were deposited on the self-same date. Full stop. Next para. Ultimately, the certified copies of the judgment and decree impugned herein were also made ready on August 30, 2024 itself. Full stop. The appeal has been presented before this court on October 7, 2024, comma, which is well within the limitation period. Full stop. Hence, comma, we deem the date of application of the certified copy to be on the date of passing of the judgment and decree, that is on May 3, 2023. Full stop. On such premise, comma, the appeal has been filed well within time. Full stop. Accordingly, we treat such defect on the said aspect to stand cured. Full stop. However, comma, the other defect pointed out shall only be ascertained however, comma, whether the other defect pointed out regarding the non-judicial stamp paper, comma, the same can only be ascertained by the revised office report as directed above. Full stop. Next para. The application for injunction is now taken up for hearing. Yes, Mr. Mahato, why was your suit? The suit was decreed finally. What is your ground basically? Just satisfy us on prima facie. Take this back. Eta ferat diye din.
Not affirmed up to Supreme Court.
They cannot reopen that. Mr. Mahato, what is your ground? Allocation.
Allocation. If your lordships kindly come to the page 2 of the certified final report. The decree.
Is it annexed to the application?
Yes. No, my lord, in the memo paper.
Yes.
Final report.
Final
by
report.
Mr. Paul, by Mr. Biswajit Paul, the commissioner. Page 2. May I find it?
No, we'll just. Yes, page 2. Page 2.
Well, it is 4th paragraph. I have measured
Yes.
and made partition. Such and such, and the 3rd line. The plaintiff, namely Sopon Kumar Das, for red color mark A, more fully described in B schedule property. The defendant number 1A, namely Somit Das, and A1B, namely Amit Das, jointly for green color mark B, more fully described C schedule property. And defendant number 2, that is the appellant before lordship, Nishit Das, for blue color C, more fully described in D. Well, these are confusing because if your lordships kindly come to the next page. A schedule property, suit property schedule A. But when more fully described B schedule, it is not there. Then my lord, B schedule property. Under A schedule property.
No, marked A and more
fully described B schedule property. What does it mean?
No, marked A in the map. Marked A in the map, which is the B schedule property.
Marked A.
Plaintiff, namely such and such,
Yes.
for red color marked A. Marked A in the map.
Yes.
In the final partition map, which is described in schedule B of the suit property of the plaintiff. It's very clear. The map is there also. So the A in the map corresponds to B in the suit schedule.
The map, it's not mentioned here.
It's clear because otherwise there could not be any mention of color. red color marked A. So A corresponds to B.
But B schedule property will go to Sopon.
B schedule should go to Sopon, yes.
And my lord, the
And
B schedule,
and
C schedule will go to
C schedule Somit and Amit.
yes, Sumit and Amit. And,
And
my
you
lord,
get D.
D. Now, my lord, kindly come to
D.
the map.
Yes.
It is not paginated, my lord, after page 10.
No. Yes, we have got it. So C.
After page 10,
Yes.
my lord, the first page, I am nothing to say. But second, my lord, kindly see, so for allotment A, B, and C,
Mm-hmm.
my lord, one is common, it is pond. Other two A, B, and C, my lord, kindly consider C area is very small.
C is this page, the first page of the map.
First
There is
page,
also no, not first page.
first page, I am not saying, my lord, because
No,
it's
no.
almost same. ABC.
First page almost same, yes.
Second page, my lord, kindly see, ABC one is common.
Yes.
Other A is there, B is there, C is. Well, C area is very small.
But the fourth page is all C.
Fourth page is
Entirely C, no AB.
no, that is fifth page.
Whatever.
Yes,
One page
but-
contains 3 C's.
Yes. Next, my lord, kindly see only A and B. Next page only A and B. There is no C.
But the all C page is much more area than AB. If you see the two pages, such a small space has been divided between A and B in both the squares, and you get
If we
so many
consider,
C's.
my lord, the
So
second page,
there's a balance between. I mean, why should the code go into the
I shall show to you, lordship. And my lord, kindly come to last two pages, last three pages rather. It is first floor.
Hmm.
First floor, my lord, common for A and B. There is no C. It is first floor.
There has to be some allocation, Mr. Mahathos. It has to be distributed in some manner.
Ground floor, I should be there. My lord, they have given. It is, my lord, my medicine shop in the ground floor. My lord, that has been divided, and they have taken possession of this particular map, my lord. They have taken
That's a very-
possession of.
Yes, what do you say to the injunction?
And my lord,
Pages are not
another
absolutely
thing,
not
my lord. My lord,
Yes.
in the report, if your lordships kindly see,
Yes.
difference. It is, my lord, the page 2. I placed the paragraph that subsequent paragraph.
Yes.
The
Subs-
difference in schedule value is awarded sum to be paid by schedule E to the plaintiff and defendant number 1B by the defendant number 2. I have to give them money, although I have got a smaller place.
Yes, what do you say to the injunction application?
Injunction application, my lord, the pages which my learned senior friend was showing, my lord, is not tallying with.
Anyway, they have made out a case regarding allocation. They are aggrieved.
Yes.
So we have to grant injunction if the property is transferred in the meantime. What injunction they have sought?
My lord, only one thing, kindly see, my lord, the order, my lord, by which it was accepted, the commissioner's report and was accepted, that is 3rd May 2023. Now, my lord, challenging the order of 3rd May 2023, they have filed a civil revisional application which is still pending, my lord, from 2023 to 2025. Now, my lord, they have not shown any urgency, my lord, for grant of an order of injunction. What, my lord, they have done, my lord, for the purpose of filing an injunction on 18 January, my lord, which is at page 29 of the, my lord, Can 1, they have filed a complaint before the police, and my lord has said that we are trying to disturb their possession.
Will grant injunction.
My lord, only thing, my lord, only execution part is left. That is there. And that
No,
is take, my lord, so huge, my lord, properties are there.
No, don't do this. Non-disturbing possession means you cannot execute, in effect. The appellant has made out a prima facie case regarding the allocation of shares and OLT money granted being inequitable. Full stop. Such contention is, of course, controverted by the respondents. Full stop, learned counsel for the you are for the plaintiff respondent.
I'm for the response.
No, nothing.
Plaintiff respondent.
No.
You are appearing with him.
No. She is for the
Plaintiff has not, my lord, lodged any caveat. Therefore, no copy has been served.
Plaintiff, you are appearing for the plaintiff. She has got a copy. So you have got a copy.
I approached my lord, Mr. Phalguni Mamata. He refused to accept. Since in the revision application he appeared, I My lord, my advocate on record, my lord, went him to give a copy.
So give a copy to
Yes,
this. We'll grant ad interim injunction then.
Yes, I am
Grant ad interim
immediately
injunction.
I am supplying.
You want to file opposition? We can grant you. Suppose.
This has to be there, my lord. Appeal may be expedited, my lord.
If they a party wants you, what will be the scope of your opposition?
My lord, one copy has been sent.
But as he is not here, my lord, as your lordship. Only with adjournment grants, my lord.
Well, let there be liberty be given to all the parties, whoever files, whoever doesn't wish to file.
Objection, yes. Opposition will.
Opposition, my lord. My lord, I am appearing for my lord heirs of Ashit Das, that is different number 1A and 1B.
Shomit and Amit.
I am appearing for Shomit Das and Amit Das.
Yes, of defendant number 1.
1.
Period. যে কোনখানটা ছাড়লাম একটু
So far the plaintiff is concerned, my lord, I sent by registered post, he has received. Affidavit service.
Land counsel for the response.
হয়ে গেছে।
Land counsel হ্যাঁ কি sent হ্যাঁ of course disputed by the well, respondents. Full stop. Next para. Learned counsel for the plaintiff respondent number 1 submits that the said respondent has not been served with a copy. Full stop. Your file.
Affidavit service, my lord, I have served.
We are recording
Yes,
their
I
content.
shall serve, I shall serve.
No, you have filed an affidavit.
Yes.
So, however, comma, such statement is belied by the affidavit of service which is on record, which indicates proper service has been effected on the plaintiff respondent number 1. Full stop. However, comma, the plaintiff respondent number 1 seeks to use an affidavit in opposition to the application. Full stop. Next para. Being satisfied of a prima facie case having been made out, comma, we grant injunction restraining the respondents from disturbing the peaceful position and enjoyment of the petitioners in respect of the suit of their from disturbing the peaceful position and enjoyment of the petitioners in respect of the portion of the suit property in occupation of the petitioners, comma, from creating any third party interest and or changing the nature and character of the suit property and stroke or from bas etai ar and or dorkar nei till disposal of the application. Full stop. The respondents shall file their respective affidavits in opposition, if any, within a fortnight from date. Stop. Reply, if any, shall be filed within a week thereafter. The application shall be listed next on March 17, 2025 for hearing. Thank you. Yes. You are appealing? You are appealing?
Yes, sir.
Yes.
This is an appeal against an order passed by the learned City Civil Court.
Is this appealing for the first time?
Yes, your lord.
Serve copies of the applications and come back. The petitioner shall serve copies of Can 1 of 2025 and Can 2 of 2025 on the respondent, indicating that the applications shall be listed for hearing on how soon can you serve? Chorongi Road.
Within 1 week.
We'll keep it after 2 weeks. Indicating that the matter shall next that the application shall next be listed on February 25, 2025, when an affidavit of service to that effect shall be filed by the petitioner. Thank you.
And for the respondent. 18, my lord, this is my application, my lord.
Yes.
Suit for eviction of license.
Can 2 has been allowed.
Can 2, yes, my lord.
What was Can 2?
Can 2 section 5, condonation of delay, my lord.
What are Can 1 and 3?
Can 1 is for stay, my lord. It was
What is the suit appeal from?
suit for eviction of licensee. They got the degree against me, my lord. I prefer this appeal, my lord, from City Court, my lord. First appeal. And another application is Order 41, Rule 27 for production of additional evidence.
That is Can 3.
Can 3, my lord.
Can 3 were directed to appear along with the appeal.
Yes, my
Three minutes, they have annexed these documents which are, my lord, already available to them at the time of trial, and that is not relevant.
We'll direct you to file affidavit in opposition. We're not disposing of that application.
Opposition has been filed and reply has been filed also.
So we'll direct that application to appear along with the appeal.
There is no problem, but my lords, the documents they have submitted are actually irrelevant. My lords, plaint and written statement of a suit filed subsequent.
We'll consider that. Can 3 of 2023 is an application under Order 41 Rule 27 of the Code of Civil Procedure, full stop. Learned counsel for the appellant stroke petitioner submits that the documents now sought to be produced as additional evidence are adjournment for the adjudication of the appeal. Full stop. Learned counsel for the plaintiff respondent controverts such submissions and argues that apart from those documents being available to the appellant at the time of hearing of the suit, comma, the said documents are entirely irrelevant for the purpose of adjudication of the appeal. Full stop. Be that as it may, comma, as per the established practice, comma, the can 3 of 2023 shall be listed for hearing along with the appeal. Full stop. Next para, can 1 of 2023 is now taken up for hearing. Yes, can 1 is an application for stay.
Stay was initially granted by your
Degree of
degree of
eviction.
Eviction, my lord.
So we are to consider
Occupational charges kept.
no, but eviction of licensee or
Eviction
trespasser.
of licensee, my lord. But my case is that I am a tenant, my lord.
Where is the opposition for that? Let us find. Actually, yes. Why 2 oppositions? Oh, 1 for can 3, sorry.
One for cancel.
Supplementary affidavit filed by whom?
With can 1, my lord.
You have dealt with that also in your opposition. এই এটা দিন তো কেটে দিন। এখানটা কেটে দিন। ও এখানটা কেটে। আচ্ছা ওয়েট। We granted ad interim stay.
Yes, ma'am.
Yes, first we'll hear him then on the occupation charge or what?
Yes, ma'am.
Yes.
For my lord, I have already submitted on the last occasion.
Use the microphone, we can't hear.
I have already
Can't
submitted.
hear you still. Use the microphone.
I have already
You're too
submitted.
soft spoken. Use the microphone, take it up.
Yes, my lord. On the last occasion, I have already submitted, so that they have prayed for, stay of the operation of the decree and judgment.
We can't hear you properly, please. We cannot strain ourselves for this.
They have,
Mr. Meena, please help him with the microphone.
it is on.
Bring it closer to your mouth. Yes.
Yes. They have, prayed for stay of the operation.
We know that, but what is your argument on occupation charge?
Occupational charge, if your lordship, kindly come to page 3 of my opposition. Paragraph 9.
Yes.
If your lordship sees, I have said, this is consisting of, 1 room, veranda and 1 privy. And, carpet area is, 300 square feet. And, the area is, 35B, Koilasbor Street. If your lordship kindly.
What is the police station?
Amma Street.
All right. Yes.
And B and C, I have said, the amenities that are available to the property. And D, I have indicated that what would be the market rate of rent. And I have also
300 per square feet means comes to 9,000.
Yes, my lord.
What is the present rent?
No rent.
Or license?
License.
9,000 comes to 9,000 according to you.
Yes, it almost comes to 90,000.
9,000. 300 square feet.
300 square feet. 300
and 300 per square feet.
Yes, my lord. It comes to 90,000.
90,000.
Yes, my lord. Per square feet.
Yes.
And I have also annexed query report. That is annexed at page 18.
That is the market value of the property.
Yes.
We are to ascertain the market rent.
The rent value of the property is almost 7,500 per square feet. So we have said 300 per square feet would be.
Achha.
And there is no question of their capability and occupation as well, because he is a businessman and also
he's exploiting the property commercially.
No, residential.
Residential. And I mean, have you annexed any any other rent receipt in the locality or something like that? How do you ascertain? Only on the basis of valuation of market value, we cannot ascertain. No other rent receipt of the area.
Rent receipt, no, I am not great.
90,000 is a bit too much. For 300 square feet, 90,000 residential, definitely.
As your lordship deems fit,
Yes, what do you say?
Lord, Lordship kindly takes up my supplementary affidavit,
Hmm.
my lord. My predecessor in interest, the tenant of this particular property, my lord. Subsequently, the father of the plaintiff sold out the entire property to another person, one Pritam Gupta, my lord. Initially,
He is for that another person. He is the another person.
no, my lord. He filed the suit, my lord. He's the son of original landlord, inducting landlord.
Yes.
My lord, kindly
You
come.
substituted him after the demise.
No, my lord.
I have filed this
Oh, the suit was filed originally.
I have said, Manoj, I have granted permission to Manoj, permission to
case
them to stay the
Understood.
property.
Understood.
And-
No, you say that the property has been sold to somebody else. He does
Yes,
not
my
have a
lord.
title. How was it dealt with by the trial court?
It was dealt with trial court in other way, my lord. Lordships kindly comes to internal page, my lord.
So just tell us how it was dealt with. I mean, very internal page.
Internal page 6, issue number 1, decision with reason.
That is limitation.
Number
one,
in the
one.
plaintiff,
Manoj, issue number 5, 6, and 7, and it would be Manoj
issue
internal
number
page
1,
7.
my lord. I am just page number 6, internal
We are
page.
there.
Whether plaintiff is the owner in respect of the suit premises or not is a matter of inquiry to be adjudicated on the basis of evidence out from the present. It appears that the suit for decree of recovery of possession by the plaintiff is maintainable in law. We have
Come to
filed
5, 6, 7, as you said.
5, 6, 7, my lord. This that subsequent 5, 6, 7, next paragraph, my lord. Next page, page 7. The plaintiff claims that I'm just skipping upper side, my lord. Plaintiff claimed that he is the owner of the said suit premises. Defendant denies the same and say in his affidavit in evidence that one room from the southern end fell into the southern block as per the recital of the sale deed, that is 25th of May 2005, executed by Rishi Ram Mitra, father of the plaintiff, in favor of Pritam Gupta, and according to the defendant, he is a tenant under Pritam Gupta, who purchased a portion of the premises, including the suit premises, which is a room with privy failing in the share of the said Pritam Gupta according to sale deed. Therefore, it is found that the defendant denies and dispute the claim of the ownership of the plaintiff on the suit premises, and if it is found that the suit premises was sold to Pritam Gupta by the father of the plaintiff, then definitely the prayer of the plaintiff will be defeated. Therefore, the question of status of the defendant in the suit premises as to whether he is a permissive occupier in respect of the suit premises or whether he is a bona fide tenant in respect of the suit premises, it relates to the question whether plaintiff is the owner of the premises. These three issues are therefore interconnected, and fate of the instant litigation depend upon the result of these three issues. As noted earlier, the defendant has stated in his evidence that is agreed further. Shahai Chakraborty was the original tenant in respect of the entire northern portion of the premises number 36B, Kailash Bose Street. And
You are in occupation of the southern portion.
They are saying, my lord. Our, my lord, entrance is absolutely different, my lord. Even, my lord, it will appear from the plaint itself, my lord. I am just handing up to the plain, my lord.
No, keep it with you for the time. Let us see.
So, Lordship, Manoj, kindly come to Manoj.
Wait. Both of you cannot argue. Suit property is 35A or B? Mr. Meena, 35A or B? Suit property.
35B.
You are given a tenancy in 35A, that is the finding. No. Court's finding is southern portion fell in his portion and you are licensed. So that's debatable. So you cannot. So what is your argument on occupation charge?
My lord, kindly see the schedule of the property, my lord. This 300 square feet is.
Yes, that's an admitted position. They are saying it's 300 square feet.
It is not there, my lord. Only it is written one on the first floor, one southern portion of the.
They need not say what is the
veranda
measurement
and
of the
one
room.
PV, my lord.
In the plain schedule, measurement need not be given. What is your stand on that measurement? Have you denied that? What do you say about the area?
My lord, I have annexed one leave-in licensee.
What is your pleading, Mr. Meena, regarding the area? In your reply, at least. They have said 300 square feet. Have you denied that?
300 square feet, my lord, we have given a,
Whether you have denied that or not?
it is disputed, my lord, denied and disputed. But one agreement has been annexed in the.
We go by 300 square feet because there is no clear denial of that. You have not said it's not 300 square feet, it's such and such square feet in your reply. Let us see which he has stated in we don't find anything in his opposition. He has stated 300 square feet. That is paragraph 9. Let us see how you have dealt with that paragraph 9 in your reply. Let's just see that will suffice. 9 ABCD you have dealt with separately.
Page 7.
No, 6. Starts from 6.
6.
You specifically deny that said measuring out such and such in this connection is a clear demarcation such and, but you don't state the area. You just deny that it's 300. You don't say this is this much.
Yes, sir. That is.
No, you have not stated it.
Well, there were no
Only denials.
trial court, my lord. So, my lord, I couldn't ascertain, my lord.
You were residing there. You could not ascertain no commission work.
No commission work. in the
Ridiculous
trial court,
submission,
my lord.
Mr. Semina. You are residing there. You don't know the area of your premises because there was no commission work. Next, you will say you don't know your name. Your client does not know his name because it was mentioned erroneously in the memo.
My lord, kindly comes to.
Well, this is for sentimental value. Page 16, photograph.
My lord, that I'm.
They obviously for sentimental prejudice value. We are not prejudiced by this.
Just to show that the very old building, my lord, dilapidated condition. For that reason.
Kailash Bose Road, there is no new building probably.
But page 15, my lord.
But it's a commercially exploitable area.
But it is a.
What does your client do?
Residential, my lord, purpose.
He's a doctor. No, he's a doctor. What does your client do?
Businessman, madam.
70 years old.
My lord.
And this is your family. You have annexed a photograph of that. You are not paying anything at any point of time. What is your, according to you, what is the rent paid?
We are paying rent to the tune of rupees initially 140, my lord. I have annexed, my lord, with the supplementary affidavit, my lord.
For the northern portion.
That is written, my lord. And subsequently to Pritam Gupta, that is 210, my lord.
When was that from when the tenancy was created when? Pritam Gupta?
Pritam
According
Gupta,
to
it was sold out to Pritam Gupta on 25th of May 2005.
So 2005 rent is obsolete now. We are in 2025 now. 20 years, 2005 and yes, 20 years have passed.
My lord. There was a litigations with the Pritam Gupta also, my lord.
এমনি ওই জন্যই ছবিটা দিয়েছে বাট ওই এলাকাটা কমার্শিয়ালি
Pritam Gupta also filed a suit claiming the title over that particular room, my lord. That suit, my lord, that plaint I have annexed with that.
That will decide in the
application, my lord. And my lord, I have annexed one in my affidavit, my lord. I have annexed one leave and licensee agreement, my lord, wherefrom it will appear 1,000 taking consideration 300 square feet, my lord.
Have you stated anything in your opposition regarding that they are running a business or they are businessmen? Because they have stated unemployed in their affidavit consistent.
Kindly come to our opposition.
When they filed the application, the age was 69 years. By the time they filed the supplementary affidavit, it has increased by 1 year. So,
If your lordship kindly comes to my lord, page 11 of my opposition.
Yes, page 11 of your opposition.
This is my lord a miss case. They have filed on my lord's 28 November 2024 before the my lord executing court. Now, my lord, if your lordship kindly come to the my lord affidavit of portion, page 17, your lordship kindly sees by occupation business. And my lord, they have said in the appeal unemployed.
Yes, Mr. Mina. Your learned friend is very thorough. Nothing doing.
Milk sell করে
My lord, my instruction is that he is selling milk door to door.
Do you have any idea how much they earn without any overhead expense? And where do you keep your cows? It's illegal in Calcutta.
তখন করতো, এখন কিছু করে না, এখন বয়স হয়ে গেছে, করতো না, যখন লোয়ার
এখানে তো লিখেছেন
Within 1 year বয়স হয়ে গেছে? 2024, you have affirmed this affidavit. And this affidavit also probably in 2024 itself, or no, 2025 recently. So that was filed, we are telling you when. November 2024, and we are in February 2025. So 3-4 months back, you are employed, you are selling milk, now you are doing nothing.
That is, my lord, your lord, what I have got in.
It's a wrong statement in your opposition, in your application. It's that bad.
My lord, kindly come once, one leave and licensee agreement I have annexed that
What
is.
leave and license? You have said you are unemployed, but you have said you are doing business. And milk business, now you are admitting after you are charged. 300 square feet, ওটা যদি কমার্শিয়াল ইউজ করতো তাহলে ওরকম দিতাম না, কমার্শিয়াল থাকে family. The person who came is a member of that family. You have only annexed the photograph of the aged people.
5 members there. 5 members.
Apart from those 3 people who are there. Grandson, son, what? Daughter or ask your client, the milk business person, ask him.
আমি আর ভাই ভাগ্নেরা ভাগ্নেরা দিদি যাচ্ছে, দিদি যায় ওটা
4%.
4%.
$300 square feet বলে চিন্তা করছি কত তো 20,000 বিল
ঠিক করছে লেটেড পারসন রেসিডেন্সিয়াল কমার্শিয়াল থাকলে
দুধের ব্যবসা করে মানে টাকা আছে, টাকা নেই তাই এরিয়াটা খুবই ছোট, 300 স্কোয়ার ফিটটা খুবই ছোট, ওখান থেকে ব্যবসা করে আমি থাকি।
My lord, may
We are debating between 50,000 and 20,000 now. We are in the midst of that.
My lord, may appoint.
Not debating.
Appoint
discuss.
a special officer
To do what?
Inspect the local, my lord, to see what is the conditions, my lord.
The area, the
And,
neighborhood is
and-
very good. Neighborhood, if you they can, the test is whether they can let that out to some person who will give, it will fetch more money. Now that area, that's really in the vicinity of the Chaltabagan, that Lohapatti, as they have said. And have you seen the gaddis of those areas, where in a small space, 300 square feet, they would stack so much, so many things, and they have their khatas and they earn mint money there. Mint money from there. He'll easily get much more there. And you have suppressed that you are selling milk. You have suppressed, you have said you are doing business in a different affidavit, which has been exposed by their annexure.
That instructions which I have received, my
No,
lord.
no, not you. Obviously not you as counsel. No, we'll grant 20,000.
But it's very difficult for him, my lord.
Leave the premises.
My lord, 20,000 will be very hardship, my lord, for the client, my lord, to pay 20,000, my lord.
You are selling milk. What is your earning from that? Ask your client. From selling milk. Heard learned counsel for the parties. Puts up next para. The question boils down to the occupation charges, which should be fixed as condition for grant of stay. Puts up next para. The appellant claims to be a tenant in respect of the property, which is disputed by the respondent and has been disbelieved by the learned trial judge. Full stop. The learned trial judge, comma, upon perusing a sale deed produced by the appellant in favor of a third party to the litigation, comma, came to the conclusion that only the northern portion of the property was sold to a third party by the predecessor in interest of the plaintiff respondent, and the southern portion, comma, where the suit premises are located, comma, still has still been retained by the present plaintiff respondent through inheritance from his predecessor. Full stop. Next para. The learned counsel for the respondent argues that the property is of about 300 square feet in a commercially viable area, and the surroundings thereof are exploited commercially by the neighborhood people. Full stop. Next para. It is also submitted that on a proper assessment of the market value of the property, comma, in support of which documents have been annexed to the affidavit in opposition, comma, the minimum market rent which could be fetched by the property if let out at the current juncture would be rupees 300 per square feet, comma, bringing the total to rupees 90,000 per month for the 300 square feet premises. Full stop. Next para. Learned counsel appearing for the appellant stroke petitioner controverts such submissions and argues that the petitioner is 70-year-old and is unemployed. Full stop. As such, comma, since the premises are being used for residential purpose, comma, the occupation charges should be much less. Full stop. It is submitted that contemporaneous tenancies have been granted in recent times to the tune of rupees 200 per month. Full stop. It is also argued that a visual inspection of the premises would show that it is situated in a not posh neighborhood, and as such, the occupation charges ought to be reasonable. Full stop. Next para. Although we agree with the submission of the appellant and convinced by photographs annexed to the supplementary affidavit of the appellant that the building is quite ancient, comma, we also find from the said photographs that moderately modern amenities are existing in the premises. Full stop. Next para. It is also evident that the neighborhood of the premises is quite commercially viable, and as such, if the property is let out to third parties at the current juncture, comma, the respondent would be able to get monthly rent to the tune of at least rupees 20,000 per month, rupees 20,000. Full stop. Next para. Accordingly, comma, on a balanced assessment of the respective contentions of the parties and the documents annexed to their pleadings, comma, we are of the opinion that the appellant should pay at least rupees 20,000 per month as occupation charges. Full stop. We must mention here that although the appellant has stated in his affidavit, in his supplementary affidavit and affidavit in support of the stay application, that he is unemployed, comma, the said the incorrectness of the said statement has been exposed by the respondent, who relies on a miscellaneous case filed in connection with an execution case as lately as on November 28, 2024, where the appellant described himself to be in business. Full stop. Next para. A lame explanation is sought to be advanced on instruction by learned counsel for the appellant to the effect that the appellant used to carry milk business from the said property, which has now stopped. Full stop. However, comma, in view of the suppression, comma, we draw adverse inference regarding the income of the appellant as well. Full stop. Keeping in view the above considerations, comma, Can 1 of 2023 is disposed of by granting stay of operation of the impugned decree and or connected execution case till disposal of the appeal, subject to the appellant paying occupation charges to the tune of rupees 20,000 per month, comma, payable by the 10th day of each current month from March 2025. Full stop. Next para. The area occupation charges from the date of passing of the impugned decree till the month of February 2025 shall be paid at the rate of rupees 10,000. Full stop. Such arrears shall be paid by 3 equal monthly installments, comma, the first of which shall be paid by a February 28, 2025, and thereafter by the last day of each succeeding month. Full stop. Next para. In default of any of the above payments, comma, current or arrears, comma, the stay order granted above shall stand automatically vacated without further reference to the court. Full stop. No orders to cost. The appellant shall, in view of the appearance of the respondent through his learned advocate, comma, service of notice of the appeal is dispensed with. Full stop. The trial court records shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. The liberty is given to the parties to mention the appeal for inclusion in the list as and when the same is made ready for hearing. Next. Yes. Who is appearing? You are for the appellant. You are for the respondent. You have not filed a no objection. There is a previous Vakalatnama. You are Miss. Who has filed? You are Sandeep Dinda.
Yes, I'm the junior.
Junior to Sandeep Dinda. There's an office report that without a no objection, there's a previous caveat lodged by Shahnaz Parvin. You have to file a no objection for appearance. You have to file a no objection certificate, Vakalatnama.
No, my lordship. My lordship, I was there no instruction, my lordship.
Pardon?
No instruction, my lordship.
No instruction means?
Vakalatnama is no objection.
No. Previously, an advocate has filed Vakalatnama for your client, right?
Yes, my lordship.
So, if you want to appear now, your senior wants to appear now, he has to file a no objection certificate. A Vakalatnama with a no objection from the previous advocate. You have to do that. Unless you do that, we cannot permit you to appear.
My lordship, give me some time.
We'll give you some time. We'll give you some time. Yes, what is the application for?
Pay of the said primary degree.
Preliminary degree, partition degree. Sandeep Dinda. You are appearing for whom?
Opposite party.
Sandeep Dinda has filed Vakalatnama.
Yes.
Without no objection, there is the office report. Previously, there was a caveat lodged by Shahnaz Parvin. Ask your client, take a no objection from her. We will have to keep the application pending unnecessarily. We could have disposed of and passed directions.
Kindly give a 2 days time within that.
2 days?
2 days.
Can you do that? Where does your client reside? Vishnupur. Can you obtain no objection? You have a talk with the previous advocate, some Shahnaz Parvin, Ms. Shahnaz Parvin. She has filed this caveat for him. Anyway, we'll grant you liberty, but till then there'll be the usual order. The final degree proceedings will continue, but no final degree. The office report indicates that although a caveat was lodged by filing Vakalatnama through a different learned advocate, comma, one Mr. Sandeep Dinda has now filed Vakalatnama on behalf of the sole respondent, bereft of any no objection certificate from the erstwhile advocate. To sub next para. Accordingly, the learned advocate, having instruction now to appear for the respondent, is directed to file a proper Vakalatnama with no objection from the erstwhile advocate within a fortnight from date. Pushed up next para. The learned trial judge shall continue with the final degree proceedings, but shall not draw up any final degree without the leave of this court till disposal of the application. Pushed up. The application shall be listed next in the monthly list of March 2025 for hearing. Do whatever you can in the meantime, file that Vakalatnama, then we'll dispose of the application and direct them to file paper books and all. Yes. Give your names, please. না কিন্তু নামটা নামটা দেবেন তো নামটা রেকর্ড করবে give your names নামটা ব্র্যাকেটে রেকর্ড করবে advocates having instruction to appear for the respondent advocate for the respondents না advocates having instruction to appear for the respondent আর appellant যেরকম আছে yes
Your Lordship, I am appearing for the appellant.
Right.
My Lord, this is against the award.
Mr. Banerjee, there is a caveat. Sir,
Because section 5 was there, I served, they appeared my Lord, last the day. Your Lordship has been pleased to
so that
appear.
section 5 has been allowed and now it's under order for two.
Yes.
What is the challenge against?
Challenging the award passed by Justice Samanto as his Lordship then was of 2,62,000.
Award under which provision? Arbitral award?
Yes, arbitral award. Now, my Lord, here, my Lord, the difficulty is that
Section 34 has to be filed then.
my Lord, it was earlier filed. That is the thing.
What is the valuation? We hope it's not a commercial matter.
My Lord, award passed.
This is Mala, this is a under Mala section 11. Under section 11.
2 lakhs and 300,707.
Well, this is
That
under
is the-
section 11 of the Requisitioning and Acquisitioning of
Acquisitioning
Immovable Property Act.
Immovable
Sir, different.
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 Well, 34 with Mala in
Now our contention, my Lord, most respectfully, I am submitting
Sir,
contention.
I have never heard of the act.
My Lord.
Requisitioning and acquisition of.
First matter, my
Have you got a copy of the act?
Yes, yes. I have.
Give please write the name of the act on a slip of paper
Yes,
so that we can have a copy later on.
I'll do it.
Right.
এটা রেখে দিন এটা
Also,
এটা
my
একটা
lord,
আনিয়ে
you
নেবেন
can
হ্যাঁ
get a copy of the act, my lord, from here.
বইটা আমাদের দিয়ে দিন আর উনি স্লিপে লিখে দিচ্ছেন ওটা আনিয়ে নেবেন ওই স্লিপে প্লিজ রাইট অন আ স্লিপ অফ পেপার দ্য নেম অফ দ্য বুক
Yes.
রাইট নাও ইয়েস
Now, my Lord, our
নাম Yes, teach us about the act first.
my Lord,
What is
our
the act
con-
about?
Our contention is that, my Lord,
Compensation granted.
already
Your
granted.
property was you are
I
the landowner. Oh, acha,
Central
you
government-
acquired.
Yes. After,
Acquired or required?
my Lord,
Both are here.
acquired.
Acquired.
Hereafter, my Lord, compensation was already paid to the state government. Now, my Lord, the total land was 3045.18 acres. Out of that, my Lord, 292.87 acres were acquired by the central government, which, my Lord, erroneously, I may say, my Lord, given by the state government to the petitioner as a lease, which starts from 1996 to 2026.
When did you acquire?
My Lord, I acquired on 1963, 7/12/1963. Now, already I paid the amount of compensation of 34 lakhs to the exchequer of the state government, which has not been paid to my learned friend's client.
According to the act, what is the modality? You have to pay through the state government. Why the state government?
My Lord, because at that material point of time, state government, my Lord, give the lease to the petitioner. And what happened, my Lord, when the arbitration proceeding was taken place, unfortunately, our learned advocate, my Lord, did not file any written objection, did not bring this fact.
It went by non-traverse.
Yes. Though he appeared, my Lord, that is reflected. If your Lordship kindly take the trouble.
Now let us see the compensation was awarded. Now, where is the provision of giving it to the state government through whom lease was for how many years?
Lease from 96 to 2026. That is.
So how are they entitled?
My Lord, through RIP Act.
RIP Act says whoever is in possession has to get it or what?
Your Lordship.
Did you challenge their locus standi to get the compensation at all?
The Lordship kindly, my lord, comes to the grounds, that is, my lord, ground number 12, my lord, page 10. May I please, my lord? Page 10, my lord.
There is no pagination in your memo.
No pagination.
In your memo, there is no pagination. Anyway, round 12, yes.
Yes. Well, section 8, 1B, read with section 17 of the Requisition and Acquisition of Immovable Properties Act 1952, having authorized the central government or its delegate power to select by notification public in the official gazette and laid before the parliament and appoint statutory arbitrator by appointing such and such. Now, here what happened after the award? My lord, award has been passed against us. My lord, we preferred the appeal. Now, thereafter, they filed execution case. Now, the execution case, my lord, respondent number 2.
How is the execution case filed in the under this act? As a public demand recovery or before civil court?
Before civil court, my lord, the DM, the collector, my lord, yes, my lord, he passes an order against the petitioners stating inter alia that it is not maintainable. Against that, they preferred a writ petition.
Execution case was, my lord, filed initially before the original side of this honorable court. It was held to be not maintainable.
Ultimately, it has been held to be maintainable. It has been filed before the proper forum.
Yes.
So let us forget that chapter.
Yes.
So what is the ground of challenge here?
My lord, one of the ground of challenge is that, my lord, the compensation amount was paid.
Very well. What is the any application we are admitting the appeal? What is the application
My
for?
lord, application, my lord, kindly gives us leave. My lord, will file this application within 2 weeks, my lord. So far, this stay is concerned, my lord.
Why should you give you leave? If you don't have, if you haven't filed any application, you haven't.
My lord, the difficulty is that
Now, in view of arguable questions of fact and law being involved in the, in view of arguable questions of fact and law being involved in the appeal, comma, FMA 309 of 2017 is record hai jacket. In view of arguable questions of fact and law being involved in the appeal, comma, FMA 309 of 2017 is admitted. Full stop. The appellants shall put in the requisites for in view of appearance of you are for which respondent?
There's only one respondent.
Achha.
But I'm for the no, they are
No, the others are state.
Well, I'm for the
And
company.
state is also an
In,
important.
in view of appearance of the respondent number 1 through its learned advocate, comma, service of notice of appeal on the respondent number 1 is dispensed with, full stop. The appellants shall deposit the requisites for service of notice of appeal on the pro forma respondents. Full stop. The trial court records be brought by special messenger. The records be brought by. Are the records before this court? No.
No.
The records be brought by special messenger at the cost of the appellants, also to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court of the records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. If you file any application in the meantime, we'll hear it.
Some precedents, well, because 2015 award, nothing has been paid yet. And my lord,
You proceed with your execution.
after my lord, the execution, my lord, this was dismissed for default. My lord, repeatedly, my lord, mentioned.
Proceed with your execution. Who prevents you? এই বইটা ফেরত দিয়ে দেবেন আর এই বইটা আনিয়ে নেবেন।
My lord, I will try to converse myself also. So far, the act is also.
Yes, right.
Good.
Yes.
Of the appellant.
Yes. What is the appeal about?
For declaration, permanent injunction, and recovery of first possession.
You are the defendant.
I am the defendant, appellant hearing.
Yes.
But the fact is that one, Shikhar Majhi was the absolute owner in respect of the scheduled property. But he belonged to a scheduled tribe category.
No, this is a judgment of affirmance. All right. Scheduled tribe, yes.
Scheduled tribe. But he is only one daughter, Shabia Mohajan.
Right.
But the Shabia Mohajan inherited his property with a limited scope. According to the section 2, subsection 2 of the Hindu Succession Act,
Hmm.
if your lordship,
Hindu succession একটা দিন তো হিন্দু সাকসেশন এটা না এটা
section 2, subsection 2. Notwithstanding anything content in subsection 1,
give us half a minute. Yes. Yes.
notwithstanding anything content in subsection 1, nothing content in this act shall apply to the member of the scheduled tribe within the meaning of clause 25 of the article 366 of the Constitution, unless the central government by notification in the official gazette otherwise directed. That means section 1 is not applicable in respect of the scheduled tribe woman. But Shabia Mohajan executed a deed of conveyance in favor of her daughter. But she
Deed of conveyance means transfer. I mean, give deed or what?
no deed of conveyance, sell it.
Sell it. Yes.
Sell it. Her two son and one daughter. But the elder son is
No. The sale was made to the daughter only.
Only daughter.
Two sons were left out.
Left out.
Very well.
But they are residing there. But the elder son is the appellant defendant herein.
There are 4 appellants.
4 appellants. 3 appellants are the son of the defendant appellant number 1.
All right.
Younger son is not made a party in the suit. Only elder son by elder brother of the Tuni Hazda is the party of the instant suit.
Tuni Hazda is
the plaintiff of respondent hearing.
Yes.
And a daughter of the Shabia Mohajan.
Yes. What was the suit for?
A suit for declaration permanent injunction
On the basis of the sale deed. Right.
Yes.
Then
but the first question is that this is the misgender and non-gender of the parties, because the younger brother is not a party in the instant suit. My second point is whether section 2, subsection 2 of the Hindu Succession Act, in respect of the tribal woman, they are the scope of the limited inheritance, some limited scope. They are not right to the saleable on transfer in the property belongs to her father. My third point is, according to the 14B of the West Bengal Land Reforms Act, a tribal property should not be transferred unless...
No, the second point you could not understand. That Tuni Hazda is the vendor. So she received the... you say Shabia Mohajan could not transfer the property.
Yes.
Shabia Mohajan was the only heir of her father. But why do you say she cannot transfer the property? The property transfer is not under the Hindu Succession Act. You say she does not succeed to the estate of her father.
He succeeds to the estate of the father,
then,
but it's a limited scope.
What do you mean exactly by limited scope?
Limited
what
scope
is the limit?
Residential power. Her residential power is there, but did not transfer. But
so therefore, title is not, she does not succeed to the title.
Yes.
As per the Hindu Succession Act, she does not.
Not.
But even otherwise, she does not succeed.
No. Because...
Who succeeds then? For tribals?
Tribals?
Who gets the property of the father? The only heir does not get the property. Who is the heir as per the tribals?
according to the
What law is governing them?
the law is governing
I mean, which law of inheritance governs them? They have to have a law of inheritance.
Yes.
For you to say that she does not acquire, as the only heir, she does not acquire the property. Then who does?
If your lordship kindly want this Southall Porgona's Tenancy Supplementary Provision Act 1949, Section 2. If your lordship
Does it confer rights of inheritance also?
Not only one.
This is the Chotanagpur area.
Section 2.
There is a Chotanagpur Tenancy Act. This is not that.
Yes, Southall Porgona provision.
Yes, 2 says applicable, yes, provision.
Only section 2 of the subsection 2 Hindu Succession Act is applicable. Their inheritance power.
Acha. Santal widow cannot make alienation without legal necessity.
Yes.
So they inherit title to a limited extent that they cannot transfer.
Transfer.
Very well. Then
my third point is, according to the 14B of the West Bengal Land Reforms Act, the tribal property, if that has been transferred after obtaining sanction from the block land and land reform officer. This is the provision incorporated in the section 14B.
have you got a copy of the act? Just hand up. Land Reform Sector in West Bengal Land. Government civil partition is agent by sale or exchange in favor of any person belonging to scheduled type. But subsection clause small e says that sale or exchange can be effected in favor of any person belonging to a scheduled tribe. So her daughter is also a scheduled type person. So sale can be effected. আর কোনো বই পাওয়া যাচ্ছে না, এটা ফেরত দিন ওনাকে। Please come to clause E. Acha, previous permission is there.
Yes, previous permission is required. Only my contention is.
No. Sorry. If she transfers to a person not belonging to scheduled tribe, then only that permission is required. But if the transfer is effected in favor of a person belonging to a scheduled tribe, no permission is required. Here, both of them belong to the scheduled tribe. So no. The third ground fails.
This deed of convention been executed in the 2000.
Even then, she can transfer by way of a sale to another scheduled tribe person. So the first ground is also we are not very satisfied because this is a suit for declaration and eviction. Whoever is in possession of the property, her cause of action is against them. This is not a partition suit that all the co-owners have to be implemented, nor a probate application. Why should another person, another brother who is not resident there be implemented?
The property obtained by the Tuni Hasda from her mother. Her mother has not right, according to the section 2, subsection 2 of the Hindu Succession Act, has right to the transfer the said property. Therefore, if she obtained the said property by way of deed of conveyance, then the other co-sharer should be a party in the instant suit.
Other co-sharer of whom? Of the mother.
Mother.
Means Sabia Mahajan.
Sabia Mahajan had 2 sons, 1 daughter.
All right. The other co-sharers of the of Tuni Hasda, the transfer should be implemented.
Yes. If the Sabia Mahajan has not right to the transfer the said property according to the law,
But no relief is sought against the other person, because if she had challenged the sale deed, somebody had challenged the sale deed, then the other heirs would be necessary parties, other co-sharers. But she's relying on a sale deed. She's saying that I have right by virtue of this sale deed. It has to be one of the issues is whether that sale deed is valid, undoubtedly. So she relies on a sale deed and says, I seek a declaration of my right on the basis of the sale deed, and also eviction of the persons who are there. So for seeking that declaration on the basis of the sale deed, that the sale deed is valid, why should she make the other co-sharers a party?
sale deed itself is not a valid sale deed. Because they who execute the said sale deed, her has not any right and power to the execute the said sale deed.
Let us see the frame of the suit. Have you annexed the plaint?
Yes, yes.
Let us see.
In my stay
Yes,
application.
yes. Just let us see that we want to see the reliefs only. It's almost illegible. Yes, very well.
Page 8B, the
You have given type
page
copies also.
for degree of declaration.
Oh, title, right.
Over the land mentioned schedule 1 below. on the
Title,
plaintiff
title.
that the defendant have got no right title interest over the
Yes, you are right.
any portion of the schedule.
You're right. She seeks title also, not declaration that. How was it dealt with by the courts below? These questions? You raised these questions in the court below?
Yes, yes.
How were it dealt with? Let us see the appeal court, how it was dealt with.
Yes, Honorable, if your lordship kindly come to page 7 of the appeal court's order, internal page 7. There is no designation.
Yes, yes, there is a pagination. I mean, internal page is there. Yes, 7.
The middle portion, Sikorbaji was a member of the scheduled tribe, and in view of the subsection 2 of section 2 of the Hindu Succession Act, provisions of the Hindu Succession Act are not applicable in the matter of inheritance and succession of the property. Accordingly, Sabia Mahajan inherited Shikar's property. She acquired only life estate over the same. It is a further case of dependent that accordingly, after the death of the Sabia properly ought to have reverted back to the Shikha Mahajan and devolve upon the dependent number 1 and Barku. Barku is the another brother. Her 2 sons. During the lifetime of the Sabia, Barku demanded half share in the property left by the Shikhar, and he was given half share of the property of Schedule 1. The dependent got property of the Schedule 2 and some other portion of the property, the Schedule 1 and this residential house over the homestead over land of the Schedule 1. That Sabia did not acquire any saleable right over the property question and had no right to execute any sale deed in favor of the plaintiff, and dependent believed that the plaintiff, her husband and Barku is absolute ignorance of the Sabia, managed to sell deed execute by the Sabia in favor of the plaintiff, taking the advantage of the physical and mental condition of the Sabia, who became too old and was suffering from several alignment and at the relevant point of time.
This is a case. How was it dealt with?
The
decision with reasons. Let us see.
Actually, the appeal court created
So many judgments were cited.
Actually, appeal court did not properly dealt with already some of the judgment trying to or
No, but you have the thing you have cited. That's a comment. That's not the section. Which section of this act is applicable? Which divorce transfer? we appreciate that Hindu Succession Act is not applicable. Then what is? What is the law regarding Santals? You have handed over only you are relying on a comment, the comment of the author, of the publisher. Which section of this act prevents or gives a limited right on her?
I did not find out any separate right of the Santal or scheduled tribe.
Then why should the এমনি Succession Act দিত? Second বইটা ওপর থেকে সেকেন্ড বইটা দিন But then why should the Indian Succession Act not apply? Because it was your duty to prove whether there is any particular customary usage of the Santals. Because you deny the title. No usage of the Santals was provided. Customary usage no evidence was adduced on that. So if that be so, if Hindu Succession Act is not applicable, then Indian Succession Act would, and Section 34 says where intestate has left no widow, his property shall go to his lineal descendants. So Sabia was a lineal descendant. So the property goes to her. Goes to her means lock, stock, barrel. The property shall go. That is the language. So you did not produce you did not produce any material to prove the usage of the Santals. And here you are relying on a judgment of some other high court probably. PLJR, we don't know what is PLJR. Patna maybe. Patna law journals. In that case, only the head note is given. So is there any provision in this act which says that she gets only a limited right? You haven't got the index of this. They're difficult to find out for us. There are so many comments, they override the sections. If you did not prove any usage of the Santals, then what can the court rely upon? I mean, anyway, it's a question of law, we'll admit that. Upon hearing learned counsel for the appellant, the present appeal shall be present appeal is admitted and shall be heard on the following substantial questions of law. Roman 1, whether in view of the provisions of the Hindu Succession Act 1956 not being applicable to Santals, Santals, by virtue of section 2 within whether whether in view of section 2 within bracket 2 of the Hindu Succession Act 1956, the provisions of the said act being not applicable to Santals, the vendor of the plaintiff respondent, namely Sabia Mahajan, acquired any sellable title in the property which was sold by her to the plaintiff by virtue of section 34 of the Indian Succession Act 1925, or whether, being governed by customary usage of the Santals, she acquired only a limited title in the property without the right to transfer. Roman 2, whether the suit was bad for non-joinder of, what was the name of the younger brother?
Barku. Barka Soren.
Bartha.
Barka. Bhurka.
Whether the suit was bad for non-joinder of Barkha, Burkha, Bhurka, Soren, comma, one of the brothers and heirs of Sabia Mahajan. That's now, what is the application for?
The application for stay.
What is Can 3? Section 5 has been allowed only.
No, that isn't allowed.
Okay.
Can 1. Of the
Stay of operation, what is the decree passed?
Passed in
Recovery of possession.
recovery of possession.
Declaration of title, recovery of possession, permanent injunction. Recovery of possession, we don't find. Yes, recovery of possession. In view of a strong prima facie case for hearing of the second appeal having been made out, and the second appeal has been admitted on the above substantial questions of law, comma, there shall be stay of operation of the impugned judgment and decree dated July 18, 2017, passed by the, oh no, you have given it wrong. There shall be stay of operation of the impugned judgment and decree dated December 21, 2022, passed by the learned civil judge, senior division, additional court at Purulia, comma, district Purulia, in title appeal number 102 of 2017, as well as the judgment and decree dated July 18, 2017, passed by the learned civil judge, junior division at Purulia, in title suit number 218 of 2010, till disposal of the application. The appellant stroke petitioners shall serve a copy of the application on the respondent opposite party, indicating that the application shall be listed for hearing in the monthly list of March 2025. The appellants shall file an affidavit of service to that effect on the next returnable date. Thank you. Thank you. Yes, next.
For the caveat.
Yes. Yes, Mr. What is the appeal against Mr. Mitra?
My learning is appellant, but I am for the respondent.
Yes. Mr. Mitra, yes. That
I was wondering whether the surname, my lord, whether I heard something else, my lord. Your lordship said
Your
Mr.
lordship
Mitra.
asked me that what is the matter about Mr.
No,
Mukul?
Mr.
That's
Mitra.
the
No,
Mr. Mitra.
Oh,
Mr. Mitra.
then I made the mistake.
Yes.
Now, my lord, a suit for recovery of possession on the ground that, my lord, the defendants or, my lord, the defendants, my lord, were trespassers into the property from a particular date.
Right.
The suit was contested by one of the defendants alleging that
Previous matter. Hangover of the previous matter.
my lord, alleging that, my lord, the defendants or the predecessor of the defendant, my lord, was in possession and was in adverse possession of the property. Now that suit was decreed in favor of the plaintiff. One of the defendants or the contesting defendant, my lord, had filed an appeal. The first appeal. In the first appeal, my lord, during the pendency of the first appeal, my lord, the defendant or the appellant had made an application under, my lord, order of 41 Rule 27, saying that further documents are required to be disclosed without annexing or, my lord, without relying on such documents. When the appeal came up for hearing, my lord, the appellant made a second application. Again, my lord, under order 41, rule 27, saying that documents are required to be disclosed, electricity bill, blah, 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 without annexing those documents. The court below, my lord, has, my lord, passed an order of, my lord, open remand, saying that issues were not framed on adverse possession. Documents are required to be considered, so go back. Everything has to be tried. Subject to correction, my lord, this is the short compass of, my lord, the order under appeal.
No, adverse possession. What was the finding of the trial court? They could establish the commencement date.
No.
Hostile, anything.
No.
So how would the your question is how would the documents make a difference even? Because their possession is admitted. You are admitting their in possession because you're.
I say that they trespassed into. I was not in Calcutta. They trespassed into.
Trespass. So their possession is admitted.
Yes.
So the documents which they now want to produce are relating to their possession only. So they could not make a difference.
So, my lord, what would transpire from those documents?
So the documents were also not disclosed. The nature of the documents were disclosed.
Yes. Electricity bill. Now, I really do not know which electricity bill.
Even if electricity bills are produced,
that
will show
shows possession. That's it.
This appeal will be admitted definitely, but Mr. Mukherjee would never agree to the appeal being disposed of.
We have to support him, Lord, for admission of the appeal.
Obviously. But, Mr. Mukherjee, you are taking undue advantage of the completely erroneous judgment.
But,
will direct paper books to be informal paper books to be
that your lordship
filed within 4
the
weeks and
question here is not all about not whether I can prove my not the
adverse
condition
possession.
of the adverse possession. In that respect, not I wanted to produce document to show that my entry and not subsequent not possession was not adverse to not the original.
You don't disclose the documents in the order for 27.
But I have. In fact, I have given an indication of the document. The
Electricity
question
bills.
My learned friend says that whether Lord, I have to produce Lord, the evidences at the stage of filing an application, or that Lord, the application should disclose about Lord, the documentary evidence that I intend to Lord, produce before the court. Now, Lord, if I have given a sufficient indication of Lord, the documentary evidence that
how would electricity bills make a difference, Mr.
but
Mukherjee?
because Lord, I say, and not only electricity bill, Lord, there are other documents, Lord, also to be produced, Lord, the trade licenses and all.
The point
Those
of
are
commencement, how can you prove by those?
Because, Lord, my uninterrupted possession in the property, which I say, Lord, it culminated into
Open
my
and hostile, that doesn't make
That
a difference. Trial court must have held that it was not also open and hostile.
Trial court did not dwell into that issue, Lord.
Yes, definitely. Definitely.
Because
I
Lord,
shall
that,
show you, Lord.
that
It had
contention
gone
was-
into issues were not required to be framed. The documents were required to be looked
that
into.
is not the
No,
reason why
the
Lord, I have
documents
to
were
take
to
out
be
that
looked into by the appellate court before passing an order, before allowing the order 41 rule 27.
Mr. Mukherjee, those documents never saw the light of day because they have challenged the remand order. So, can we decide the appeal on the not right now? I mean, can we decide the appeal on the basis of the annexures here, or there are some other documents?
So there are other documents.
What sort of others?
The evidence.
Those are not
Evidence is required.
And Lord, your lordship will
It-
kindly come to page 65.
Yes.
Lord, these are not the documents Lord, that I propose not to use.
No,
Page
come
60.
on.
No, appeal will obviously admit. I mean, we are not hearing Mr. Mukherjee on the appeal.
See it.
Electricity bills for
Kindly
the
come to page 65.
yes.
Page 65 or not the indication of the document.
This would not prove the commencement of the adverse person.
Lord, the electricity for the years not 1982 and all.
I'll tell you, Lordship, already. It
And Lord,
was
thereafter the trade licenses are there. Lord, the municipal corporation tax receipt for the year 1980. But the period.
So you are in possession during that period.
Yes, Lord, and whether Lord, I am entitled to a defense of Lord, the adverse possession or not, based on this document. My case was Lord, at one point of time, it was a different case, but now Lord, I try to say, Lord, I have acquired title by adverse possession.
Very well, they will admit the appeal and the usual order will direct you to prepare paper books, informal paper books, without comparing with the records within 4 weeks from arrival of trial court record.
Arrival
of the trial court records. Without trial court records, can you hear it? Can you prepare paper books? Can you prepare certified copies? No, sorry. The evidence is necessary.
certified copies are there. Evidence is also there, my lord.
Evidence is annexed here.
No, it's not
You have
annexed here,
copies.
but certified copy is there. We have, my lord. In fact, it was taken up by the other bench, my lord. We had handed over the
Mr. Mitra, do you have all the copies of the documentary exhibits? I mean,
certified copy.
certified copy of all.
I
So then that we can dispense with the we'll categorically say that they have to annex to the paper book all relevant documents, including documentary and oral evidence, and all the pleadings.
Lord, subject to correction. Lord, if your lordship is with Mr. Mitra, Lord,
Totally with him.
total, yes. Then, Lord, again, Lord, it should go back to the appeal court, Lord, for a decision on merits in the appeal. But it is a appeal
Yes.
of an order of remand.
Do you consent to that? We'll send it to the.
Lord, what I mean to say is that, Lord, that if your lordship is dwelling into the merits of the appeal here, then that will take away my right, Lord, in a second appeal. So, Lord, Mr. Mitra has to, Lord, convince your lordship.
No,
that the
he has
first
to convince
appellate
us
court was
that on the basis of the materials on record, order 41 rule 24 basically. That on the materials on record, 24,
Yes,
25.
yes.
On the materials on record, court could itself.
Whether the appeal court could have not
Should not have
decided,
remanded, yes.
and there was no necessity of a remand.
Yes.
So, Lord, that is the scope of an appeal.
So let us pass that order, admit the appeal, we are disposing of the appeal and directly.
That is, Lord. Because otherwise, Lord, if your lordship goes into the merits of the appeal, and
Appeal court did not go into the merits of the appeal. And they did not. So then, Mr. Mitra, let us agree to that and let us do it right now.
Either it is the appeal court should hear or the trial
Yes,
court should hear.
You are right. You are right. Absolutely right. Either of the two courts should hear it. Appeal court should hear the appeal on merits.
Yes.
Decide the appeal on merit. That is the best order we can pass.
That is, Lord, if your lordship
If he
is,
wins.
yes. And whether there
So
was
let
a-
us pass that order right now. We are admitting the appeal and hearing you and passing that order right now.
Lord, kindly hears me on the next time, Lord. I'll come back, Lord. Whether, Lord, the other thing, Lord, whether, Lord, the necessity of taking the evidence by the appeal court or taking the evidence by the trial court, there are two modes. Either the evidence can be recorded by the trial court, sent to, Lord, the first appellate court.
Yes.
Or the first appellate court, as in this case, Lord, has sent it back, Lord, to the trial court for reframing of the issue.
But it
and
has
for
sent back on
admitting-
open remand.
Yes.
I mean, so whether that was justified, we have to consider that.
That is.
It at best, even if the order 41 rule 27, we can also hold alternatively that order 41 rule 27 did not disclose any German document, which nothing hinges on those documents. If you hold that, then the appeal court order, then also we have to remand to the appeal court.
First
To the
appeal court
appeal
has
court.
to hear on, Lord,
Right,
the
right.
propriety of, Lord, the trial court's order.
Yes, on merits.
Lord. So, Lord,
So
in
come
that
to-
event, Lord,
We are dispensing with the trial court records, Mr. Mukherjee.
I beseech your lordship, do not, Lord, opine on the merits of the matter, Lord. Otherwise, I'll be
No. That will work. If you agree to that order, we can pass it right now.
Lord.
Because first of all, the appeal court. No, we have to decide on whether the order 41 rule 27s were allowed correctly. We have to decide on that. We are not going into the merit. We may say.
Lord, let us, Lord, just try to assist your lordship. In the event your lordship holds that order 41 rule 27 that was
Could have
allowed
been-
by the was not a
Would not
proper
make any
allowance.
difference. Yes. So
Then again, Lord, the first appeal court has to decide.
yes.
Without those.
Without
Without
those
those.
additional
Without those
documents, then
additional.
the question of demand doesn't come. And if, Lord, your lordship is of the opinion that those documents are necessary for not proving my client's case of adverse possession,
Then we don't
then
interfere.
the question comes whether it should be before the trial court.
That
or
would be a
before
very limited question. We may not interfere also then.
the Lord.
So we have seen what documents you are seeking to produce.
Lord.
So we are not impressed that those are German documents for proving adverse person.
That I'll try to, Lord, address your
So
lordship.
we are dispensing with the trial court records and we are directing them to prepare informal paperwork. So that the short conspectus of the present appeal, comma, which has been preferred against a remand order, comma, is whether the learned appellate judge was justified in allowing the applications of the defendant stroke respondent, defendant number 2 stroke respondent within bracket appellant before the first appellate court, bracket closed, under order 41 rule 27 of the Code of Civil Procedure, in view of those apparently seeking to furnish documents as additional evidence which are not germane for the adjudication of the case of adverse possession made out by the defendants. Full stop, next para. In view of the limited conspectus of the appeal, comma, we are of the opinion that the trial court records may be dispensed with and accordingly direct such dispensation. Full stop. The appellants shall prepare and file the requisite number of informal paper books without comparing with the records, comma, incorporating therein all relevant documents, including the pleadings of both parties, comma, the memorandum of appeal in the first appellate court, comma, as well as the evidence, comma, both documentary and oral, within 4 weeks from date. Full stop. Next para. Advance copies of the paper book, an advance copy of the paper book shall be served on the defendant number 2 stroke respondent. Full stop. Service of notice of the appeal on the other respondents is dispensed with. Full stop. Next para. You have made an application for stay also. Can 1 of 2024 is that application?
Yes, ma'am.
Can 1 of 2024 is allowed on contest, comma, thereby granting stay of all further proceedings in the suit after remand till disposal of the appeal. Full stop. The appeal shall be listed for hearing in the monthly list of April 2025.
Lord. There is another prayer, my lord, that restraining them from dealing with the property in the meantime.
Then, my lord, kindly pass a degree that I have, Lord, acquired title by Lord adverse possession.
Why? Parting with possession.
No.
Parting with possession, yes.
But they have, Lord,
Well, dealing with
this application also
Your
prays for that.
Yes, there is
kindly
not a, Lord, I do not find any
Page 14.
averment at all, Lord, in apprehension that, Lord, I am dealing with the property.
Page 14, my lord, kindly come to the last part.
No supportive, Lord, the paragraphs, Lord, why they are asking for this.
You have not alleged that they are trying to part with possession anywhere. Only the grounds of the appeal has been reiterated. Mr. Mittu, if you are saying they won't create any third party rights, sir, then you are admitting the title.
No.
Dealing with
Dealing with, my lord,
generally
dealing with does not always mean
does
my
not
lord,
always
selling.
No.
Or my lord,
Very well. The respondent number 2 shall also remain restrained from parting with possession or dealing with the suit property in any manner in favor of third parties till disposal of the appeal.
the defendant number 2, respondent number 2.
This defendant number 2 stroke respondent number. Yes. It should have gone before the family court. Yes.
So I'm appealing for the appellant plaintiff.
Right.
My lord, this is a case relating to the
Is there any caveat in the matter?
No, there is no caveat. My
Yes.
lord, refusal of the order of injunction.
Ad interim or temporary?
And finally decided, and thereafter, my lord, the injunction application has been refused. My lord, the first appellate court, my lord, they are stating that we have, my lord, the annexing all the documents.
No. There was you preferred a misappeal?
Misappeal. My lord, that there is no judgment and degree has not been drawn up. My lord, the report, my lord, the defect.
One second. Misappeal against temporary injunction refusal.
Refusal, my both the court below. Finally decided by the first appellate court, my trial court. Thereafter, they have preferred an appeal before the my lord, district judge.
Suit is still pending.
Suit is still pending.
The norms for the second miscellaneous appeal that does not lie. You have to file a division.
I have no scope for my lord.
Order 43, no, order 43.
Rule 1 IR, they have been classified.
Order 43 and section 104 debars you from preferring a second appeal against the misappeal order. There is no second appeal. You have to prefer a second revision application.
Second, not appeal, one revision application, that is the appeal.
If an order is passed under order 43, that order is not further appealable.
One is stands final.
That is a law.
That is all.
The present appeal has been preferred against an order passed in miscellaneous appeal against an order of refusal of temporary injunction by the learned trial judge. Full stop. In view of the bar under section 104 as well as order 43 of the Code of Civil Procedure, comma, no further appeal lies against an order passed in a miscellaneous appeal under Order 43 of the Code of Civil Procedure. Full stop. Accordingly, FMAT 499 of 2024 and the connected application bearing CAN 1 of 2024 are dismissed as not maintainable, with liberty to the appellant to approach the appropriate forum with a properly constituted challenge against the impugned order. Full stop. Leave is granted to the learned advocate on record for the appellant to take back the certified copy of the impugned order upon replacing the same with a photocopy of the same, with a photocopy thereof for the records.
I appear for that.
Yes. Charte volume. Yes.
I believe, my lord, this is a very unique case. But when I say unique, my lord,
Mr. Mittal, please take a seat.
Lord,
You are for the respondent. Yes.
Respondent plaintiff.
Respondent number one.
Respondent number one,
Respondent.
plaintiff. My lord, I am different. My lord, it's a case, my lord. Why I say, my lord, a peculiar case. My lord,
What case? I'm sorry.
peculiar case.
Peculiar.
Peculiar case, my lord, I say because,
Yes.
Lord, an order of injunction restraining all the defendants in the suit have been passed by the London trial court. And my lord, for the first time in my short little career, my lord, I have seen that these many caveats have been filed by the defendants against whom orders have been passed. So, my lord, possibly, my lord,
Defendants filed caveats who have been restrained.
who have been restrained.
Anyway.
So, my lord, possibly, my lord, I don't need better example to cite, my lord, of the suit being a collusive suit between the plaintiff and other supporters.
What is the suit for?
The suit, my lord. Before, my lord, I trouble your lordship as to what the suit is, my lord. If I may, my lord, briefly narrate the facts, my lord. But I prepared a short.
No, just give us a background. I mean, what is the suit for?
Suit, my lord, is being filed by my learned senior friend's client, my lord.
For?
For seeking delivery up and cancellation of a registered deed of partition and settlement. Saying, my lord, that he was a major at the then point of time in the year 2008.
He was a major or a minor?
He was a major.
Uh-huh.
But he's shown as minor. Says he was a major, he's shown as a minor. And my lord,
He was represented by someone else.
His father. His father.
So he was not a signatory there.
He is not a signatory himself. He says, and my lord, the act of his father representing him, my lord, is considered, is my lord claimed to be an act of fraud by me and by his own father. That's the, my lord, allegation of fraud. And hence, my lord,
all the other parties were signatories there.
My lord, barring one or two, my lord, all of them are signatories, my lord. So, my lord, that is one of the.
So they sought for an injunction.
They sought.
What is the nature of the injunction?
Injunction, if my lord, injunction restraining me, my lord, from relying on that document.
Not only you, all the defendants, as you said.
All the defendants.
From relying on the document.
On the documents and taking it from the custody of the registering authority. Because the document is still lying with the registering authority.
It has not. The registration has not yet been completed.
Registration. Yes, yes. It's prayer. Prayer is there, my lord. My lord.
It has been registered, but it has not been taken by you.
Yes, because my lord, one of the respondents was in possession of the original IGR.
No, ad interim has been granted or temporary injunction?
Final. Allowed.
Injunction application has been allowed.
Application disposed of.
Very yes. Then now you say what you were saying.
Yes. My lord, then my lord, may I just hand over a brief list of dates, my lord?
Just give a copy to them also.
Yes, yes, definitely. If my lord, kindly takes, my lord, I am Pradeep Kumar Ganeriwala, my lord.
Yes.
I am the eldest son of Vishwanath Ganeriwala. My lord, in between the year 1950s and 1994, my lord, my father purchased, acquired, or my lord, created interest in numerous properties, both movable and immovable. My lord, in the year 1986, my lord will kindly mark this. My father participated in an auction conducted by this honorable court, my lord, with regard to property of the then Sanchayata, my lord, investment, my lord. Property, my lord, at Mumbai, Juhu. My lord, and I was, my lord, announced as a successful and highest bidder, my lord.
The father.
Not you, the father.
The father, my father.
if Lordship takes third entry of my first page, 8th of August 1986, my Lord. This Honorable Court, my Lord, by an order of 8th of August 1986, my Lord, confirms the sale in favor of my father, my Lord, Vishwanath Ganeriwala. And my Lord, my father executed a will in the year 1994, 15th of January 1994. My Lord, under the will, my Lord, save and except 2 petrol pumps, my Lord, which he owned, my Lord, one in Raniganj and one at Asansol, my Lord. He bequeathed all his property, my Lord, unto and in favor of the then HUM, which was known as Vishwanath Ganeriwala HUM. That was the scope of the will.
So that was in line with the tested succession, intestate succession.
Yes.
What was the necessity of the will anyway? It was.
My Lord,
Anyway,
my
it
father
was.
did, my Lord, I cannot see, but then that was the will. 1994, my father died of it.
Right.
3rd August, if Lordship kindly turns.
You said testate. Yes, testate.
Because
Okay.
there was a will.
Oh, the will. Yes.
My Lord, after the demise of my father, my Lord, I became the Karta, being the eldest sibling. And that was, my Lord, my Lord, desire of my father also, which was recorded in the will, that, my Lord, I shall become the Karta of the HUF
All right.
of my father. Then, my Lord, between the year 1994, Lordship will kindly mark this. This is very important. Between the year 1994 to 2010, my Lord, after my father passed away in 2010, the spouse, my Lord, that is my mother, and myself and my brothers, entered into numerous agreements and understandings, my Lord, with regard to properties. My Lord, by which, my Lord, we decided, my Lord, to partition, allocate, distribute numerous properties left behind by father. And, my Lord, numerous conveyances have also been.
All these were between yourselves.
Between the
in between the family.
In between the family.
In between the family,
In between the family, my Lord, in between the brothers and mother.
There were sisters also.
There were 2 sisters.
And
Till
the
that time.
grandson.
Pardon?
And the grandchildren.
Grandchildren of where?
They were not there.
Yes, please.
Then, my Lord, in the year 1997, the will, the probate of the will was granted. Now, my Lord, on 18th of August 1998, the respondent numbers 2 to 6, my Lord, that is, my Lord, my mother and my other 4 brothers.
Mother is respondent number 1.
Respondent number 1 is my nephew.
Sorry.
He is my nephew.
Yes, yes.
Respondent number 2 is my mother.
Right.
And 3 to 6, my Lord, are my brothers. My Lord, they affirm an affidavit. My Lord, by which, my Lord, they give a consent to mutate the Mumbai property in my favor. My Lord, I have just, my Lord, for Lordship's convenience, I mentioned the page number also where all these affidavits.
Thank you. Yes.
My Lord will kindly mark the next entry, March 1, 1999. This is very important because, my Lord, one of the allegations made by the respondent number 1, my Lord, is that I perpetrated fraud before this honorable court. My Lord, when I, my Lord, made a submission before this honorable court way back in the year 1999, my Lord, that Vishwanath Ganeriwala HUF has been converted into.
So we are telling you this. I mean, this is against an interim injunction. If you grant stay, that would tantamount to allowing the appeal at this stage. We cannot grant stay. We will hear the appeal and along with the application.
My Lord will see the nature of order which has been passed. Drastic order. It couldn't have been, my Lord. And not just that, my Lord, I will show.
But if that injunction order is lifted now, that will amount to allowing the appeal before hearing it on merits.
My Lord will kindly.
Because then you will deal with the properties.
My Lord, I can. My Lord, I will satisfy.
At this stage, because whatever you are arguing, virtually a full-fledged hearing of the appeal will be akin to hearing the application.
My
So
Lord
we'll hear out both together on the papers which are already on record.
Lordship, I will just show your Lordships, my Lord, the prayer which was there in the plain and how the learned trial court has passed the order. My Lord, Lordship will kindly pardon me for using the term, my Lord, the learned trial court has gone haywire. My Lord will kindly see what are the reliefs which the plaintiff had asked for.
Everything is there.
Yes.
My Lord, before that, my Lord, may I file my affidavit of service, my Lord?
All have been served.
My Lord, the persons who have filed caveats, my Lord.
Oh.
Because there were caveats filed by a number of. So
then in any event, the others have to be served. Yes.
My Lord,
where is the prayer? Plain prayer?
My Lord, the plain starts at page 63, first volume. Sorry, my Lord. Plains.
67.
67, sorry, my Lord. 67. Prayer is at page 82, my Lord.
82. Yes.
82, my Lord.
Yes.
My Lord will kindly see what is the prayer.
Yes.
a decree of declaration that the said purported deed of partition and settlement dated so and so, a copy whereof is annexed hereto and marked F is void or voidable and be directed to be delivered. My lord, so this is the really what he's seeking. Prayer B, my lord. A decree for declaration. My lord, lordship will kindly permit me to place these two documents, my lord. I will place these two documents to demonstrate whether any of the properties over which injunction has been granted, whether those properties form part of the deed. I will show that. Thereafter, my lord, I leave it to your lordship. A decree for declaration that the purported deed of declaration dated 1st of June 2009, a copy whereof is annexed hereto and marked G, is void or voidable. My lord will kindly mark this. Lord, this deed has not been executed within the jurisdiction of the learned court. This declaration. Declaration has been executed.
But the properties covered by it are within the jurisdiction of this court.
Mumbai. The property, the only subject matter.
But even if it is part barred, I mean,
no,
it
my lord,
cannot
this
be
is
rejected.
completely barred. This declaration is completely barred.
Even if the suit is part barred, we cannot reject the plaint at this stage.
No, my lord, I am not even for a moment asking your lordships to reject the plaint. My lord, that is
At
not
least
my
regarding
state.
that property, injunction could not have been granted. That is what.
My lord, I am saying in respect of none of the properties, because the properties which are described, the plaintiff has been very selective. My lord, he only chooses 3 properties, my lord, over which he wants control to be injuncted. He does not, my lord.
Does not choose the Mumbai property.
No, he does. Mumbai property, bank accounts which are not within the jurisdiction of the learned court, and demat accounts which are not within the jurisdiction of the learned court. Only these 3 properties, nothing else.
Oh, all the properties regarding which?
No, I will show that. I will show that, my lord. I will show that. Then perpetual injunction restraining the defendants, and particularly the defendant number 2 assigns relying on and taking any steps on the basis of purported deed of partition and settlement dated so and so. And my lord, one more submission, my lord. This prayer, what my learned friend's client has been asking, my lord, is in teeth of an order passed by this honorable court. I will show that as well. Lord, prayer D. Permanent injunction against the defendants and each of them restraining them from circulating and relying or disclosing the said deed of purported deed of partition and settlement before any court of law, my lord, in violation of section 28 of Contract Act. My lord, I cannot rely before court of law. My lord, in fact, my lord, to be honest, my lord, I cannot even rely upon this before your lordships also.
Specific relief act.
Yeah. No, Indian Contract Act as well, section 28.
Relief act also, because anyway, section 28 Contract Act.
Contract Act, yes, my lord.
Contract Act din to?
My lord, permanent
Contract
injunction.
Act specific relief act, dutoi din.
Prayer E, my lord.
Yes.
Permanent injunction against the defendants and each of them from recovering and or trying to recover. My lord, I just made submission. My learned senior friend said whether they've asked for such a relief or not. Trying to recover the said purported deed of partition and said so and so from the office of additional district sub registrar.
Injunction is changing.
So, my lord, these are the reliefs.
Thank
you. Now, my lord will kindly see the
specific relief act to them.
My lord will kindly see what are the properties. Same page, page 84. My lord. My lord will kindly see Schedule A.
Yes.
Schedule A is property at Mumbai outside the jurisdiction of the learned court. My lord will kindly turn over Schedule B, page 85. All bank accounts. Now, my lord will kindly see bank accounts maintained and operated in the name of Vishwanath Ganeriwala HUF bearing PAN number so and so, and in the name of executors of Vishwanath Ganeriwala. My lord, if my learned friend's client is seeking a restraint order in respect of a deed, claiming that that deed has been obtained, my lord, by fraud, or is a product of fraud, my lord, how such a prayer or relief can be granted, my lord? Because Vishwanath Ganeriwala, my lord, in my respectful submission, existence or non-existence of Vishwanath Ganeriwala is not at all an issue before the learned court.
No, fraud was that he was a major, he was shown as a minor. If one of the parties was a major and shown as a minor, somebody else is not a signatory, then the entire partition, because he has shared over every inch of the property. So the partition deed fails.
Partition deed fails.
Cannot be a partial partition.
My lord, partition deed, in my respectful submission, partition deed can only fail as regards, at best, in my respectful submission, at best, as regards he is concerned. My lord, other signatories, my lord, will they be allowed to go scot-free? My lord, who? My lord, they have not challenged.
No, there cannot be a partial partition.
There cannot be a partial partition. But my lord, at least I can enforce that deed of partition against all other signatories to the...
No, if the partition is bad in law, how can you enforce it at all against anybody? It's not a question of selective enforcement.
My lord.
Because it's a partition. Everybody has share over every inch.
Then,
If
my
it
lord,
goes as a whole.
then if it goes as a whole, then everything has to come back to the common hodgepodge.
HUF.
Each and every property,
Yes.
including the properties which has gone to them.
Yes.
So, my lord, I put a question to myself. Where are those reliefs? My lord, lordship sees how selective he has been. And my lord, I have to demonstrate. And in fact, that is for my learned senior friend, my lord.
The deed of partition allots particular portions to particular people.
Yes, my lord.
That goes, everybody has right over every portion then.
So then my lord has to see whether the properties which has been described in schedule A, B, and C forms part of the deed of partition.
Yeah, definitely.
I will show that whether it is there. My lord, that is what has to be seen.
Yes.
So, my lord, right now what I am trying to demonstrate, my lord, that none of these properties are described in the deed of partition. My lord,
What
first,
does the deed of partition say? Generally, that all the properties.
No, my lord. There are
all properties of the HUF.
My lord, no, my lord. There are division. There are
There's a schedule to the deed.
There are schedules. And in none of the schedules, any of these properties are there.
Show us
I will show. That I will show.
Yes.
Sir, may I just point out? Lord, I am.
You are appearing for?
Defendant number 18. Even I was a major but shown as a minor. And there are other instances, my lord, within my lord, the
You are supporting him.
No, I'm not at all supporting.
Nobody.
I'm opposing. But your lordship pointed out that my lord, the plaintiff was the major but shown as a minor. The plaintiff is not the only person. There are others, including me.
Two wrongs do not make a right.
No, my lord.
Two wrongs do not make a right.
Of course not.
You were also represented by someone who did not have the authority then.
My lord, I'm opposing the appeal.
Your choice.
I'm opposing the appeal.
But you are relying on a wrong.
No, but I'm not. I have suffered.
Unless you are a party to that, just because you suffer and don't challenge, that does not mean anybody else who suffers will not challenge. You don't, that does not confer, take away anything from him.
The person who's challenging.
I am suffering from a disease. So my fellow roommate is also suffering from a disease. I go to a doctor, he does not. Does not mean that because I don't go, he cannot go.
No, I'm agreeing with your lordship. Lord,
Then
I'm exactly.
why did you lodge a caveat?
No, Lord, because I'm opposing this appeal. I'm supporting the plaintiff. I'm a defendant, and I've independently also.
You are magnanimous.
In a different proceeding, my lord,
You are magnanimous. You don't have a right of hearing on. I mean, suppose you are a major. You are represented by somebody who was somebody else, your next friend. The deed is also bad in your respect, whether you like it or not, whether you challenge it or not.
Yes, it is bad. I'm saying it's a bad deed, and I've said so.
So you are opposing the appeal on what ground?
Lord, because they are saying that the deed is good. The appellant is saying that the deed is good. I'm saying that the deed is bad. Mr. Jain today is saying that the deed is good. I'm just pointing out, my lord, I'm against Mr. Jain here. And I have also taken this stance in a different proceeding, saying that the deed is bad. I was shocked to see the deed. How could I have, my lord, been shown as a minor there when I was a major?
All right.
That's what I'm clarifying. Since it fell in your lordship's, my lord.
But the defendant is supporting the plaintiff on that count.
Yes.
Very well.
Yes.
Sorry.
I just wanted to clarify, my lord,
Right.
that there are more of us who are majors.
This is on his submission that he was surprised why you lodged caveat.
Yes.
Very well. Get your point.
I hope, my lord.
Clear.
Great.
Yes, please continue.
Yes. So, my lord,
was that these are not part of the deeds.
The deed of partition. I will just
challenge the declaration and settlement.
I will just trouble your lordship with Schedule C as well, my lord, just to demonstrate, my lord, that none of the properties were within. Schedule C, my lord, is all demat accounts opened from the corpus of, my lord, it does not say of Vishwanath Ganeri. It says from the corpus of Vishwanath Ganeriwala, bearing number so and so, and or shares in the name of Vishwanath Ganeriwala. It does not talk of Vishwanath Ganeriwala HUF, my lord. Since deceased, transferred by such account, and also demat accounts opened in the name of named executors of the Vishwanath Ganeriwala since deceased, Pradeep Kumar Ganeriwala and Deepak Kumar Ganeriwala.
Joint family nucleus. But then they rely on joint family nucleus. That's the difficulty. When they say it's open from the corpus of Vishwanath Ganeri, that has to be decided in the suit.
It has to be in what suit? And what is the prayer, my lord? My lord, lordship has seen what was the relief. And my lord, these demats account are held with one, my lord, Baljeet Securities, my lord, though the address is not mentioned. The address is at Pretoria Street, which, my lord, again is outside the jurisdiction of the learned Alimony court, my lord. So all these properties, lordship, possibly have been able to demonstrate. These are the only three schedules. Lordship will see how selective he has been, the plaintiff, that he is only concerned with these three properties, no other properties. Now, if my lord kindly turns to.
Now, how do you affect it then if this is granted? I mean, let us come to prayer C. We suppose the temporary injunction application is also in line with C or D also.
It is not, my lord. My lord, what the learned judge has done.
What is the where is the
Here-
temporary injunction prayer?
Temporary injunction prayer, my lord, is at page 60. 62, my lord. 62.
There is a pending partition suit also.
Yes, my lord.
Who filed that?
My lord, the respondent
One of
number
them.
five. Respondent number 5. He files a suit saying that there never ever has been a partition.
Yes, on the premise of I mean that is dependent on the result of this also.
No, my lord, my lord, what I do my lord, when I come to know of the partition suit, my lord, I file a order 7 rule 11.
Hmm.
My lord, and my lord, there I also take a point, my lord, there has been a partition effected between the parties which was kept pending. My lord, when I take that point, my lord, then my lord, the plaintiff in that suit, he files an order 6 rule 70, saying that no, there was a partition deed, but that was given a go back. Why? And that is why, my lord, we did not take steps to put in.
Let us come to page 62 once.
Yes, my lord.
63 rather.
Yes, my lord.
That there are two parts of this injunction. One is that from relying upon the purported deed of partition and settlement dated such and such,
yes,
and deed of declaration.
Yes, my lord.
Now, regarding this, your first argument is not applicable because that restricts itself to those deeds only. Next part of the injunction may be what you are arguing, and or parting with possession or in any way encumbering or removing and or disposing of Schedule ABC, where they speak about these schedules. So the first portion, I don't think you have a point, because if these schedules are beyond those deeds, then your first argument is not applicable. That I mean, they are going beyond the schedule and seeking for injunction. Even if the first portion of the injunction is maintained, you cannot have any objection to that, because it's sub judice in the suit as to whether these deeds are valid or not.
Then lordships will see whether the learned court had the territorial jurisdiction to decide that. This
The
deed
deeds
of
were
declaration-
executed within the territory of
only deed of partition, not deed of declaration. And he is not a signatory. The
even
person
if the
who-
deed of declaration was within this jurisdiction.
Yeah.
Some of the properties must be within Calcutta jurisdiction also. Alipur
that is
jurisdiction.
in the deed of partition.
Settlement rather.
Yes, yes. But
Partition.
that is none of the properties are part of the schedule. My learned friend.
Yes, yes. We are coming to that second. The second part, let us be satisfied that these are not part of the either of the deeds.
Now, if I may trouble your lordship with the deed of declaration, my lord. If lordship kindly take second volume. Second volume,
Yes.
first page, my lord. That is the deed of declaration over which, and lordship will kindly permit me to place the entirety of the deed of declaration.
Which page?
Page 116, my lord. Second volume, first page, my lord. Second volume. Lordship, sir.
Yes.
Deed of declaration, my lord.
Yes.
In the matter of auction sale of 8th August 1986, filed by Sancheta Commissioner Mr. So-and-so relating to Bangalore at premises number R154 Juhu Tara Road, Mumbai, 4 lakh so-and-so, and acceptance of bid to purchase the same by Vishwanath Ganeriwala HUF, represented by its Karta Vishwanath Ganeriwala.
Yes.
If lordship kindly turns over to page 171, my lord.
Hmm.
Then in the matter of sale, sorry, my lord.
Yes.
In the matter of sale certificate issued by so-and-so, Commissioner of Sancheta Investment, certifying the sale of said premises in favor of Vishwanath Ganeriwala HUF, and in the matter of premises number so-and-so. Now, my lord, can you see who are the ones who are affirming this declaration? We, Savitri Devi Ganeriwala, my mother. Pradeep Kumar Ganeriwala, myself.
Hmm.
Deepak Kumar Ganeriwala, my brother. Dilip Kumar Ganeriwala, my lord, the father of my learned senior friend's client. My lord. Manoj Kumar Ganeriwala, my lord, he is the plaintiff in the partition suit, my lord. And Rajiv Kumar Ganeriwala. Do hereby declare, confirm, and state as follows. It is accepted and confirmed that the said declarants, so-and-so, 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 are making this declaration for self. My lord will kindly mark this. For self and as Karta of their respective HUF, consisted of co-partners and members, being of them wives, sons, and daughters. Then if my lord may skip page 172, 173, my lord, that's a recital. If lordship kindly straight away now turns to page 174, my lord.
Hmm.
That's internal page 5, my lord.
Hmm.
We, the said, first paragraph, my lord. We, the said Savitri Devi Ganeriwala, so-and-so, so-and-so, in connection with the said application being GA number so-and-so and WP number so-and-so, did also confirm, my lord will kindly mark this, did also confirm by our joint affidavits duly affirmed on 18th of August 1998 and duly filed in connection with the said application. Now, that affidavit was filed before this honorable court. Had expressed having no objection to the mutation of the name of only, my lord will kindly mark, only Pradeep Kumar Ganeriwala HUF as being absolutely entitled to the said property. Then thereafter, my lord, para 6, very important, my lord. We do hereby confirm, accept, agree, declare, and ratify that we had not and we do not have any objection to the mutation of the name of only Pradeep Kumar Ganeriwala HUF being records in the various offices under the Collector of Mumbai, Mumbai Municipal Records, and also the records of City Survey Office and other concerned records. My lord will kindly mark this as being the absolute owner. My lord will kindly mark this as being the absolute owner of the said property with khas possession of the said property having been heritable, transferable title, and all kinds of right, title, and interest to the exclusion of, my lord will kindly mark this as well, to the exclusion of Srimati Savitri Devi Ganeriwala, Deepak Kumar Ganeriwala, Dilip Kumar Ganeriwala, Manoj Kumar Ganeriwala, and Rajiv Kumar Ganeriwala, who have already disclaimed, renunciated, and released their right, title, and interest, if any, in the said property to be held and owned absolutely by Pradeep Kumar Ganeriwala HUF, free from all their claims, rights, and disputes, and also free from all encumbrances created or suffered by others. Now, my lord, next paragraph. We are making this affidavit without any kind of influence by anybody and with full knowledge of the fact that the said Pradeep Kumar Ganeriwala HUF, my lord will kindly mark this, the owner of the property is Pradeep Kumar Ganeriwala HUF and not Pradeep Kumar Ganeriwala. Is and shall.
But this deed is also challenged.
This is the declaration what they are challenging.
Yes.
What is challenged? This is challenged.
Right.
Is and shall be exclusive owner of the said property at R154 Juhu Tara Road, Mumbai, so and so, and that none of them, my lord will kindly mark this, and none of the said Srimati so and so, so and so, so and so.
But it's qualified. HUF without these people, they are also part of the HUF.
Hello.
So then it's not, you are relying on this only Pradeep Kumar Ganeriwala HUF, but minus these people. So it's not entirely Pradeep Kumar, the entire HUF.
It is
You're dismissing some of the people.
No, so my HUF, Pradeep Kumar Ganeriwala HUF
Oh, you're
is
right.
the owner.
Oh, right.
That is my HUF, my lord.
Oh, achha.
That is the owner.
Achha.
My lord, my father's was Vishwanath Ganeriwala.
Right, right, right. Sorry.
Sorry, ma'am.
Yes.
Or his HUF, Manoj Kumar Ganeriwala or his HUF, Rajiv Kumar Ganeriwala or his HUF had and or shall have any claim, right, title, or interest whatsoever, and will also not have.
But these people, Savitri, Deepak, and all, they were not signatories here.
They are.
They are also
They are all
signatories.
signatories. They have signed. Lordship will kindly turn to page 175. And this affidavit is affirmed before the Metropolitan Magistrate within the jurisdiction of this honorable court.
And Dilip was this, the predecessor of the plaintiff.
Father.
Plaintiff's father.
Plaintiff's father.
He is number 4.
He is number 4, my lord.
They are not challenging the signatures.
No. My lord, if they want to challenge, they have to come by way of independent suit, my lord.
No, in this suit,
No.
they are not challenging these documents on the ground of signatures.
The
They are saying only on the majority ground, the majority minority.
That is majority by my learned senior friend's client, because he is the plaintiff there. And Lordship will kindly see where it is affirmed before whom. Affirmed before Metropolitan Magistrate, signed at 6 Old Post Office Street. So, my lord, this document, subject to correction, my lord, the learned Alipur court, my lord, does not have jurisdiction, my lord, to declare this document as void.
Signed at 6 Old Post Office Street.
Achha, very well.
Now, my lord. Then, my lord, page 179.
And what about the properties? Properties
now, my lord,
do not include any all Juhu.
No.
Calcutta properties are also there.
The suit is only about Juhu. Calcutta. Now, my lord, I will.
In this, Calcutta properties are also covered.
No. This affidavit, this declaration is only for Juhu.
Yes, we are asking that only.
Yes.
That this declaration is only taken.
Only for Juhu. But why it was required, my lord? Because, my lord, the registering authority, my lord, they were not registering property in my name. My lord, despite order of by the order passed by this honorable court, my lord. I'll trouble your lordship with those orders as well, my lord. So, my lord, that is why, my lord, this affidavit came to be my lord. This declaration came to be affirmed, my lord.
All
now,
right.
my lord, the deed of partition, my lord, which is the my lord, which is the fulcrum of all the dispute, my lord.
Yes.
It starts at page 183, my lord, 184 in fact. At page 184, my lord.
184, yes.
My lord, first party is my mother. Deed of partition, lordship will kindly mark the date 2nd of December 2008. My lord, this 2nd December 2008, my lord.
Right. 2008,
Now,
yes.
Now, my lord, page 186, lordship will see my name. My lord, I represent myself as for self and as Karta of HUF governed by Mitakshara School of Hindu Law, consisting of himself and his two sons, namely so and so, so and so. My lord, Deepak Kumar Ganiriwala, Dilip Kumar Ganiriwala, my lord, my brothers. And page 188, my other two brothers, my lord, page 188. And then, my lord, rest of the family members. My lord will see number 8 at page 188. At page 188, my lord, number 8. Master Rohan Ganiriwala, son of so and so, a Hindu minor, represent. Lordship will kindly see, my lord, who represented him?
Father.
Hindu, by father Dilip Kumar Ganiriwala. His father represented him.
But he also has the right if he is a major.
He says, my lord.
His right could not be relinquished.
May not have been. Now, my lord, if my lord kindly turns over to page 192.
Yes, 192.
My lord, if lordship kindly skips 10 lines from the top, by a registered deed of conveyance, my lord, lordship skips 1, 2, 3.
Yes.
By a registered deed of conveyance dated 18 September 1956, executed by and between the Hind Bank Limited, therein referred to as a vendor of one part, and Srimati Anuparna Devi Ganiriwala. She was my grandmother. And of one part, and and Savitri Devi Ganiriwala, my lord, my mother. Jointly referred to as purchasers of the other part, the said vendor had sold, transferred, and conveyed all that the present Kolkata municipal premises number 3 India Exchange Place, Kolkata, so and so hereinafter referred to for the sake of brevity the said premises, and the said deed of conveyance was duly registered. So this property, though my lord was purchased by my father, it was purchased in the name of his mother and my lord, his wife, spouse. My lord, that is my mother, my lord. My lord, that is why, my lord, this formed part of this partition deed. My lord, and my lord, under numerous family settlement, my lord, this property has gone to my brothers. It has not come to me, and they have not challenged that, and that has not come back to my lord to the so-called HUF. Now, my lord, if lordship takes last entry of this page at page 192, last entry, all that unit number 09 measuring a super built-up area of 617 point so and so be the similar same a little more or less lying and situated on the 3rd floor of building at 230 AJC Bose Road, Kolkata. Lordship may ask me what is the fate of this property. This property has been transferred to all the 5 brothers pursuant to this deed in proportion.
You have filed a written statement and
I have filed my written statement. Yes, my lord.
In this suit.
Yes, yes. I have filed my written statement, written objection filed, my lord.
And you have taken this point that this has been transferred already. Transferred by whom to whom?
No, my lord, originally my father, he had acquired interest in this property.
Right.
So, my lord.
So this is one of the Calcutta properties.
This is one of the Calcutta properties.
Although Alipur Court does not have jurisdiction regarding this also.
Alipur Court may have jurisdiction, my lord. I am not
AJC Bose Road?
AJC Bose Road
does.
Possibly, maybe, my lord. Possibly. So, but my lord, this property has been transferred. My lord, because this deed records...
That will be decided in the suit.
No,
but we cannot go on territorial jurisdiction on this part.
No, territorial jurisdiction with regard to the properties mentioned in the schedule.
No, it cannot be segregated like that. Suppose one deed, obviously, one deed covers both Bombay properties and...
The learned court has jurisdiction to deal with this deed. I am not even for a moment
saying
that the court does not have jurisdiction.
Again, the deed of declaration.
Deed of declaration it doesn't have jurisdiction over the properties which are described in the schedule.
And Juhu property and the bank account
and demat account.
But Juhu property has been included in the declaration.
Yes.
Regarding which this court does not have jurisdiction.
That court does not have jurisdiction.
I mean, Alipur court does not have jurisdiction.
Your lordships have. City civil court has.
All right. Because it was executed beyond Alipur and the property is in Mumbai. So either way.
Either way, that court does not have jurisdiction. My lord, I would say that learned Alipur court does not have jurisdiction in respect of any of the properties. None.
Why do you say that?
All the bank accounts are outside.
But regarding that deed of declaration?
No, not deed of declaration. Scheduled properties, A, B, C. There are 3 properties there. There are only 3 properties, my lord, in the plaint.
Why do you say that about the bank accounts?
Because all bank accounts are within the Honorable Calcutta High Court jurisdiction. MG Road.
Oh, Alipur Court does not have.
Alipur Court doesn't have jurisdiction. Demat account at Pretoria Street. Alipur court doesn't have jurisdiction.
All right.
That court doesn't have jurisdiction. Now, my lord, C at page 194. Third proper.
Yes, C.
All that Kolkata municipal premises number 16B Roland Road. My lord, this is the property, my lord, where all of us are staying, my lord. My lord, these parties are in possession of their respective allocation, my lord, as has been decided and demarcated in this deed, my lord. Ever since, my lord, execution of this deed. And property has been mutated in respect, in the name of respective parties, my lord. Though joint mutation, but only it is mutated in name of 6 persons. It is not, it has never ever been in the name of Vishwanath Gandhiriwala. It is presently lying, my lord, in the name of 6 brothers, 5 brothers.
So you say the mutation has been in line with this
deed of partition. And parties have been enjoying their respective properties.
But plaintiff was not a party to the mutation also. He did not mutate.
Not to the mutation.
So a chain is as strong as the weakest link. That is a difficulty in your case.
My lord, whether
even if there's one major person was represented by somebody else,
my lord, it is not.
they can take advantage of it. And
not a case.
there are others also who are also.
My lord, it is in my respectful submission, my lord, it is not a case where a minor was shown as a major and his properties was.
So that is a different. That is on a different footing altogether. But this is a case where the major, I mean, non-implement of the major at all.
My lord, the agreement executed.
I mean, you have to you have to implement in a partition deed. You have to join in all the co-owners.
My lord, I have not gone for partition. This partition, this
the
partition.
Settlement, yes.
My lord, I went by not just me, my lord. All the parties.
Relying on this deed.
My lord,
they are disputing.
My lord, we all went on and executed this deed on the basis of representation made by my lord respective person, my lord. Fraud, if at all, my lord.
Even if not fraud, deliberate fraud or fraud ingredients cannot be found, but this is bad in law also. Otherwise, because in absence of all the co-owners, I mean, you cannot all the co-personers actually. Co-personers, it is a bad document in law, so they can get an injunction. Otherwise, regarding the deed of settlement, barring the territorial jurisdiction point, we'll come to that later.
My lord, I'll demonstrate that, my lord. Because why I'm showing all these things, my lord?
Yes, why?
That parties.
Why are you showing the deed of settlement? Because you don't have the territorial point.
No, because my lord, because the parties have acted upon this deed.
That will be decided in the suit.
Properties have been distributed. My lord, it can, my lord,
the parties who are parties to this document, they have acted on this deed, but for the plaintiff and maybe some of the other defendants who are saying that they are also similarly wronged. I mean, they were majors, but represented by their next one. So, barring these people, if these people have also acted on this document by seeking mutation, then it's a different proposition. If they have not sought mutation, they have never considered to this. So they may have a ground of challenge to this. But I was never implicated in that document.
They may definitely independently challenge, or they may file their counterclaim, or may support the plaintiff in this suit, my lord.
Yes.
That is an avenue available.
So therefore, regarding the deed of settlement, otherwise the first part of the injunction that this cannot be acted upon, that injunction is, I mean, why should I interfere at this stage?
Then, my lord, it cannot be acted upon. Then it cannot be acted upon by anyone in respect of any of the properties. Then, my lord, what happens to the properties which have already been transferred, and when parties are already individually enjoying those properties?
This particular suit, this is the judgment which will be passed in this will be a judgment in personam, binding only the parties. If third parties have acquired interest, they will not be bound.
No, not with regard to third party, my lord. The parties who are parties, because my lord,
these parties, yes,
individually properties have been transferred. Like my lord will kindly see, my lord, D for a moment, my lord. At page 194, item D. All that super built up constructed area of 900 square feet be the same little more or less of Kolkata municipal premises 3B Kamak Street.
Have they produced their birth certificate or something to show that they were? If that is there, they have a prima facie case.
Now my lord will
prima facie. We are only considering injunction. We are not deciding the suit.
No.
Definitely in the suit, if you can prove that they have acted on that or something like that.
Then now my lord will, if lordship will kindly.
Yes.
My lord, now I will show whether any of the properties which are there in the schedule, whether they are part of this.
Yes, that is the important thing. Because this deed of settlement, we are not very convinced on this deed of settlement because this may be bad for, at least if one of the properties within this is, it falls within Alipur jurisdiction, then the court has jurisdiction.
No, but then.
Regarding the deed of settlement.
Partition.
Partition and settlement, that is a nomenclature.
That it is. That it is, my lord, not even for a moment, my lord, I am saying that.
But this deed of partition or settlement does not contain any of the scheduled properties, you were saying.
Now, my lord will kindly see, the only.
Not covered.
There's only a reference to Mumbai property.
How is that?
At page 198.
90?
198. There's a reference. On the dissolving and dissolution of the said Vishwanath Gandhi, Lordship, last paragraph,
yes.
paragraph 16. On the dissolving and dissolution of the said Vishwanath Gandhiriwala HUF, the immovable property in Mumbai has been allotted to Pradeep Kumar Gandhiriwala in the second party herein free from. This is the only reference.
No, this is a reference.
Only reference.
This does not create a right in presentee.
Absolutely. Now, my lord, I will trouble your lordship with the schedule.
So it cannot be said that that property is covered by this deed or affected by this deed.
Now, my lord, will
it
kindly.
refers back to some previous document.
Now, the schedule of this deed starts from page 211. Now, my lord will kindly see. Page 211.
This deed of partition?
Yes, ma'am. My lord sees first schedule. My lord, that property at 230 AJC Post Road. Second schedule, some property at Chatterjee International. Third schedule,
yes,
16B
not
Roland Road.
None of those are covered.
None. No bank account, no demat, no Mumbai property. How could such an order be passed?
Those are covered by the deed of declaration.
Only Mumbai property.
Not this bank account.
None. None. Lordship will see. There are total seven or 8 schedules. 7 schedules. None of the properties which are part of the schedule.
Where the schedule
of the plain.
The deed of declaration does not have any schedule as such.
No, my lord. It only talks.
Whatever is provided within that. So it speaks only of the Mumbai property.
Yes.
Juhu Tara Road.
That also, my lord, vaguely defined.
Yes, but still in Mumbai.
Yes, Mumbai property.
P154 Juhu Tara Road.
Yes.
No, and
no,
yes.
No, R154, my lord. Lordship is reading, my lord.
Page 172, sorry. 172.
Lordship is at deed of declaration.
Deed of declaration. We have gone back to that.
Deed of declaration.
Only Juhu property, that 154 property.
Only Juhu property.
And has there been any mention in either of the deeds regarding the funds or the estate of the Vishwanath?
Deed of partition says after execution, Vishwanath Gandhiriwala HUF dissolves. That is what the deed of partition says. Or it is
then it affects the funds of the Vishwanath Gandhiriwala.
This was an overall family settlement.
Because we are only on the, because they say that the bank accounts were opened with the corpus, the joint family nucleus of Vishwanath Gandhiriwala HUF.
He says, but then my lord will kindly.
That's an allegation. But
allegation, but the relief is not in my lord.
If by virtue of this, if this deed of settlement was not there, then wouldn't Vishwanath Gandhiriwala HUF have those funds? Those have been dissolved by virtue of these deeds. Vishwanath Gandhiriwala HUF has the funds of those estate has been taken off.
No, of the then Vishwanath Gandhiriwala HUF, my lord. My
yes.
Cases, my lord. My cases.
They are claiming on the premise of Vishwanath Gandhiriwala HUF estate, which has been negated by these deeds.
No, but then
the deed of settlement negates that deed.
Subject to correction, my lord, the scope of the suit is not the existence of Vishwanath.
No. If they challenge the deed, a deed of settlement, which, let us say, put it like, appropriates the funds of Vishwanath Gandhiriwala HUF also. If that be so, and if they say the bank accounts were opened with the joint family nucleus of Vishwanath Gandhiriwala HUF, that corpus, if they refer back to that, if the corpus is the source, if they are able to prove that, then the court derives jurisdiction regarding the bank accounts also. Because that's opened with Vishwanath Gandhiriwala HUF, which was negated by this deed of settlement.
My lord, this is absolutely correct. But my lord,
so the bank accounts, the injunction can be granted regarding the bank accounts on the pleadings based on their plaint.
That is not the pleading. That is not the pleading in the plaint.
No, they have challenged this deed. The deed by itself shows that it has appropriated Vishwanath Gandhiriwala estate's HUF estate. If that be so, if they challenge the deed, if the deed goes, if they succeed in the challenge, then this aid relief is in the injunction is in aid of the main relief. Because if that goes, then the property reverts back to Vishwanath Gandhiriwala HUF, which has its funds, which have been appropriated by this. Therefore, now if they say, we challenge this deed, if we win, this deed goes and the funds revert back to Vishwanath HUF, then the bank accounts opened with the corpus of Vishwanath Gandhiriwala should be protected. So that's in aid of the main relief claimed in the suit regarding the bank account.
Well, then,
Because that corpus word has been introduced there.
well, that corpus has been introduced in the pleading, but then there's no relief as such. My Lord, Lordship has seen the
The relief is injunction regarding the bank accounts, which has been opened with the corpus, which this deed of settlement tries to take away from the estate.
My Lord,
Regarding the bank accounts, not the Juhu property.
My Lord, then, my Lord, at least if I'm a plaintiff, my Lord, I have to demonstrate something from some document. In air, my Lord, I'm just making submission.
Corpus, it's very
Lord,
difficult.
he himself says, my Lord, he says that there are bank accounts opened by the executors to the estate.
No, the deed of settlement itself, the purport of the deed of settlement or partition, as you say, deed of partition, the purport of it is such that it is self-evident that it assumes appropriates the estate of the funds of the Vishwanath HUF also.
It does. It does.
It does.
It does.
It is evident therefrom. It's self-evident.
Yes, yes.
So they challenge that deed.
They are challenging that deed. But then, my Lord,
so this is in it. They need not prove anything further. Your deed proves that it took assumed jurisdiction over the corpus of Vishwanath HUF also. We're trying to make ourselves clear. Now, your deed of settlement, that itself makes it clear without any further proof from their end or anybody's end, that this deed says that it takes away the estate of Vishwanath HUF and allocates it among others.
What? My Lord, what?
Whatever, including the entire estate, not the funds also.
My Lord, I put a question.
Yes, clarify on that.
My Lord, what fund? From where, my Lord? There has to be some certainty, my Lord, in the pleading at least. My Lord, he himself says, my Lord, that there are accounts in my individual name. There are accounts in the name of the executors of the state. My Lord, he himself admits, my Lord, then how can there be injunction?
Those accounts were opened by you.
Me and the second executor under the will.
Second executor.
My Lord, then there are accounts opened by me individually.
But that was after this deed of settlement was entered into.
No, prior to also. My Lord, sir, I have to take instruction. My Lord, I am not very sure as to the date of opening, my Lord. That I cannot, my Lord, make submission.
They say that the funds of this has been put in, the Vishwanath estate has been put in there also.
But, my Lord, if Lordship sees the prayer, my Lord, Lordships will once again, my Lord, see the prayers of the plaintiff.
They challenge both the deeds, the declaration and the deed.
Declaration in my respectful submission, my Lord, they could not have challenged, at least not before the Alipur court. He could not have. And Alipur court could not have.
Declaration will be coming to. We are now on the deed of settlement and the bank account.
And the bank. And DMAT.
DMAT is also there. It's also
he
there.
He did not have DMAT, my Lord. My Lord, when he passed, my father passed away, my Lord, there was no.
DMAT was not existing.
No DMAT, my Lord.
No, but then still they go back to their averment that it was from the corpus of Vishwanath HUF.
That's
averment is there. Prima facie case, that is prima facie case on affidavit.
Now, my Lord, I will trouble your Lordship with the numerous orders and to show the conduct of the language.
Bombay property, we have some doubt. Yes, you may have a point there.
Now, my Lord will.
And the deed of declaration also.
If my Lord kindly takes third volume, page 390. My Lord, why I say that order couldn't have been passed? Page 390, my Lord. $90.
20 minutes per volume. We'll charge you for this.
Lordship will kindly.
And that will go to the funds of the Advocates Benevolent
Fund. Absolutely, my Lord. I'll be more than happy, my Lord, to do that.
Yes, which page?
My Lord will kindly permit. It's a 4-page order. Lordship will kindly permit me to place this order.
Which page? Sorry, volume 3?
390, my Lord. So this was a writ petition filed by the present appellant, my Lord, because, my Lord, the registering authority had refused to, my Lord, hand over a registered document. Because, my Lord, I was not in possession of the original IGR. And Lordship, my Lord, correctly, my Lord, dismissed my writ petition saying, my Lord, my remedy lied in, my Lord, filing a suit. And not because, my Lord, none of my fundamental rights were infringed in as much as, my Lord, the IGR was not issued in my name. My Lord will kindly permit me to place. Lordship will kindly take first paragraph. That is very important. Because he was, my Lord, a party.
If the court had any idea that this would lead to this, then the order would be otherwise. Anyway.
No, possibly, my Lord, nothing would have changed then also, my Lord. Affidavit of service filed in court be kept today be kept on record, my Lord. So, my Lord, he was a party. The plaintiff, my Lord, he was a party.
How is this material? Let us.
Because, my Lord, he suppresses this order and says that I did not participate in the proceeding. My Lord, he chose not to participate. My lord, doesn't mean my lord is not aware. Now, my lord will kindly, if my lord
This
states
only relegated you to the civil court.
correct, my lord,
Did
so
not declare any right in your favor or against you.
but my lordships granted me leave, my lord, to obtain the deed from the registering authority following due process of law. My lord, I was in the process of filing a suit. Now, my lord, I cannot even file a suit.
Why can't you file a suit?
Because I have been injuncted. I cannot rely on the document.
Oh, that rely on the document.
Yes, relying on the document. How do I file a suit?
That is why we are referring to specific relief act also, whether this in effect debars you from doing that. But there are decisions that they can seek an injunction which may have the effect of debarring you from relying on a document to file a suit, but that does not tantamount to a restraint order being passed from filing a suit. You cannot rely on the documents. They challenge the documents. In aid of that, they say that you cannot rely on the document.
Any way or manner whatsoever. My lord, that is the language. My lord, I shall trouble your lordship with the.
Yes, if tomorrow you go and file a suit, I mean, you cannot, because the veracity of the deed is challenged in this suit. That
I may not be able to use, but my lord, can I not, my lord, the lordships have granted me leave, my lord, to approach appropriate court, my lord, to seek my remedy. Lord, today, if I win, my lord, if I can file a suit, if I can succeed in that suit, my lord, at least I can hold the document. Whether that document can be relied or not, my lord, is for a future thing to be looked into.
Why do you say it's barred by section 2841 A of specific relief act is there, that you cannot be restrained from approaching a judicial forum for a relief, but this is tangentially that, I mean, not directly. You cannot rely on a document even in a suit, but that injunction can be. Yes, 28 is in the same tune. But why do you say 28? 28 is agreements in restraint of legal proceedings.
Agreement in restraint. So, my lord, the order which has been passed.
Order is not an agreement.
It is not, but it is in the nature, my lord. I will demonstrate, my lord, what kind of order has been passed, my lord.
Unless you rely on the social contract theory. But that is now a bit obsolete.
I won't be relying on that, sorry, my lord. Now, my lord, will kindly permit me to place this order. Few paragraphs, my lord, as to
not
why
section 20, probably you are referring to section 41A of the specific relief act.
That as well, my lord.
Yes.
Lord, page 392, lordships kindly take
Yes.
page 392. Paragraph 11, my lord.
Paragraph 11.
A perusal of the representation of the petitioner indicates that thereby the petitioner inter alia sought for making over the original of the deed in question to the petitioner and for registering the authorities to take appropriate action in accordance with law, including conducting a hearing. However, since the deed was presented by the respondent number 7 and not the petitioner, and the IGR was issued to the respondent number 7 as well, the petitioner does not have a legal right which has been infringed to get back the original.
Yes, yes.
With regard to appropriate action in accordance with law sought by the petitioner, it is beyond the purview of the registering authority to undertake a detailed inquiry as to the right of the parties respectively to get the original deed. Page 392. However, the remedies, if any, of the writ petitioner lies in civil suits, which are pending before different courts. Now, lordship will assess there is no scope of intervention. Now, my lord will kindly see paragraph 16.
Yes.
Accordingly, so and so is disposed of by granting the writ petitioner liberty to approach any competent civil court, including the courts where the suits are pending, at present for seeking appropriate remedy, both with regard to petitioners for getting the original of the deed, as well as for raising any dispute regarding non-return of the same. So, lordships granted.
So, you have to establish a right on the basis of that deed.
Yes. So, I have to file a suit, my lord. Because of this order, my lord, now today I am.
No, that is not your right to file a suit is not dependent on this liberty. This liberty is not a liberty, I mean, directing the civil court to take up. This was only a liberty in consonance with law. If you have a right in law, then
absolutely.
Nothing hinges on this liberty.
But my lord, my right has been curbed, my lord, I am saying. My right has been curbed by this impugned order. My lord,
there is a distinction. If they sought for an injunction restraining you from initiating a legal proceeding as a whole, then it would be in defiance of, in violation of 41A. But if they challenge a document in a suit, in a validly constituted suit, and if they say you cannot rely on that document, then your restraint from relying on that document, even in a suit, is tangential. It's a collateral damage, if you may use the expression in cinematic language. Collateral damage, which you suffer. But it's not a direct injunction restraining you from filing a suit. You can still go and file a suit. But you cannot rely on that document. Right. You can otherwise prove your case.
But my lord, if I have to, my lord.
But that's an incidental effect. It's not in violation of section 41. I challenge a particular deed. I obviously have to seek an injunction so that you cannot rely on that deed. Because if I ultimately win, I mean that the document goes.
My lord, the language of the order is in any manner whatsoever. Well,
That includes, we are taking the worst of it, the marginal case only. In other manners, you cannot in any event rely on that. You cannot assert your rights on the basis of that. Because that's challenged here.
And whether I am lordships will have to, my lord, also, my lord, appreciate whether I am trying to assert my right over Mumbai property.
Mumbai, you are confusing Mumbai. Mumbai, you have kept separately. We are still waiting for your best argument on declaration. Because that is the best case you have. Regarding deed of settlement, they have made an allegation, challenged deed of settlement on an apparently valid basis that some of the parties were not, Rohan was not represented, suppose. He was a major but represented by somebody else, which was a bad representation, could not have been. So therefore, they have made out a prima facie case and they say these bank accounts have been opened with the corpus of that estate, which has been taken away by the settlement.
My lord will kindly appreciate, when has he come with this challenge? After almost 15 years. 2008 deed. He was major in 2000.
They must have shown some cause of action, recent cause of action.
My lord, he has.
You must have asserted on that.
He says
that has to be done.
So
people of the like of Mr. Mitra there in this court must be equally. Somebody must be there. So,
but now, my lord will kindly turn to page 396 once, which is very important. His document.
What does it say?
Lordship will kindly permit me to place this.
What is the secret held by that document?
Page 396.
396.
Rohan writing to the ADSR on 6th of July 2023. Now, my lord will kindly see.
Yes.
Purported partition deed. This is respected, sir, my lord. This is to bring to your immediate and urgent attention that I am, my lord, will kindly mark this. I am one of the signatories to the above mentioned deed.
This is that deed referred to?
Yes. Now, that deed, this is to bring to your immediate and urgent attention that I am one of the signatories to the above mentioned deed of partition, and it has come to my knowledge that the said purported deed of partition has been compromised or manipulated. My lord, he does not say that the fraud, he says it has been compromised or manipulated or interpolated. Thus, the above deed is bad in law and nullity and honest. So this, my lord, my learned senior friends, client's answer is, my lord, at the then point of time, my lord, I came to know that my other cousins are writing a letter to them. My lord, and I also issued a letter. Then, my lord, may it also be mentioned that my mother, late Sarita Ganeriwala, was also, and lordship will kindly bear this in mind. My lord, both father and mother were signatory to that. His mother was alive that time. So both signed that document. May it also be mentioned that my mother, late Sarita Agarwala, was also one of the signatories of the above mentioned deed, and she had died on so and so. However, recently, lordship will kindly mark this. However, recently it has come to our knowledge that some of the signatories of the said deed are now trying to conclude the process of registration of the deed with respect to the above mentioned IGR for their personal and wrongful gain, even in the absence of the original IGR copy. So, in the above circumstances, we request you, your good office, to seal the above mentioned partition deed and not allow the said pending registration or partition deed bearing so and so under any circumstances. We would also request you to cancel the said purported deed of partition and no registration should be allowed. I would request you to take urgent and necessary steps as requested above. This is without prejudice to my legal rights. So, my lord, he's at least as way back in 6th of July 2023, he was aware. My lord, what he says, he came to know of this on 1st of December 2023. That is his case. And my lord, he suppresses this letter. When I try to bring it to the notice by way of filing a written objection, my lord, his only reply is that no.
This was a part of your written objection in the court bill.
Yes, my lord. It is part of my written.
Yes, his reply is that?
His reply is that my other brothers were intending to file similar letters. So I was sent a soft copy. There is no evidence to show that any soft copy was there.
We don't get it.
Lord, he says that my other brothers were, because my lord, similar
this
letters.
was written to the additional district sub-registrar.
Yes, yes. Similar letters have been written by all. If lordships kindly takes.
But we are concerned now only on the plaintiff because plaintiff has sought this relief against
Correct. So he says that other defendants in the suit.
Yes, they also similar.
they were writing similar letters, so a soft copy was sent to him and he signed it.
Maybe.
But my lord,
But he says here that he was one of the signatories of the,
my lord,
which is what you are relying on.
correct. So he said, now to that, to what he says, merely me saying I am signatory will not do because I am not a signatory. That is his response.
But still then it becomes an arguable case. What is the, and prima facie case is whether a tribal issue is there.
Tribal issue with
Not
regard
prima
to,
facie title to the
maybe
hill.
tribal issue with regard to the
Sorry
existence.
to interrupt, my lord. I have spoken about this in the plaint as well as in the petition.
About this letter.
My lord, I am grateful. I am grateful to my learned friend. My lord will kindly come to.
page 51.
My,
Submission was that, my lord, in reply, I have said that.
Yes.
I have
That
got
was
a
the
copy.
submission.
my lord.
Kindly
Yes,
come
yes,
to
yes.
page 51, paragraph 21.
Achha.
Second
My lord,
paragraph, on that
page 50.
occasion.
I'm grateful to my learned senior friend.
Thank you.
In fact, my lord, I'll place from paragraph 20 onwards.
Please.
From paragraph 20 onwards. Lordship,
Yes.
page 51.
Yes.
Lorships. On or about 28th of March 2023, the defendant, respondent number 5, Manoj Kumar Gandriwala, as a co-parsoner, has filed a suit for partition. So, my lord, a suit for partition has been filed, which is pending before the very same judge. Of the said HUF properties in this learned court being number so and so, and the plaintiff petitioner has been arrayed as a defendant, respondent number 7 in such suit. The copy of suit is plaintiff's annex, my lord. Now, para 21, my lord. The plaintiff petitioner came to know about the said suit when factum of institution thereof was informed to the plaintiff petitioner by the defendant, respondent number 5 herein, sometimes in early July 2023. On that occasion, the defendant, respondent number 5 herein, had also informed the plaintiff petitioner that the defendant, respondent herein number 2 in his defense was trying to rely on a purported partition deed, which was presented for registration before the ADSR, Alipur, to allege that the properties and assets of Hindu undivided family has already been partitioned. The defendant, respondent number 5, on that occasion had also furnished to the plaintiff petitioner the IGR number and the serial number of the said purported partition deed, and had alleged that the registration of the purported partition deed, which was allegedly signed not only by the plaintiff petitioner, but also by the parents of the plaintiff petitioner, was yet to be completed, my lord. He does not say, my lord, that I am not a signatory, I am not aware. Now, my lord will kindly see. Para 22 is where he talks about the letter, and lordship will see whether he discloses whether he has written letter to the ADSR or not. Para 22. The plaintiff immediately contacted his father, being defendant so-and-so, herein asked him about the purported partition deed when the defendant number 4 had refused to disclose. My lord, both father and son live in the same house, but father refused to disclose. Refused to disclose any particulars to the plaintiff. As the mother of the plaintiff had already expired, the plaintiff, finding no other alternative, contacted some of his other family members, including defendant respondent numbers 3, 20, and 21. When the plaintiff petitioner came to know, now my lord will kindly mark this. When the plaintiff petitioner came to know that the said defendant's respondents had decided to issue letter to ADSR, Alipur, requesting him not to complete the registration of the said purported partition deed and also to cancel the same. On that occasion, the said defendant had also given the plaintiff petitioner a soft copy of the letter.
No, he does not say that he wrote a letter.
Exactly, my lord. That is what I am saying. My learned friend says that.
He does not.
Where does he say? My lord, that is what I am saying.
No.
That's why, my lord, I was so very obliged to my learned senior friend. He says that it was soft copy was handed over.
No, he said others wrote letters.
Correct.
And those
so
soft
when
copies.
I bring it to the notice, then he says that, and he refers to this para 22, saying that I have disclosed it. He refers to this para.
No, this letter was not disclosed.
Yes. And the factum of him writing was also not disclosed.
No.
My lord, I have just prepared a short to show the contradictions, my lord, so that lordships need not take the trouble of my lord of shifting from one brief to another, my lord. I'll just hand over.
Give a copy of Mr. Mitra's contradictions to him also.
My lord,
Your contradictions.
My lord takes, this is page 48, my lord. Yes. Hi.
It's from the, oh, acha. You have called out certain portions of the
my lord,
pleadings.
so that lordships need not, my lord, I need not trouble your lordships, my lord, from shifting one volume to another, my lord. Lord, page 48 Lord, is part of the injunction application, my lord. If my lord kindly takes paragraph 12 of his injunction application.
I is for injunction, this I at the top.
My lord, this is part of injunction application. Sorry, man.
Huh?
Sorry. Lordship,
What
sorry, I
for,
did.
No, something else. Yes. No, this is Roman 1 and 2 for us.
Oh,
They wrote.
sorry.
I thought it was an I for an injunction. I for an I. Yes, injunction.
This is page 4 of the injunction application. Lordship,
Para 12.
Para 12. In the year 1986, my lord, he is talking about event, my lord, when he was not born. He is born in 1988 because, my lord, he affirms this true to his knowledge. That is how he has affirmed the affidavit. In the year 1986, the said Vishwanath Ganeriwala, since deceased, purchased a property being a bungalow at premises number R154 Juhu Tara Road, PS Juhu, Mumbai. My lord, this is not the property which was purchased. This is not how the property was described. My lord, if my lord, in this very volume, if my lord kindly turns to page 439. Look, this is the order of this honorable court, my lord, division. Lordship will kindly permit me. Page 439, my lord.
Yes.
Order dated 8th of August, my lord.
R154 Juhu Beach, Bombay.
My lord. Now, my lord will kindly see what he says.
R154 Juhu Tara Road.
There was no, my lord, existence of Juhu Tara Road. It was only R154 Juhu Beach.
Achha.
R154 Juhu Tara Road, so and so. And as such, the Mumbai property formed part of the common hodgepodge of the said HUF. So this is his allegation. Now, my lord, we'll kindly turn to next page, page 50, paragraph 16, where he talks about bank account, my lord. Paragraph 16, my lord. Sorry.
Paragraph 16, yes.
Paragraph 16, page 50, my lord.
50.
After demise of said Vishwanath Ganeriwala, even before the probate was granted and the said will of that last will by the learned district delegate at Alipur, the defendant number 2 being the eldest male member of the family and named Karta started acting as Karta of the said HUF being Vishwanath Ganeriwala HUF. As far as plaintiff is aware, the defendant number 2 continued. My lord, he says, as far as he is aware, it is not true to his knowledge, cannot be. As far as he is aware, the plaintiff, the defendant number 2 continued with the bank accounts maintained with Union Bank of India, MG Road branch, Kolkata, and Jammu and Kashmir Bank, RN Mukherjee Road branch, Kolkata, in the name of the said HUF, and also opened bank account in the name of Pradeep Kumar Ganeriwala, Deepak Kumar Ganeriwala. So, my lord, by his own admission, my lord, these are not part of, my lord, the corpus, so-called corpus of the HUF, my lord. He does not say so. He admits, my lord, that this account was operated by 2 individuals, Pradeep Kumar Ganeriwala and Deepak Kumar Ganeriwala, being joint executors to the estate of Vishwanath Ganeriwala. My lord, if I have done anything wrong, my lord, being an executor, my lord, his remedy lies somewhere else, my lord. He can seek, my lord.
It's a continuation of the sentence. He says, as far as he is aware, you, respondent number 2,
yes,
continued with the bank accounts maintained with Union such and such banks in the name of the HUF, and also opened a bank account in the name of you and Deepak, being the joint executors to the estate of Vishwanath Ganeriwala.
This action, he admits, my lord, that I performed this action being executor to the estate. Lord, that is
of Vishwanath Ganeriwala, exactly.
Not HUF. Of Vishwanath. So, my lord, that is pursuant to the probate granted in my favor. My lord, lordship, there are 2 different actions, my lord. One is estate of Vishwanath Ganeriwala. One is Vishwanath Ganeriwala HUF.
HUF property is the subject matter of this present.
Yes,
suit.
not the
The deed of settlement and the declaration.
Yes, not the
estate of personal estate of.
No, and if that be the case, my lord, then he has to seek my removal as executor before the probate court.
Achha.
So he admits, my lord.
There was a probate has been granted also.
Yes, my lord. It has been granted, my lord. Pursuant to probate only, my lord, the properties came in the hands of HUF, Vishwanath Ganeriwala HUF. Lord, because that was the scope of the probate. Since deceased particulars whereof are more fully and particularly described and mentioned, my lord, lordship will kindly appreciate, my lord. He does not say that these accounts were, my lord, being operated from the corpus of the HUF.
Yes, does he say anywhere? We were looking for that.
My lord,
Whether he
I
has stated that it came from the joint corpus.
I could not, my lord, I could not. In fact, paragraph 17 at that page, my lord, is very important, where he admits that I opened the account. Lordship will kindly take paragraph 17 of that page. As far as plaintiff petition is aware,
In
defendant
the name of the said HUF.
has also opened demat account in the name of the said HUF, and the said account is, my lord.
So it's the HUF's account.
HUF's account, so but then he admits that I am the one who has opened it.
Maybe you have opened.
Well, then there has to be a declaration also, my lord. Then there cannot be a blanket order of injunction, my lord. Lordship will kindly appreciate, my lord. And that also, my lord, account opened, my lord, when? And
No, the deed of settlement or partition automatically takes within its fold all the properties of Vishwanath HUF, doesn't it?
No.
If it does, and if they say
no, it did not. Sorry.
It did not.
Because, my lord, number of properties were already transferred before the execution. Those are not part of that deed of my lord, my case is, my lord, from time to time, parties have entered into agreement, understanding, properties have been distributed, conveyed, transferred.
Hmm.
My lord, then what happens to those understanding? What happens to those instruments, my lord? My lord, the only property which has come to me, my lord, that is the only property which is pinching him. Other properties which has been taken over by him or his branch of family, my lord, those are not subject matter of challenge. Those are not part of the schedule. He's being so very selective, my lord.
কোনটা কোনটা কোথায় ট্রান্সফার হয়েছে অপোজিশনে একটু দেখিয়ে দাও না
হ্যাঁ আরে সব দেখে সব দেখো now my lord, my lord, lordship kindly turns over next page, my lord, page 51. My lord, in fact, I have placed this 2021 paragraph 22, my lord, I have placed.
Yes, yes.
I will not trouble your lordships, my lord. Now, my lord, what he alleges, how he came to know, my lord, page 53, my lord, this is very important. He says, my lord, page 53, paragraph 25.
Yes.
From perusal of the said application, my lord, he refers to my application, my lord.
Your application for?
Seeking dismissal of that title suit, Order 7, Rule 11. He says from perusal.
Which title suit?
423, partition suit filed by Manoj. From perusal of the said application, it appears that the said application was filed inter alia on the following allegation. Now, my lord will kindly take B of that. By such family settlement, the defendant number 1, respondent number 1, therein being the defendant number 2, herein was inter alia exclusively allotted the said Mumbai property being immovable property R154 Juhu Tara Road, so and so CTS number 870. Now, my lord will kindly turn to page 129 of this bunch only, my lord, lordship, this bunch only. My lord, this is the paragraph of my application, my lord, where he refers. My lord will kindly mark this bearing CTS number 870, my lord. Now, lordship will see paragraph 5 of this. This is, my lord, portion of my order 7, Rule 11. Lordship will see there is no CTS 870. He says he came to know about this property from this document. Lordship will kindly see how the Mumbai property is described in subpara B, and my lord will kindly see how, because he says his source of knowledge about Mumbai property.
But you also say Juhu Tara Road, not Juhu Beach.
Because now it has become Juhu Tara. But in 86 it wasn't. Now it is.
Right.
But he was referring to 1986.
You are saying, referring to the deed, saying that it covered.
He was referring to the order of this honorable court.
Yeah, right.
Yes.
Yes.
There it wasn't. Now, my lord, it is. But my lord, I do not mention CTS number 870. Now, lordship may ask me a question, my lord, where is this CTS 870? My lord, what had happened, my lord, since in as much as Manoj was, my lord, Manoj and other supporting defendants, my lord,
what is CTS 870?
This is, my lord, this is how in Mumbai, my lord,
Yes.
how the properties are described. My lord, without the CTS number, my lord, the property cannot be identified.
All right.
So it is like premises number. But then in municipal record, this is most important. I think possibly it is city survey number. Something, possibly, my lord. So this, my lord, lordship may put a question to me, my lord, as to where, from where this number comes.
Maybe it has now become this.
No, my lord, but there has to be some source, my lord, from where he got this. My lord, what had happened, my lord, in as much as, my lord, a partition suit was filed.
This should be public knowledge. If they give the address, they will get the CTS.
No, where he got, my lord, I have filed a suit in Mumbai. I filed a declaratory suit, my lord, since, my lord, the other defendants, my lord, when I say, my lord, my lord, my HUF, who is the owner of Mumbai property, they filed a declaratory suit, my lord, seeking absolute title, my lord. In that plaint, my lord, this property is described. And, my lord, the plaintiff has borrowed this scheduled property, my lord, details from that plaint. Because it's only that plaint which has CTS 870.
How does it make a difference?
Because, my lord, he suppresses that Mumbai suit also. I say you have suppressed. He said that I have not suppressed because I am not party. I don't know. So I put him to strict proof as to from where you got this detailed Mumbai property description.
Not a necessary deduction from this.
Not a necessary.
Not a necessary deduction. He
But-
could get the CTS even independently of your suit.
Then he has to show the source. He does not. He does not. He should have shown, my lord, because I had put him to strict proof. He does not.
That's a suit by you for?
Seeking declaration that I am the absolute property, absolute owner of the property in Mumbai. My HUF. Pradeep Kumar Gandhariwala HUF has filed a suit.
Absolute property of this Mumbai property. They are contesting that suit.
Not my learned senior friends, because my brothers are party, my sister is party, so some of them are contesting.
That's why he was chosen as to file this suit. Because he's not a party there, he does not have knowledge. Maybe, but we cannot help that.
No, that, my lord, I have to take independent steps there, my lord. I have to fight it out independently. If I win, I win. If I lose,
There are certain things which we cannot, render any finding on. Even if you understand, we cannot render any finding because we have to go on the papers.
Absolutely, absolutely. My lord, then page 302 and 303, my lord, are my affidavit in opposition, my lord, part of affidavit in opposition, my lord, where I said, my lord,
So up to now, two things we find which are maybe strong grounds you have. One is that if there is no reference to this bank accounts being opened from the joint corpus of Vishwanath HUF, then they may not be entitled to injunction regarding the bank properties. Juhu property is only a part of the declaration, deed of declaration, which was executed beyond Alipur jurisdiction, and property also beyond even our jurisdiction. So therefore, the court did not have any power to grant injunction regarding either bank account or that
or demat
account, and also the Juhu property. So this is your strongest case because there is no reference in the pleading, in the plaint. If they have referred to this coming from the source of the corpus of
subject to correction, my lord, I could not come.
All right, they have to show that.
Subject to correction, my lord, I didn't come.
So therefore, the court did not have jurisdiction to grant injunction regarding this, even if the reliefs were granted. These are not in aid of the reliefs, main reliefs. Even if the deeds go, then also on deed of declaration, they could not challenge before this court.
Now I'll take your lordship through the orders. As to lordship will kindly take the last volume. Volume 4. Before that, my lord, I'll just trouble your lordship with one more document to show, my lord, the property at Mumbai is registered in the name of my HUF by registered deed of indenture, which is at page 466 of last volume. No?
For 66?
466, my lord, is the registered indenture, my lord.
Yes. This is a deed of declaration, which there.
This is deed of indenture.
This is a different deed.
466, my lord. 465, my lord. Sorry.
465, yes.
Sorry. 466, 5 is part of the deed of declaration. My lord. 466, lordships.
Yes.
This is registered indenture, my lord.
Oh, 465 was the last page, the back sheet of that.
Back sheet of deed of.
Yes.
466, my lord.
Yes.
This indenture made this 7th day of July 2009 between so and so retired district judge belonging to West Bengal Higher Judicial Services, my lord, so and so, vendor, and lordship will kindly see who is the purchaser. Pradeep Kumar Ganeriwala HUF is the purchaser. Lordships have seen? Page 466?
Your HUF.
My HUF. So, my lord, by
the present appellant before us is the HUF or you in your
because HUF is not party in the suit.
Right.
HUF is not a party.
Right.
Individual.
Yes.
And my lord will find the schedule of this property at page 471. That schedule has that CTS number. Page 471 is the schedule.
All right. So the Juhu property belongs to your HUF. You have filed a suit which is pending in Mumbai, to which some of the defendants are parties.
My brothers, my sister, not my nephews, not my.
Yes. So therefore that was suppressed. This is one of the, and the other two allegations, as we said.
Now, lordships, if my lords kindly turn to page 510.
And that letter also that shows that he had admitted to having signed the document.
Yes.
Letter to the registrar.
Yes, madam.
What was the page number of that page?
Lord, page 396, my lord.
Right.
396.
Yes.
Now, my lord, will kindly turn to page 510, my lord. Page 510. Lord, this was my first appeal, my lord, against the ex parte ad interim order before this honorable court. My lord will kindly permit me to place this order.
510?
Yes, my lord.
Yes.
Order passed in FMAT 385.
510, what do we get?
Lordships. Lordships.
Fourth volume.
510 lordships.
Huh? 509 এর পর 14 রয়েছে আমার এখানে আপনার আগেরটা 509 আগে কতটা দেন 9 তো এটা 9
lordships
আপনার আমারটা
510.
No, from 510 to 13 is not there in my copy.
Lordship's copy?
His lordship's copy there.
Lord, may I just hand? So I'm extremely sorry. Lord, may I just hand over one copy?
Five. We can.
Well, right.
No, it is required to be.
My lord, lordship will retain this. My lord, I have a spare copy. My lord. Sorry, my lord. Extremely sorry.
Recorded to রেখে দিতে হবে একটা Yes.
I'm extremely sorry.
No, you don't have any other copy. This is your copy.
No, my lord, I have mine. This
Fair.
is my lord junior. We are astonished to find that the defense of the defendant, my lord, that is the appellant before your lordship. Defendant number 2 appellant is struck off within fortnight from the date of institution of the suit, as the conduct of the defendant number 2 appellant does not find palatable to the learned judge. It is an ardent duty of the judicial officer, my lord, just to show the conduct, my lord, what has been going on before the learned trial court. It is an ardent.
So what was this? Was in connection with the same suit, the present suit. Yes.
Same suit. Lord, a suit filed on 12th of September 2024 made ex parte against me on 24th September 2024.
You are not. You are defendant number 2, right?
Yes,
right.
I am.
Oh, your defense was struck off. Why?
Within 12 days of filing of suit, no service of summons.
Why struck off on what ground?
Because.
Oh, the conduct. Let us read on it.
It is an ardent duty of the judicial officer to conduct the case on the basis of the merit and should not be swayed by an extraneous factor, and pass an order more particularly striking out the defense which is valuable right. Order 8 Rule 1 of the Code of Civil Procedure provides 30 days period from the date of service of summons for presentation of the written statement, and the proviso inserted thereto bestowed power upon the court to extend the said period of recording the reasons thereof. The right to file written statement within the statutory period is an invaluable right which cannot be squeezed or shortened by as the judicial officer thinks it fit to do so. The moment the legislature has fixed a timeline within which the defense is to be presented by the defendant, it cannot be struck off within the said period despite the conduct of the defendant does not appear to be proper. Striking out of the defense within the period provided under Order 8 Rule 1 of the Code offends the core value of the right to defend and provide an easy path to the plaintiff to march over the same and get an ex parte decree against the defendant It is an ardent duty of the learned judge to see that the justice is not only be done, but seem to be done. Any order which
This order was placed in connection with some other matter before us.
Yes.
We have a deja vu on this.
Yes, lordships. Lordships. That's the lordship's order is subsequently.
No, this particular order
Yes. Lordship.
rings a bell anyway.
So, my lord, the cost of rupees 20,000 was imposed. I will not trouble your lordship with this order.
This speaks about the judge, not the
No,
litigant.
absolutely not.
Judicial fact.
Yes.
Yes, prejudice.
Then lordship will kindly.
Same judge has now passed this order also.
Yes.
Bad judge, good order, maybe.
514.
Like most of our cases.
No. Now, lordship will kindly turn to page 514. My lord, we came before your lordships because of this order. Page 514.
Yes.
Order of 17. Now, lordship will kindly take.
This is much more vegetarian, my order.
Lordships is at page 514. 14. The learned advocate for the
Justice Tandon is vegetarian, I am a non-veg. But our orders are contrary. Yes.
Learned advocate for the defendant number 2, along with put up application. Lordship may skip.
So why are you placing this order? I mean,
No, well,
yes.
It's important, my lord. It is
Important
very
for me, but not for the case.
No,
Because
it
it
is
was
for
my
the
order.
case.
Otherwise, it's
No, page 514 is not your lordship's order.
Oh, achha, sorry.
Page
Oh, this is a trial judge.
Trial judge's order, my
Sorry.
lordship.
Wrong.
Page 514.
This is the impugned order.
No, this is
Ad
prior,
interim.
just prior to impugned order,
Right.
which was challenged before your lordship.
Yes.
My lord will kindly take third last paragraph of page 514.
No, what are you trying to prove? That the judge is, prejudiced against you?
Biased, absolutely.
Have you taken out a section 24?
I did.
You cannot accept these allegations.
I did. No, lordships I also come to a finding. I showed them, my lord.
What was that finding?
My lord, just my
Other very well.
third last paragraph. On the prayer of the learned advocate for the plaintiff, my lord, so whatever plaintiff is saying, my lord, the learned judge is passing order. Lord, on the prayer of the learned advocate for the plaintiff, that as the defendants are all co-shares of the suit property, hence the written objection filed by the defendant number 2 should be supplied to the rest of the defendants. So it is not a case of partition suit. And lordships had held that. Learned advocate for the defendant number 2 raises strong objection. Learned advocate for the defendant number so and so also prays for supply of written objection on the ground that the rest of the defendants are entitled to have knowledge of the objection raised by defendant number 2 for the sake of their personal interest in the suit property. In the partition suit, lordship will kindly mark, and lordships had marked this.
That was a mistake there.
Absolutely, man. I bowed on. In a partition suit, as there is no discrimination between the status of the plaintiff and the defendants, and everyone's interest in the joint property is same and identical, hence the procedure followed in any other suit regarding filing of applications and supply of copy of such application and written objection thereto to the other side should not be followed strictly. For better appraisal of the dispute, my lord, so this was the order where, my lord, the learned court directed me, my lord, to supply, which was challenged before your lordships. Matter came before your lordships. Lordships will kindly turn to page 516. This is the present challenge has been preferred, lordships, page 500.
Yes.
The present challenge has been preferred against an order whereby the present appellant in a suit for declaration challenging a registered deed of partition was directed to serve copies of the written objection filed by him to the injunction application on defendant number so and so. Para 2, my lord. The learned counsel for the appellant argues that since the learned trial judge proceeded on a fundamental misconception that the suit is one for partition, whereas the suit has been filed for a declaration challenging a registered partition deed, the entire premise of the order is bad in law. It is further submitted that since the written objection of the defendant number 2 appellant was to an application for the injunction filed by the plaintiff, the present defendant number 2 appellant does not have any obligation to serve notice thereof to other defendants. Learned counsel also refers to the checkered history of the matter. The partition suit was filed previously where the present defendant appellant took out a defense that there was a previous, though till then unregistered deed of family settlement whereby all the parties were allocated their respective shares, which was acted upon during the pendency of the such suit. The previous deed was registered. Such registration prompted the filing of the certain suit challenging the same. Now, my lord, para 6. Learned counsel for the appellant places reliance on a judgment of a coordinate bench passed in connection with the previous order, my lord, the same order which I placed. Now, 7, paragraph 7. In the said order, the division bench has apparently made a costly certain cost. Lordship will kindly turn paragraph 9. Same. Be that as it may, we find from the order that although the same was filed in connection with an injunction application while hearing the same, the order itself is not one passed under Order 39 Rules 1 and 2 of the Code of Civil Procedure, which are applicable.
Yes, merely copies were directed to be served. That was the
Thus
premise.
the remedy. So thus the remedy, lordships, what your lordships held. Thus the remedy of the appellant, if any, lies by way of an appropriate challenge and not an appeal, since the order was not appealable in law, and my lord, my appeal was dismissed. Thereafter, my lord, if lordship kindly turns over to page 560. 520, my lord, is the written objection, my lord. I am not troubling your lordship. Page 560. My lord, this matter, this immediate, that lordship's order was of 21st of January. This again is taken up on 22nd January. Now, lordship will kindly see. Today is fixed for hearing of the injunction application. Learned advocates for the plaintiff, defendant number 2, 7, 8, 10, and 11, defendants so and so are present and have filed their respective steps. Lordship will kindly mark this. This is very important thereafter. Because, my lord, in the impugned order, written submission is, my lord, referred to as written objection. Lordship will kindly mark this. This is very important. The defendant number 5, my lord, who's plaintiff in the
It's
other.
written in bold letters in the order also.
Yes, and in impugned order, it becomes written objection. The copy was not never, my lord, I was never favored with the copy. Obviously, I wouldn't be entitled to as well.
Why was this in bold letters? We don't understand. Anyway.
My lord, that is only for the learned judge, my lord, to.
So that you can take the point subsequently, making it easier for you.
Possibly, yes, my lord. The defendant number 5 has filed written submission in support of the injunction application. Written objection in support of injunction application of the plaintiff. Copy of the submission has been made. So again, my lord, it is submission. The copy of the submission has been served upon the learned advocate for the plaintiff. Let the written submission be kept with the record. Now, my lord, learned advocate for the defendant number 5 and 17 has filed copy of order dated so and so. My lord, that was the earlier order. And copy of order dated 21st of January, passed in FMAT 22 at 29 of so and so. Let the orders be kept in the record. Now, my lord will kindly see. My lord, I had never submitted this. Lordship will kindly see what she records. It is submitted by the learned advocates for the parties that there is a typographical mistake. My lord, I never ever made this submission.
That point you have to take before the court below. We do not know what to submit.
Lord, because I approach your lordships. My lord, she's referring to that very aspect, my lord, that it's a partition suit. My lord, I preferred an appeal. How can I say there's a typographical error? It is submitted by the learned advocates for the parties that there is a typographical mistake in the order dated so and so, where the suit has been described as suit for partition. Instead, the suit for declaration that partition dated so and so is void. Such mistake is required to be rectified, my lord. I have never made this submission. See in order dated 17th of January. Now, my lord will kindly see what she says. Fact is, mistakenly describing the suit as a suit for partition, defendant number 2 has been directed to serve a copy of this written objection to the injunction application to other defendants. But the reason, now my lord will kindly see the reason. But the reason for which this direction has been given still holds good. For the present suit, which has been filed praying for declaration that the partition deed executed so and so is void.
She has a point there. She has a point there because it's a reverse. I mean, even if it is not a partition suit, the effect is to negate a partition.
Could be, my lord. My lord, then everyone,
all the co-sharers should be affected.
Everyone has to take an independent stand, my lord. They are free to, my lord. They can file a supporting affidavit, my lord. My lord, they cannot, my lord,
They can come up and say that they support the plaintiff's prayer.
Then
they have done that only, written submission.
There is a question of me, my lord, then providing them. My lord,
you providing what?
Me providing my copy of written objection to other defendants. My lord.
That is not a major issue. I mean, we often directly give a copy to the other side also. There may be something against them also there. And if they support the cause of the plaintiff, then they have all the more right to. And please ask your clients not to nod. It's disturbing. Are they your clients? No, your clients standing behind you. Please ask them to have a seat if they have a seat. It's very difficult to get an affirmation all the time from litigants. It's good if advocates do that, but not litigants. Yes, please.
My lord will kindly permit me to place the reasons, my lord. As the suit has been filed challenging the partition deed in respect of joint property of the parties,
yes.
And as such, there is no discrimination in the status of parties in respect of said partition deed. Hence, for better appraisal of dispute between defendant number 2, copy, I could serve a copy of the written objection to the defendants.
But why are you on these? I mean, serving objection.
No, my lord, why I am, my lord? What transpired, lordship? I need to bring it to the know.
This does not ipso facto prove that she was biased.
I am coming to that, my lord. I am coming to that, my lord. My lord will it's a 3-page order. My lord will kindly. Okay, lordship may skip page 1. Lordship will kindly permit me to place page 561.
Yes.
In fact, my lord, the first, second, third, fourth line after the above direction is given to the plaintiff, my lord.
Yes. Fourth para. Fifth para.
Fifth para from the bottom.
Right.
After the above direction given to the plaintiff, record is taken up for hearing the injunction application. Now, my lord will kindly see. A dispute arises between the parties as to who shall start the hearing of injunction application. So it is the plaintiff's injunction application. He has to move it.
Yes.
There is a dispute to that. Application first. Learned advocate for the plaintiff submits to the court that as the plaintiff has already been favored with an order of ad interim injunction, hence the defendants who are challenging the said order shall submit first. To what do I submit, my lord? Unless and until, my lord, I know what is the line of argument, my lord, how can I make my submission? My lord, unheard of. Learned advocates for the defendant number 5. Sorry. Yeah. Yes, ma'am. Learned advocates for the defendant number 517 and defendant number 2022 submit that they are supporting the prayer of plaintiff. Very well, they are very much entitled to. Hence, after contesting defendants, that is me, submit, they shall put their submission next. Chronologically, my lord will kindly see, the chronologically has been arranged by the learned judge. The defendant number 2 is required to be heard first. My lord, from where does the learned court come to this chronology, my lord? Hence, without going into the complexity of the chance of hearing, the learned advocate for the defendant is requested to submit first. My lord, in here I will submit. Well, lordship will kindly pardon me, but actually, well,
was she relying on the ad interim order? I mean, the reasons have been given there. You controvert those.
No, that is.
But that is not clear from the order. You're right.
But my lord,
we have to assume.
Kindly pardon me, my lord, for using the term. Actual circus was going on there. Lordship will kindly pardon me, but on being asked to open a submission, learned advocate for the defendant submits that it is a plaintiff who shall move this application for injunction first, and then she shall put a submission. Well, rightly said so. Learned advocate for the plaintiff raises objection to such submission of the defendant number 2, to which the learned advocate for the said defendant has asked the court to order the plaintiff to give it in writing that the plaintiff shall not argue on his application. The learned advocate for the plaintiff and the rest of the defendants present in court have raised strong objection to the submission of the defendant number 2. Fact is, after hearing the plaintiff, court at preliminary stage has passed an ad.
Yes, she gives that reason.
Now she is giving that.
We had a hunch on that. Probably that was what she meant.
But my lord, in my respectful submission, my lord.
No, at the final hearing stage, again it has to be argued again.
My lord, it was not passed in an order passed in my presence. I was never there.
Oh, right.
Ex parte order passed.
That also. Yes.
Then, my lord,
right.
I was never there.
You're right. You're right.
Fact is, after hearing the plaintiff, court at a preliminary stage has passed an order of ad interim injunction asking the plaintiff to deliver to all the defendants by registered post a copy of injunction application together with copy of affidavit filed in support of the application, a copy of the plaint and copy of document on which the applicant relied as per Order 39, Rule 3 of CPC.
Achha, they have sought for injunction only against you, not the other defendants.
All defendants. And government is party. I had taken that point. Suit is barred under Section 80. Government is party. No.
The primary relief is not against the government.
One of the relief is there.
80 is diluted.
One subject. Well, I had taken that point.
Take that point before some other could.
I had taken the point, my lord.
Yes.
So, at the same time, the plaintiff was directed to send to the defendants notice directing them to show cause as to why the temporary injunction is prayed for by the plaintiff shall not be granted. Thus, it is the defendants. Now, my lord will continue. Thus, it is the defendants who should have started argument on the injunction application to convince the court as to why it is not my Order 39, Rule 4 which is being argued. She proceeds on the premise that I have filed Order 39, Rule 4. New law is being laid down. As to why the ad interim injunction so granted by the court shall not be vacated. However, as the defendant number 2 does not want to put a submission against the injunction application and the rest of the defendants are ready for hearing, hence the argument of the rest of the defendants on the injunction application is heard in full, heard the learned advocate for the plaintiff in reply in full, No prayer to give reply is made by the defendant number 2 to date at 12 o'clock 24th for further hearing. Matter is heard on 24th, and my lord, I have to be very candid, my lord, that court permitted me to make my submission. Court permitted me. On 24th, I made argument. My lord, that is the order of 24th. I made argument. And my lord, there was thereafter, my lord, order, the impugned order, which is at page 564. Now I'll trouble your lordship from but my lord, before my lord, I place the impugned order, my lord. I'll be failing in my duty, my lord. If I, my lord, do not bring it to your lordship notice, my lord. My lord, the appellant before your lordship, my lord, had filed one suit before the Alipur court.
Who had?
The appellant before your lordship, my lord, had filed one suit, my lord, before the Alipur court, my lord, which, my lord, I have placed it in my list of dates, my lord.
Regarding what?
My lord, what this property?
Regarding the Juhu property?
Not regarding the roll and rod property.
Use the microphone. Regarding the?
Regarding the roll and rod property. Roll and rod property, my lord.
Roll
my
and
lord, all the parties are staying, my lord. That is, my lord.
Yes, that you may. Why are you? I mean,
No, my lord. Why?
Submitting that in a whispering.
No. My lord, there was a mistake on the part of the appellant.
What is the mistake?
Mistake as in he was wrongly advised to file that suit, my lord.
Why?
My lord, there, my lord, he went on the premise, my lord, that property, my lord, continues to be a joint property because, my lord, what had happened? One of the parties were using one of the floors, my lord, for paying guests, my lord. Since, my lord, that was a residential
You
building.
say that's a joint property that goes against your that deed of settlement. That is what you say.
My lord, to an extent, my lord, he was wrongly advised. Suit was wrongly filed, my lord. Thereafter, my lord, suit has been withdrawn, my lord. The suit has been withdrawn, my lord. Now, my lord, this impugned order. No, it's a lengthy order, my lord. I'll have to place the entirety of the order. Today is fixed for passing of order on the injunction application filed by the plaintiff.
7 minutes.
As much as my lord.
Cover 7 pages within 7 minutes. Just pinpoint the main points.
Now, my lord, records show, my lord will kindly mark that the defendant numbers 1 to lordship will kindly mark. 25 have not appeared in this suit. 25, my lord, is the ADSR. Government.
Is
the ADSR?
Government. ADSR.
ADSR, my lord. Then, my lord, lordship will kindly come to second last paragraph of this page. Plaintiff has prayed for an order of temporary injunction restraining the defendants and their men, agents, servants, and or assigns from relying upon the deed of partition and settlement dated so and so and deed of declaration dated so and so, and or parting with possession or in any way encumbering, removing, and or disposing of property so and so in application of any third party so and so. Well, this is what the plaintiff has prayed. And what has been granted, lordship will see. Lordship will be amazed, my lord, to see what has been granted. My lord, virtually, my lord, the partition suit and this suit, both suits have been decreed by the impugned this order. It is the submission of the plaintiff that the defendant numbers 1 to 24 are related to each other. Late Vishwanath Ganeriwal was the grandfather of the plaintiff. During the lifetime, he became entitled to several. The lordship will kindly mark this. It does not say that there is any property situated within the jurisdiction of Alipur court. Became entitled to several movable properties in Kolkata and other parts of India. It does not say South 24 Parganas. Kolkata and other parts of India.
You don't stay at Kolkata.
Vishwanath Ganeriwala died on so and so making publishing. Thereafter, lordship may skip that. Then, my lord, next page, 565, second paragraph. On or about, second paragraph.
Yes.
On or about 28th of March 2023, the defendant number 5 herein, as a co-parsoner, filed a title suit for the partition of the said HUF in this court, being title suit number 420. Same judge is hearing this title suit as well. Wherein the plaintiff has been made so and so. The defendant on or about July 2023 informed the plaintiff. My lord, lordship will kindly appreciate. In this suit also, ex parte ad interim order has been obtained by the plaintiff there. He has complied with the provisions of Order 39, Rule 3, my lord. He has filed affidavit of service. The suit was filed in March. So he was in the knowledge of this suit in March. But he says, in July, I was informed.
That defendant number, that the plaintiff says, not defendant number 5.
No, defendant number 5, on or about. Defendant number 5 is the plaintiff in the other suit.
Yes, but this suit has been filed by plaintiff who says I had knowledge in July.
No, here he says I came to know in December. In plaint, he says in December 2023. That's what he says in plaint.
But there is nothing to attribute knowledge to the plaintiff. The
No.
present plaintiff is Rohan.
Yes, my lord.
Rohan, this does not say that he had knowledge.
No, my lord, he says the defendant number 5 co-partner filed so and so. No, plaintiff has been made defendant number 7. My lord, this is.
Oh, this defendant number 5 is that the present
Defendant
plaintiff?
number 7 is plaintiff, Rohan. Defendant number 7 in this suit is Rohan.
Acha.
Is Rohan.
Right, yes.
But in his suit, he says his date of knowledge is December about this deed of partition.
All right.
Inform the plaintiff that in his defense has relied upon purported deed of partition, by which was then presented before the registration, before the ADSR Alipur, alleging that the properties and the assets of the HF had already been partitioned. The plaintiff immediately contacted his father, being defendant number 4 herein, and asked him about the purported partition deed, but father refused to disclose any particulars as the said partition deed to the plaintiff. Then, my lord, I am on this. On 1st of December 2023, plaintiff appears. So, my lord, he chooses. He comes to know about the suit way back in March. He chooses to appear in the month of December in that suit.
How can you say he knew in March? The suit was filed in March.
No, he says.
He appeared in on 1st of December.
No, he says, my lord, on or about previous paragraph. On or about 28th of March 2023, the defendant here is co-partner filed as
title suit, yes.
Suit so and so, wherein the plaintiff has been made. Well, these are submission of plaintiff.
He says the suit was filed on such and such date, not that I knew about the suit on that date. How could he know about the filing of the suit on the date of the filing of the suit itself? Must have been served summons letter.
Yeah, no, not summons, my lord. Order of injunction was passed.
Maybe.
Addendum order of injunction is passed.
That is expertise also. The present plaintiff was not present then.
Defendants have to be intimated in compliance of order 39.
They were intimated subsequently, and on 1st of December he appeared.
In March.
Where do you get that from this?
From this, I don't. So I stand correct. I'm sorry. Now, my lord, in this second last paragraph of this page, 8 lines from the bottom. Hence it is. Hence it is, lordship.
Hence it is.
Hence it is the submission of the plaintiff that the said purported deed of partition and declaration dated so and so executed by defendants are fraudulent documents and cannot be acted upon. So this is what he is seeking. It has been stated by the plaintiff that the title suit number 4 and last paragraph, my lord, of that page.
Yes.
Title suit number 423, though an order of injunction has been passed on 12th of April 2023 in respect of Mumbai property, but he is there also, my lord, it is Mumbai property which has been injuncted in that title suit also. He is in dark about other joint properties and he reasonably is apprehending. My lord, this is not the prayer. He is in dark. He is reasonably apprehending that the steps will be taken in terms of purported deed of partition to defeat his right in the said property, causing irreparable loss and injury to him. Hence, he wants the court to pass an order of injunction restraining defendants to act upon the said deed till the suit is decreed. The defendant number 2. Now, my lord, these are my lord, defense, which I take, my lord, by filing written objection. My lord, I take the ground of section 80 of CPC, my lord. I say, my lord, that subpara 2, my lord, I say, my lord, this order, what he is taking is in teeth of order passed by this honorable court in writ petition 12828, my lord. My lord, paragraph 3, if lordship sees, 6 lines from the bottom. In fact, the plaintiff, lordship sees. In fact, the plaintiff, by way of purported letter, my lord, this is the letter which, my lord, I referred
ADSR.
Issued to the, has clearly admitted that he was a party to the aforesaid settlement and partition, but alleged that the deed has been manipulated and or interpolated for the alleged reasons requested. Defendant number 25 not to complete the registration of the deed and sought cancellation of the same. My lord will kindly mark this. Which fact has been fraudulently suppressed by the plaintiff in the present suit? Would my lords want me to, my lord, continue, my lord?
Let us come back tomorrow.
My lord, may I just try to, my lord, annex those pages in your lordship's brief, my lord, lordship's permit, those 3 missing pages.
You can fund supply copies of those. You can supply copies independently.
Lordship may retain it now for the moment, my lord. I will.
No, it will create confusion. You just supply pages 10 to
510 to 513.
13. Yes. Heard in part at the stage of hearing under Order 41 Rule 11 of the Code of Civil Procedure, full stop, for further hearing tomorrow. Come back tomorrow.
Sorry, my lord, lordship, I am troubling your lordships a lot more.
Day after?
Yes, why not? I mean,
That event can it be day after?
day after tomorrow, you have any
No, I don't have difficulty, my lord.
uh,
Only, my lord, if it retains its position.
Yes, yes, definitely.
পাঠার matter now. ওটাতে ডেটটা রিটার্ন ডেট টুমরো না করে ফর ফার্দার হিয়ারিং অন February 13, 2025.
Grateful.
Thank you.